Monday.
one ನಿಮಿಷ. First GMCPC ಕೊಟ್ಬಿಡಿ.
GMCPC.
ಎಲ್ಲ ಕೊಟ್ಟು.
To Monday.
Give all GMCPC matters. Mention it. Otherwise, I'll wait. I'll note. Yes. GMCPC alla tane. Wait. 1 minute. Pudi. Give it, sir. Correct agide. Tondre illa. Barli bidi. Yes. It will come Monday or Wednesday. It will come. Yes. GMCPC ella kodi. 1 minute. Just 1 moment. ಈಗ ನಾವು CRP ಯಾವ್ದಾರು ಇದ್ರೆ ಕೊಡಿ.
CRP is
CR vacating. Wait. Today first I have posted 24 vacating interim cases. At the top. Wait. Monday. All on Monday. Emergency ಇದ್ರೆ wait. Yes. ಆಯ್ತಾ ಎಲ್ಲೇ ಬಿಡಿ ಯಾವುದೇ ಕೊಡಿ ಅಲ್ಲ. ಎನಿ ಕೈಂಡ್ ಆಫ್ ಜನರಲ್ ಅವಾರ್ಡ್ ಯಾವ್ದಾರು ಸರಿ ಕೊಡಿ. ಅಯ್ಯೋ ನೀವು ಕತೆ ಹೇಳ್ಬೇಡಿ, ಏನ್ ಫ್ರೆಶ್ ಅಪ್ ಪೆಂಡಿಂಗ್ ಹೇಳಿ. ವೆಕೇಟಿಂಗ್ ಕೊಡಿ. all on Wednesday, sir. See, another 5 days left. I don't know whether I'll continue or not, so we'll see. Wait, sir. Yes. ಅಲ್ಲಿಗೆ ಹೋಗಿದ್ಯಾ? ಓ ಆಯ್ತು, ಸರಿ ತಗೊಳ್ಳಿ. ಮಂಡೇ vacating, give it. Whatever kind of vacating, give it. Yes. Monday. ಏನ್ ಫ್ರೆಶ್ ಅಪ್ ಪೆಂಡಿಂಗ್? ವೈ ಸೊ ಆಯ್ತು 2:30. No, 1 minute. Interim order is rejected by the trial court. 39 1 and 2 is rejected. File an appeal. Ex parte injunction is rejected. Fine. Yes.
Your Lordship.
1 minute. Ellaru helbedi. Wait. Please wait. Yes. We'll see. Monday kodi. LABD or GPC? GM res ಇಲ್ಲಿ ಯಾಕೆ ಬರುತ್ತೆ? GM ನನ್ನ ಹತ್ರ ಇಲ್ಲ ಮೇಡಮ್. GMCPC ಮಾತ್ರ. Yes. Go to court all 8 fast. 8 ಅಲ್ಲ. No. Wait. ಎಲ್ಲಿ ಒಟ್ಟಿಗೆ ಯಾಕೆ? Yes madam. When is the auction? 18th Friday ಕೊಡಿ.
Challenging amendment of the first statement. Remand of the decree by the first appellate court in violation of the remand order. Lord, the matter is set today for argument.
2:30. Wait. Ella, you have missed the bus. Wait.
Trial court is posting the matter for judgment.
When?
19th.
Why is ek judgment ಗೆ? 18th ಕೊಡಿ.
Your Lordship.
Monday. Fresh matter GMCPC ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ, ಅದು ಕೊಡಿ. ಅಯ್ಯೋ ಕೊಡಿ ಸರ್, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಎಲ್ಲ ಕೊಡಿ ಸರ್, ಕೊಡಿ. ಟ್ರೈನ್ ಟ್ಯೂಸ್ಡೇ ಬರುತ್ತೆ, ಕೊಡಿ. ಮಂಡೇ ಬರುತ್ತೆ.
Your Lordship.
ಮಂಡೇ ಸರ್, ಮಂಡೇ.
Your Lordship.
Pending matter now. Give it anyway. No date.
Your Lordship.
2000. Why? ಇನ್ನೊಂದು 5 ದಿನ ಇದೆ. I don't know. I'll continue. If I continue, I'll take it. You move it after I continue. Yes. You move it after I continue. Fresh pending. Pending. ಕೊಡಿ.
Your Lordship. Your Lordship.
No date in pending matters, give it, yes.
GMCPC for vacating stay order. madam.
Vacating stay ಇದ್ರೆ ಕೊಡಿ, yes.
Your Lordship,
Wait.
It is on 19th.
ನಿಮ್ ಮುಂಚೆ ಇದಾರಲ್ಲ, wait.
It is on 19th. madam.
Vacating stay it will come, yes. Give fresh matters, ಕೊಟ್ಬಿಡಿ. No time advance, give it, yes. Sir, argue ಮಾಡಿ ಅಲ್ಲಿ, adjournment ತಗೊಳ್ಳಿ, yes.
My lord,
Monday, according to seniority it will come.
my lord,
Yes.
property was granted in 1972. Now they are
ಕತೆ
trying,
ಹೇಳ್ಬೇಡಿ, ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ
pending, my lord.
ಕೊಡಿ.
Tomorrow,
My lord, the CRP is pending, my lord, since 2021. Apparently, this petition will become infructuous if the trial proceeds, my lord. Therefore, there is urgency, my lord. It may be posted tomorrow, my lord.
No, Tuesday, yes.
Your Lordship, fresh matter, Your Lordship. The alleged GPA holder is not a party to either MOU or the JV, Your Lordship, but still the learned trial judge has allowed him to mark documents and conduct evidence.
What is the next date?
Ivatte, Lordship, further evidence
2:30.
ivatte.
My lord, my TV cases.
Monday. Monday, sir. What orders? Orders on what?
Orders on the miscellaneous for sale of the immovable property, my lord.
Leave is granted? Leave is granted?
No, my lord, in the miscellaneous.
ಕೊಡಿ. 2:30.
Tomorrow,
18th. 18th, yes. Suraj 18th. Service matter? Oh, ಅಲ್ಲಿ ಇಲ್ವಲ್ಲ, yes. Great urgency. ಏನ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮತ್ತೆ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನ್ ಅರ್ಜೆನ್ಸಿ ಸರ್? ಮೇಡಮ್ ನೆನ್ನೆ ಮೂವ್ ಮಾಡಿದ್ದೆಲ್ಲ ಬಂದಿದ್ಯಾ? ಆಲ್ ಮ್ಯಾಟ್ರಸ್ ಫ್ರೆಶ್ ಅಷ್ಟೇ, ಪೆಂಡಿಂಗ್ ಬೇಡ. ಎಸ್ ದೇ ಹ್ಯಾವ್ ಶಿಫ್ಟೆಡ್ ದ ಗೋಲ್ ಪೋಸ್ಟ್ ಆಫ್ಟರ್ ದ ಗೋಲ್. ಎಸ್, ಗಿವ್ ಇಟ್, ಎಸ್.
My lord, it's a service.
ಟುಮಾರೋ ಮೇಡಮ್, ನಾಳೆಗೆ ಹಾಕಿರೋದೆಲ್ಲ ಹಾಕಿ. ಎಸ್.
My lord, sir, a disciplinary inquiry, my lord, they rejected my application for further evidence and posted for the return submission for tomorrow, my lord.
ಯಾವ್ದ್ರ ಜೇಮ್ಸ್
Service, my lord.
ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ಇದು ಯಾವ್ದು ಹೊಸದು?
Fresh matter.
ನೋ ಇಂಟರಿಗ್ ನಮ್. ಎಸ್.
My lord, fresh
ಎನಿವೇ
matter.
ಗಿವ್ ಇಟ್, ವಿಲ್ ಸಿ. ಕೊಡಿ ಸರ್. ಇವತ್ತು ಡೇಟ್ ಇತ್ತ, ಮಂಡೇ ಬರುತ್ತೆ, ಕೊಡಿ.
Your Lordship.
ನೋ ನೋ, ಮಂಡೇ. ಹಾ, ಏನು ಕೊಡಿ.
Your Lordship,
Lordship, one matter, LAKIDB. What happened is.
ಕೊಡಿ ಟ್ಯೂಸ್ಡೇ.
No, what happened is, Lordship.
ಯಾಕೆ ಬೇಡವಾ ಮೆಮೋ?
ಅಲ್ಲ, ಏನಾಗಿದೆ ಅಂದ್ರೆ.
ಏನಾಗಿದೆ ಅಂತ ಬೇಡ ನಂಗೆ, ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್.
Fresh, Lordship.
ಹಾ, ಕೊಡಿ.
Your Lordship,
Is the notice
ವಾಟ್
has been
ಹ್ಯಾಪನ್?
served.
ಮಂಡೇ ವಿಲ್ ಕಮ್.
No, Lordship, what happened is.
ಈಗ ನೀವು
tomorrow
2:30
they will
ಬೇಕಾ?
touch and, they already touched my property and.
Pending matter?
dispossessing me. Notice service ಆಗಿದೆ.
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರ?
Please, Lordship.
ನೋ ಡೇಟ್.
ಅಲ್ಲ, 2025 matter.
ಪರವಾಗಿಲ್ಲ.
ಅಲ್ಲಲ್ಲ.
ಏನೇನು?
If, tomorrow is not.
No, sir.
They have demolished my house, Lordship.
ಡೆಮಾಲಿಷನ್ ವೈ?
Because there is a ತೋಟದ ಮನೆ ಇದೆ.
ಹ್ಮ್.
ಅದನ್ನ ಅವ್ರು ಡೆಮಾಲಿಷಿಂಗ್ ತೆಗೆದು ಅವ್ರು ಏನ್ ಮಾಡಿದಾರೆ, ಟಚ್ ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳಿದ್ರು.
ಯಾರು ಟಚ್ ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳಿದಾರೆ?
ನಾವು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದೀವಿ.
ಹಾ.
KDB ನ PTCL ಪೆಂಡಿಂಗ್ ಇದೆ
ಹಾ,
before this honorable court, but they have not entertained the petitioner and they have
ಆಯ್ತು,
started to
ಅದು
formation the
ನಾಳೆ
road and demolishing the
ನಾಡಿದ್ದಕ್ಕೆ
house.
ಹಾಕಿ, 18th ಹಾಕಿ.
Please, Lord.
Counseling is
Your
there
Lordship.
on Monday, my lord. I'll be displaced from
ಡಾಕ್ಟರಾ?
my lord.
ಡಾಕ್ಟರಾ, ಟೀಚರಾ?
Guest lecturers, my lords.
Your Lordship,
2:30.
Your Lordship,
Pending matter, GMCPC, pending matter.
ಯಾಕೆ ನಿಮ್ ಮುಂದೆ ಯಾರಿಲ್ವಾ? ಅಲ್ಲಿಂದ ಹೇಳಿ.
Service matter, my lords, one is suspension and one is transfer. Suspension, I had moved it yesterday, it's not listed today, so both the matters.
FR ನಂಬರ್ ಇದೆ ಬರಲ್ಲ. ಗೋ ಅಂಡ್ ಕಂಪ್ಲೈ ಫಸ್ಟ್.
Transfer
ಆಯ್ತು, 2:30 ತಗೊಳ್ಳಿ.
Your Lordship,
ಟ್ಯೂಸ್ಡೇ.
Your Lordship,
ಕೊಡಿ. ಗೆಸ್ಟ್ ಲೆಕ್ಚರರ್ ಏನ್ ರೈಟ್ ಇಲ್ಲ ನಿಮ್ಗೆ? ಹೂ ಇಸ್ ದಿ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ದೇರ್? 8th ಕೋರ್ಟ್ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಯಾರು?
My lords, in this, what has happened is previously also last year we have filed number of cases. my
ಎನಿವೇ
lords.
ವಿಲ್ ಸಿ.
Your
ಕೊಡಿ,
Lordship.
2:30 ಕೊಡಿ.
Your Lordship, is a 7A PC
Why,
Act
ಕೊಡಿ.
matter, Your Lordship, is a part.
ಮೇಡಮ್ ತಗೊಳ್ಳಿ, ಯಾಕೆ 2:30 ತಗೊಳ್ಳಿ.
Your Lordship, is a PC Act 7.
ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ, ಟೇಕ್ ಇಟ್. FR ಕಂಪ್ಲೈ ಆಗಿದೆ, ಕಂಪ್ಲೈ ಮಾಡಿ. ಎಸ್.
Your Lordship,
ಹಾ, ಎರಡು ಸೇಮಾ?
ಇಲ್ಲ, one suspension, one transfer.
ಕೊಡಿ, ಅದು ಟ್ಯೂಸ್ಡೇಗೆ ಹಾಕಿ.
Your Lordship, is a 7A PC Act matter, Your Your Lordship, it's covered by multiple judgments of Your Lordship. It's the part heard.
There's an interim order operating.
Your Lordship, the interim order that is granted is only for the local
Don't
authority
worry.
to not
Yes,
file
it will come.
any
All
charge.
7A matters will post on a particular day. Yes.
Much obliged.
Fresh GMCPC, not yesterday I had moved,
Ah,
not listed.
urgency ಏನು?
There is a threat of dispossession. Commissioner's report is accepted.
ನಾಳೆ ಬೇಡ 2:30 ತಗೊಳ್ಳಿ. ನಾಳೆ ಪೆಂಡಿಂಗ್ ಕೊಡ್ಬೇಡಿ. ನೋ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಆಫ್ 8th court. ಎಸ್ ಗಿವ್ ಇಟ್. ಯಾವ್ದಾರು ಆಗ್ಲಿ ನೋ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಆಫ್ 8th court. ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿದ್ರೆ ಎಂಟೇನೆ ಮಾಡಲ್ಲ. ಎಸ್ ಅದು ತಗೊಳ್ಳಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮಾತ್ರ ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಗಿವ್ ಇಟ್ ಸರ್. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಡೇಟ್ ಇಲ್ಲ ಕೊಡಿ. ಹೇಳ್ತಾ ಇದ್ದಾನೆ. ಹಾ. No, give it, sir, give it. No, if I take one pending matter, then gone, unless your house is demolished or you are being dispossessed, authorized matra.
For partition.
Oh, adralli ಏನು urgency ಇಲ್ಲ.
My application for.
ಏನ್ ಪರವಾಗಿಲ್ಲ, ಏನ್ ಪರವಾಗಿಲ್ಲ.
ಈಗ defendant's evidence.
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ ಸರ್.
Next week any.
Nothing is going to happen, give it. Pending matter ಕೊಡಂಗಿದ್ರೆ ಮೆಮೊ ಕೊಡಿ, no date. ಒಂದು ಕೊಟ್ರಲ್ಲ ಶಾಸ್ತ್ರಿ. ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್ ಆ ಕೋರ್ಟ್ದು ಆ ಕೋರ್ಟ್ಲೆ 8th court ತಾನೆ. FR ನಂಬರ್ ಇದ್ರೆ ಕಂಪ್ಲೈ ಮಾಡಿ, ಇದಾರೆ ಬರಲ್ಲ. ಅದು ಟ್ಯೂಸ್ಡೇ ತಗೊಳ್ಳಿ ಅವ್ರದ್ದು ಕವರ್ಡ್ ಮ್ಯಾಟರ್. ಟ್ಯೂಸ್ಡೇ ಪೆಂಡಿಂಗ್ ಅದು ಕವರ್ಡ್.
ಎರಡಿದೆ ಮೇಡಮ್.
ಫ್ರೆಶ್ ಗಿವ್ ಇಟ್. ಎಸ್ ವಿಲ್ ಸಿ.
GMCPC pending matter but
ಪೆಂಡಿಂಗ್ ಕೊಡ್ಬೇಡಿ. ಮೆಮೊ ಕೊಡಂಗಿದ್ರೆ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಗಿವ್ ಇಟ್. ಎಸ್
My lord, my DV case is stalled, my lord. There is a stay.
DV ಕೇಸ್.
Yes, my lord. Truth or dare case, my lord. Cat case.
ಓ ಆ ಒಂದು ಆಯ್ತಲ್ಲ.
Yes, my lord. But DV case
ಇನ್ನೊಂದೇನು?
DV case is also stayed because
DV
of
case-
the 498, my lord.
ಅಲ್ಲ.
It is before your lordship only, my lord.
498 have already disposed.
Yes, my lord. DV is also before your lordship, my lord.
ಇದ್ರೆ ತಗೊಳ್ಳಿ, ಫ್ರೈಡೆಗೆ ಹಾಕಿ ಮಾಡಿ.
Thank you. Yes.
Your
Obliged.
Lordship, GMCPC fresh matter, Your Lordship,
You have
96.
given 2 memos already.
First, second memo, Your
What
Lordship.
is it?
96 suit, Your Lordship, 2007 ಅಲ್ಲಿ execution ಹಾಕೊಂಡಿದ್ದಾರೆ. But ಅದ್ರಲ್ಲೇ IA ಒಂದಿದೆ Lordship for conditional attachment. IA ನ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ Lordship ಇನ್ನು, ಅದಕ್ಕೆ we filed it
Mandamus,
also.
to consider that
IA speedy disposal.
Friday.
Thank you.
Yes, call the cases. Service matter. Drama.
Open to
Pass over.
hearing on IA fill number 2.
For stay, 2017 stay.
ಸ್ಟೇ ಇಲ್ಲ, ಹಿಯರಿಂಗ್ ಮಾಡಬೇಕಷ್ಟೇ. ಇದರಲ್ಲಿ ದೇ ಹ್ಯಾಡ್ ಅಗ್ರಿ ಟು ಗಿವ್ ಅಸ್ ಮಲಾಟ್ ಅಟ್ ಎ ಪರ್ಟಿಕ್ಯುಲರ್ ರೇಟ್, ಮಾರ್ಜಿನಲ್ ಲ್ಯಾಂಡ್. ದೇರ್ ಆಫ್ಟರ್ ಮಲಾಟ್ ದೇ ವೆಂಟ್ ಬ್ಯಾಕ್ ಆನ್ ಇಟ್. ಇನ್ನೊಬ್ಬರಿಗೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಮಲಾಟ್ ಇನ್ 2024 ಮಲಾಟ್ ದೇ ಹ್ಯಾವ್ ಗಿವನ್ ಇಟ್ ಅಟ್ ದ ಸೇಮ್ ರೇಟ್. Therefore ಮಲಾಟ್ ಆರ್ಟಿಕಲ್ 14.
Lord, your lordship may fix a date for final hearing. Senior is held up in court hall 2.
Heard the learned senior counsel Shri Uday Holla appearing for the petitioner. The learned senior counsel would submit that the issue revolves around grant of a marginal land. The marginal land sought by the petitioners is rejected, and in the same breath, identically placed persons are granted such marginal land.
Can I put it in this manner? They have fixed a price malaat at a very
Price,
high,
marginal land, quay the price. The learned senior counsel therefore submit that there is arbitrary action on the part of the respondent. The learned counsel for the respondent seeks a day's time. We'll fix it on Tuesday.
As you
List the matter on Tuesday at the request of Baby Patil. It's made clear no further adjournment would be granted in the matter as it is 8-year-old. Yes.
23rd about that Tuesday, I'm not in town.
23rd, no problem. 23rd ತುಂಬಾ ಇದೆ ಸರ್. 23rd GMCPC ಡೇ ತುಂಬಾ ಇದೆ. 24th ತಗೊಂತ. ಎಸ್, ಅದು ಕೊಟ್ಬಿಡಿ ಸರ್.
Please oblige.
ಎಸ್, 24th ಜವೈ.
Still number 3.
Including application dismissed, my lord, against that order I filed.
ಅರ್ಲಿ ಹಿಯರಿಂಗ್
Earlier it was been filed by me by the first
ನೀವಾ
respondent.
ಸ್ಟೇ ಇದೆಯಾ?
Stay.
Stay is there, my lord, and the
ಎಸ್ ಸರ್ ಹೇಳಿ.
My impeding application is dismissed, my lord, against that order I filed this petition.
ಏನ್ ಹೂ ಆರ್ ಯು ಸರ್?
I am one of the family member. And
Partition suit?
Yes, my lord.
Why is it dismissed?
reason, my lord, I have not stated detail. My brother application, my lord,
ಏನಿದು 5 years ಇಂದ ಸ್ಟೇ ಇದೆಯಾ? ನೀವ್ ಯಾರು ಸರ್?
I am one of the brother.
My lordship,
It's
they are
a-
contending that they.
ಇದು ಬ್ರದರ್ಸಾ ಅದರ್ಸಾ?
Others, my lord,
Others,
because they are
sir.
telling that their contention is that they are the wife, children of the second wife of Karibasappa, who is the propositors, my lord.
One moment, kindly see, my lord. Earlier suit
Their
filed
properties
by
are not
the
at
very
all
same
included.
ಒಂದ್
person.
ನಿಮಿಷ.
Earlier suit filed by the very same person withdrawn. I am one of the party in that
Which,
partition.
where is that suit?
That suit, my lord, they withdrawn.
ಬೈ ಮಿಸ್ಟೇಕ್ ನಿಮ್ಮನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ಬಿಟ್ಟಿದ್ದು ಅಂತ ವಿಡ್ರಾ ಮಾಡಿ.
ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ. ನನ್ನ ಬ್ರದರ್ನ ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ. ಈ ಸೂಟ್ ಅಲ್ಲಿ ನನ್ನ ಬ್ರದರ್ನ ಪಾರ್ಟಿ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಆಗಿದೆ. My brother ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ is allowed.
You don't like him?
No, my lordship.
It's a
I
collusive
did
suit
not-
for-
One person.
No problem. We'll make you like him. We'll allow the petition. Yes. ಅಷ್ಟೇ. 4 ವರ್ಷದಿಂದ 5 ವರ್ಷದಿಂದ ಇದಕ್ಕೆ ಪೆಂಡಿಂಗ್ ಇರ್ಬೇಕಾ ಮೇಡಮ್? ಬಂದು ಹೇಳಿದ್ರೆ ಯಾವಾಗ್ಲೂ ಆಗ್ತಾ ಇತ್ತು. Suit is of 18, still pending, stayed here. ಅದಕ್ಕೆ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಇವತ್ತು 24 ಹಾಕಿರೋದು ಅದಕ್ಕೇನೆ ಎಲ್ಲ ಖಾಲಿ ಮಾಡ್ತೀವಿ. Yes. The petitioner is before this court calling in question an order dated 14/12/2020 passed in OS 93 of 2018 rejecting an application filed by the petitioner under Order 1 Rule 10 seeking to implead himself as a defendant in a suit for partition. The learned suit for partition heard sounds. The learned counsel, the first respondent is the plaintiff institutes a suit in OS 93 of 2018 seeking a decree of partition and separate possession. And arraigning several defendants. The petitioner is said to be one of the brother of the family member who is not impleaded into these proceedings. Therefore, he comes up with an application under Order 1 Rule 10 seeking his impleadment. The said impleading application is rejected on the objection filed by the plaintiff on the score that he has not produced any document to demonstrate that he is the member of the family, and therefore the petitioner is before the court. Learned counsel B.S. Prasad would submit that the petitioner is a family member. His brother is made a party to the proceedings, but he is not, and also would take this court through an earlier suit filed by the very plaintiff in which the petitioner was a defendant, and the suit comes to be withdrawn. Therefore, would submit that the petitioner is a proper and necessary party to the proceedings which seek partition and separate possession of the suit scheduled properties. The learned counsel for the respondent would put up vehement opposition, but would not dispute the position that the earlier suit did contain the present defendant Ubrana, present defendant as a party defendant in the present petitioner as a party defendant in the aforesaid suit, and would further admit that the brother of the petitioner is already a defendant in the subject suit. In that light, the suit, I have given my source. The afore narrated facts are not in dispute. The suit initially filed in OS
18 of May.
2007, my lord, one submission, my lordship, that suit was not filed by this plaintiff. It was filed by the first defendant in the suit.
No, partition ಎಲ್ಲ ಒಂದೇ madam.
2017.
I was not a party to that suit. my
The
lordship.
partition role reversal can always happen. Yes.
I was not a
Elru,
party to that
everybody gets a share there. ನಿಮ್ಗೊಬ್ಬರಿಗೆ ಅಲ್ವಲ್ಲ? Yes.
18 of 2017.
The first defendant had instituted a suit in OS 18 of 2017 in which the present petitioner was arraigned as a defendant. This is a matter of record. The said suit comes to be withdrawn by the first defendant and comes the subject suit by the plaintiff. The plaintiff arraigns the brother of the petitioner as a defendant but not the petitioner. Therefore, the petitioner had preferred an application under Order 1 Rule 10. The said application on the aforesaid facts on the face of it ought to have been allowed by the concerned court. The concerned court has erroneously rejected the application filed by the petitioner, which has led the petitioner to this court and the petition languishing for last 5 years before this court. Therefore, the petition deserves to succeed and the application filed by the petitioner deserves to be allowed. For the aforesaid reasons, the following order. Allowed, first allowed, quashed. The application filed by the petitioner and Order 1 Rule 10 stands allowed. the petitioner plaintiff, the respondent plaintiff is directed to amend the cause title before the concerned court. The concerned court is directed to regulate its procedure and expeditiously conclude the suit as it is of the year 2018. Yes, ordered according. Next.
Hope.
I appear for petitioner in this matter, my lords.
ನೀವು ಯಾರಿಗೆ? You are assisting him?
Serial number 4.
4.
Some confusion.
Bimbadar.
Please,
This matter was heard for some time.
I know, sir.
Please, ma'am.
ಇದರಲ್ಲಿ ಫೈನಲ್ ಡಿಕ್ರಿ ಆಗಿಲ್ಲಲ್ಲ?
ಇಲ್ಲ,
ಪ್ರಿಲಿಮಿನರಿ ಡಿಕ್ರಿ.
ಹೌದು.
ಎಕ್ಸಿಕ್ಯೂಟಬಲ್.
My lord, true, my lords. The petitioner, my lords, may ask this honorable court, my lords, permission to refer this matter for a mediation, my lords. Illi,
ಹೌದಾ?
only two things, my lords. There are two properties. One is a 2-bedroom apartment, or another one is a 3-bedroom apartment.
Apartment ಏನು ಅಂತ that does not decide the issue in
Please,
law, sir.
please, my lords. So the entire issue revolves around the rights with regard to the 3-bedroom flat. So, my lords, the petitioner has decided, my lords,
If
once.
you want to settle, no problem, I will refer it to mediation.
Please.
But in law, the interim injunction or interim order granted during preliminary decree is executable till the final decree is passed.
Please.
Anything else?
No.
ಮತ್ತೆ?
My lords, this matter may be referred to mediation, my lords.
Yes,
Let us,
Naresh.
Third time mediation is failed, my lords. Thrice it is failed.
ಏನ್ ಮರಳಿ ಯತ್ನ ಮಾಡಿ ಏನು?
once, my lords, let us
Mediation
put a full stop for all the matters, my lords.
Full stop
Please, my lord. All
full
the
stop.
matters.
Yes,
No, my party has no faith on them, my lords.
on them.
No, my lords.
No, sir, you should have faith.
No,
in
my
the
lords.
system.
They
Yes.
have lost faith, my lords. They're brothers, similar siblings, my lords.
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು
spite of
you should-
which, my lords,
you should never
My
lose
lords, let
two.
them deposit, my lords,
one
let them
ನಿಮಿಷ.
at least deposit 50% of the
You
amount.
should never lose two things, faith and hope.
My lords. Let them
That,
deposit
that keeps
50%.
you going.
Lords. My lords, it is pending since.
Have faith in yourself, have hope in others.
Lords, I agree, my lords. Let them deposit 50% of the amount, will go for the mediation, my lords.
ಅದೇ ಕಂಡೀಷನ್.
Lords,
ಎಷ್ಟಿದೆ?
this 19 lakhs is pending, my lords, since,
Lords,
lords.
absolutely wrong, my lords. Earlier, on the earlier occasion, my lords, it was the.
I will
specific
permit
state-
execution now.
My lords, it was a specific statement, my lord, that the respondent has made, that the 6 lakhs is, my lord, the pending amount. My lords, in this writ petition, I have deposited 1,15,000, 1,30,000, and in the RFA, my lords, I have deposited 2 lakhs.
3,30,000.
3,30,000 is already deposited, my
total?
lords. 6 lakhs
19
on the last
lakhs is
time
the
only
total.
submission.
ಎಷ್ಟು?
my lord.
19 lakhs, my lords.
19 ಯಾವಾಗ
Lords,
ಆಯ್ತು?
since
When
2007.
did it become 19?
Lords, since, lords, 2000.
ನೀವೇನ್ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಇಂಟ್ರೆಸ್ಟ್ ಹಾಕ್ದಂಗ್ ಆಗ್ತಾ ಇದ್ದೀರಾ?
No, my lords. Lords, it is every month rent, my lord, they are supposed to, my lords, pay.
ರೆಂಟ್.
Yes, my lords.
6 lakhs pending ಇದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. 3,30,000 is already deposited before this honorable court.
ಆಯ್ತು, if it is that sit across, you're all siblings ಅಲ್ಲ?
Yes, my lords.
Sibling rivalry.
Lords, 3 times, my lords, it is failed, my lords.
ಏನ್ 4th time ಮಾಡಿ siblings ತಾನೆ?
Lords, let them deposit, my lords, at least, my lords, the admitted amount, my lords, they will. my lords,
Admitted amount ಎಷ್ಟು?
6 lakhs, according to them, it is 6
ಅದ್
lakhs.
ಮಾಡಿ.
My lords, 330 already ಮಾಡಿದ್ದೇನೆ. ಇಲ್ಲಿ 130 ಇದೆ, 2 lakhs RFA ನಲ್ಲಿ.
ಅದೇ 330 ಆಯ್ತು, ಮತ್ತೆ ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದೀರಲ್ಲ, ಇನ್ ಟೋಟಲ್ ಜಾಸ್ತಿ ಆಗಲ್ಲ.
My lords, ಒಂದ್ಸರಿ mediation ಗೆ ಹೋಗಿ ಬರ್ಲಿ ಸ್ವಾಮಿ, ಆ ನಂತರ.
ಬೇಡ, ನೀವು ಒಂದು 6 ಲಕ್ಷ ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬಿಡಿ, ಮೀಡಿಯೇಷನ್ ಕಳಿಸ್ತೀನಿ. ಇಲ್ಲಾಂದ್ರೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪರ್ಮಿಟ್ ಮಾಡ್ತೀನಿ. Because law it is permissible. What you are projecting is not the law. Final decree ಆಗಿದ್ದಿದ್ರೆ definitely.
6 lakhs would not be.
Deposit, I will fix a date for mediation 50. Madam ಇದೇನು? Holidays ನೋಡಕ. ಪರವಾಗಿಲ್ಲ, ತೊಂದ್ರೆ ಇಲ್ಲ, ಸುಮ್ಮನೆ ಹೇಳ್ತೀನಿ.
My lord, the remaining amount ಗೆ ಡೆಪಾಸಿಟ್ ಗಾದ್ರೂ ಆರ್ಡರ್ ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ. ಉಳಿದಿರೋ ಅಮೌಂಟ್ ಗೆ. Not the entire 6 lakhs, my lord. ಉಳಿದಿರೋ
330 ಆಗಿದೆ.
Please, my lord.
ಇನ್ನ 370 ಮಾಡಿ.
ಇನ್ನು 270.
2 sorry. Yes. 270.
Yes, my lords.
The learned counsel for the petitioner submits that if one opportunity is granted, comma, yet again, the 4th in line, the 3rd or 4th?
4th time this now.
4th in line, the parties could settle the dispute amongst themselves, which will conclude all the proceedings pending between the parties, as the issue is with regard to sibling rivalry. The learned counsel for the respondent submits that the petitioner has to pay rent of the property that he is in possession of, which is now to the tune of 19 lakhs. The counsel for the petitioner submits that the admitted amount is 6 lakhs. Therefore, the admitted amount be deposited before which court? ಅಲ್ಲೇ ಎಲ್ಲಿ ಮಾಡಿದೀರಾ ಮುಂಚೆ?
Before this court, 1 lakh 30.
Deposited before this court. the 6 lakhs would work out in this way. 3,30,000 is already deposited. Therefore, the remainder 2,70,000 be deposited by within 2 weeks.
Please.
Within 2 weeks from today. List the matter on 30th. Sorry, within 2 weeks from today, the parties are directed to appear before the Bangalore Karnataka Mediation Center on 28th at 3 p.m. List the matter on 30th. The deposit be made by the 28th of July.
If such deposit, it may not permit me to withdraw, my lord.
One by one, Kelly. Yes.
Lords, the earlier amount also I had not withdrawn, my lord.
One by one. Step by step.
All right.
Mediation ಆದರೆ ಎಲ್ಲ ಸಿಗುತ್ತೆ. Impleading applicant. Who is impleading?
If I may say so with great respect.
ಯಾಕೆ sir?
Maybe I may have to be allowed without much ado. This is for this reason. That first respondent is the plaintiff. All other respondents are the defendants.
Partition.
Partition. They file a compromise petition. The petitioners are also members of that family. They are not impleaded. Therefore, petitioners filed an application for impleading.
That is rejected.
ಇಲ್ಲ ಅದು ಪೆಂಡಿಂಗ್ ಇದೆ.
Pending.
I filed an application for impleading for this reason. That's I am concerned only with item number 24.
ಅಲ್ಲ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ ಇಲ್ಲಿಗ?
ಅಲ್ಲಿ ಡ್ರಾಫ್ಟ್ ಫೈನಲ್ ಡಿಗ್ರಿ ಅಂತ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
Recalling of compromise has been kept in abeyance. That order has
Let them implead.
Yes.
Pending application is. As far as I am concerned, I am interested in item number 24. I am not a member of the family. It is my absolute property. ನನ್ನ ಮೇಲೆ ಫಾರ್ಮ್ ನಂಬರ್ 7 ಹಾಕಿ ಪ್ಲೇಂಟಿಫ್ ಅವರ ತಂದೆ.
ಆಯ್ತು ಅದೆಲ್ಲ ಅಲ್ಲಿ ಮಾಡ್ಲಿ.
Therefore, let's ಡ್ರಾಫ್ಟ್ ಫೈನಲ್ ಡಿಗ್ರಿ ಅಂತ annexure ಹೆಚ್ಚಿದೆಯಲ್ಲ ಅದನ್ನ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿ
we will send it
decide
back.
all the impleading applications.
Correct. Yes. The petitioner. You are the plaintiff, huh?
Yes, ma'am. No, plaintiff is
Or the petitioners, the defendants, 7, 8 and 9 are at the doors of this court calling in question an order dated 26/11/2021 passed in OS 590 of 2006, whereby the concerned court directed drawing up of a final decree pursuant to a compromise that had entered into under Order 23 Rule 3 of the CPC. They heard so and so. The suit instituted in OS 590 of 2006 was for partition and separate possession. The suit, during the pendency of the suit, it transpires that few of the plaintiffs and the defendants enter into a compromise without drawing all the persons of the family as parties to the said suit or the compromise. Therefore, the learned counsel for the respondent, Varadarajan, would submit that their impleading applications in the suit is pending adjudication. He would further submit that the order that directed the drawing up of final decree be set aside and the concerned court be directed to answer the impleading applications in accordance with law and then proceed to pass necessary orders thereon, as the rights of every party has to be assessed by the concerned court in a suit for partition. The learned counsel for the petitioner defendant 7, 8, 9 would not dispute the position that the impleading applicants who have filed impleading application before the concerned court and before this court are the members of the family who are not parties to the compromise so entered into between few of the plaintiffs and few of the defendants, and therefore have filed a subject petition. Therefore, have filed a subject petition where the concerned court has directed drawing up of a final decree. In the light of the aforesaid facts and the submissions made at the bar, I deem it appropriate to pass the following order. The order dated so and so stands quashed. The matter is remitted back to the hands of the concerned court to consider the impleading application so pending before it. Here the parties regulate its procedure and pass necessary orders thereon. Mr. Sakala?
I I am a stranger to the family. ಆ 24ನೇ ಐಟಮ್ ನಂದು ಅಂತ ಹಾಕಿದೀನಿ.
ಅಲ್ಲ
By
ಏನ್
implementing
ತೊಂದ್ರೆ ಇಲ್ಲ,
application-
ಅಲ್ಲೇ ಎಲ್ಲ ಮಾಡ್ಲಿ.
They also filed application, impeding application.
ಎಲ್ಲ ಏನೇನ್ ಅಪ್ಲಿಕೇಶನ್,
Implementing application
ಆಲ್
shall
ದಿ
be
ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್, ಎಸ್ ಎಲ್ಲ ಅಲ್ಲೇ ಮಾಡು, ಎಸ್ ಆರ್ಡರ್ಡ್ ಅಕಾರ್ಡಿಂಗ್. ಹಳೇದ್ ಮುಗಿತಾ ಇದ್ರೆ ಒಳ್ಳೇದು. ಎಸ್
Lord, appear for the petition, Lord, I have,
ರೀಕಾಲಿಂಗ್ ದಿ ಆರ್ಡರ್.
please, my Lord.
ಯಾರ್ದು order?
Dismissed for default for non-compliance
My
of two
order.
objections, along with an application for condoning delay, my Lord.
ಎಷ್ಟು ವರ್ಷ ಡಿಲೇ?
No, there's delay of 103 days.
103 days.
That's
Condoned. The petition, the coordinate bench of this court by an order dated 7/3/2023 dismissed the petition for its non-prosecution. The petitioner has preferred an application in IA, applications in IA 1 of 2023 for condoning the delay and IA 2 of 2023 to recall the order. The delay is 103 days. In the light of the reasons indicated in the affidavit accompanying the application and being satisfied with the same, the delay of so and so stands condoned. The application in IA 1 of 25 is allowed, and consequently IA 1 of 2024 stands allowed. The petition is restored to file. Interim itta?
No, Interim. I have to
Yes.
comply the objections.
Next. Amendment filed by petitioner.
The petitioner, my lord, I prayed for 2 days' time. I filed certain decisions of the earlier occasion between the same parties. Today it is filed, my lord. Kindly have it on Friday, my lord. Today it is filed in the counter. Certain decisions of the earlier decisions between the same parties. Kindly call it on Friday, my lord. Today it is filed in the.
List on Friday agala. List on 28th. Yes.
Alla Monday, my lord.
Needful to be done by then. Next.
Alla Monday, my lord. May I request, my lord?
Adu Monday, sir. Yes.
Next Monday, man. Next week, because of some urgency is there.
It is just next Monday. Yes.
Kindly pass over, my lord.
Pass over. Who is seeking pass over?
I have paid for respondent number.
ನೀವು ಯಾರಿಗೆ?
I am the petitioner.
From this side. What's the matter? ಏನಿದೆ?
My lord, suit is for permanent injunction. My lord, respondent is my own brother. I am the petitioner.
ಆಯ್ತು ಹೇಳಿ. You are the petitioner.
He's a party.
Yes, my lord. I am
Party in person.
Not in party in person. I have engaged.
You are
the
M.V.
service of
Rajanna.
DRS. Yes, my
Where is
lord.
your advocate?
He's coming.
My lord.
Kindly pass over, my lord.
May I make, kindly have it on day after tomorrow, my lord.
Saturday? Friday? ಯಾಕೆ?
2 days.
Why?
Need some time, my lord.
Stay ಇದೆಯಾ?
There is no stay, my lord. Concurrent finding.
Not to cut and
Both the-
remove.
ಏನ್ 39?
Please.
My lord.
Not to cut and
ನೀವು
remove.
ಯು ಆರ್ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್. ಇಲ್ಲ ಯು ಟು ಕಮ್ ಆಸ್ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್. ಅಡ್ವೊಕೇಟ್ ಆಗಿ ಎರಡೂ ಮಾಡಕ್ಕಾಗಲ್ಲ.
Please,
ಗೆಟ್ ದಿ ಅಡ್ವೊಕೇಟ್. ಎಸ್.
please.
ಫ್ರೈಡೆ.
Please.
9.
Matter where.
There's an interim order
innocuous
here.
Order.
There's an interim order here.
Yes, yes.
Will
Allah, interim order is.
both parties are directed not to alienate, encumber third party so and so.
The court
Yes.
wanted to dispose it off.
No,
At
we'll
that
send
stage,
it.
they said
We'll
mediation.
confirm this and send it.
Yes.
ಎರಡು ವರ್ಷದಿಂದ ಹಂಗೆ ಇದೆ.
My lord, if it can be had next week, my
No,
lord.
madam.
Senior is, held
Today
up in our-
specifically, I have listed all these old matters where vacating stays there. I am not going to pass it over nor adjourn it. This is the order. Whoever comes, this will be the order. I'll send it back. ಈಗ not to alienate on the 3 years in the idea.
1.5 year in the Desam. 2 years prior to that, they didn't have any interim order. Against two
23,
concurrent findings.
July?
23, 2
Now-
years
now-
ago.
July 25, 2 years ಆಯ್ತು.
My lord, now. the
Now don't
MA
argue the suit here.
No, I'll
We're
not
only on
argue the
39,
order.
1 and 2.
No, my lord. Your
Yes.
lordship may kindly see the MA order, my lord. It's on 16th of August 2022. Now the WP has been filed on 5th of July 23. After 1 year, they have filed the WP.
Then why is the interim
I
order
have
now?
moved, my lord. I have moved the matter. Now your lordship will also see, my lord, 2 concurrent courts have said that the injunction cannot be granted.
Where is it?
Your lordship may kindly take the trial court order 16th of August 2021.
Why are they here? Concurrent finding.
Concurrent finding of the 2 courts below that we cannot grant injunction.
The court says it is a matter of trial. We have spent over 2 crores. They wanted it, this honorable court said it will dispose of the petition with the direction that the stay would continue. They have
Who
sub-
said? I have
that-
not said.
No, ನೀವು last time ತಾವೇ ಆರ್ಡರ್ ಮಾಡ್ತಾ ಇದ್ರಿ
ಮಾಡ್ತಾ
ಅಷ್ಟೇ
ಇದ್ನಾ?
mediation. ಹೌದು.
ನನ್ ಮುಂದೆ ಬಂದಿದೆ.
Mediation, ಹೌದು ಬಂದಿತ್ತು last.
Allah, they have asked 10
They
crores in the
wanted it
mediation.
referred to mediation.
10 crores is the demand.
After
So,
9
what happened to
years.
mediation?
Failed, my lord. They demanded 10 crores. Their compensation is fixed under the joint development agreement.
What is the issue, sir?
Issue is, my lord, joint development agreement, we have terminated the joint development agreement. They have filed a suit simpliciter for injunction. What the trial court said is, you have to file for a larger relief under 41H, my lord. We have also raised a point that this is a pure commercial dispute. The court does not have jurisdiction.
Commercial court?
Not meant, commercial court alone has the jurisdiction because it's for the virtually the joint development agreement. They have not even sought for the enforcement. Now the two courts below have said, all this issue is matter of trial. We will not grant injunction, and that injunction has been dismissed by the trial court.
1 minute. What is the effect of this order? That is not to alienate all that.
We are agreeable.
Ex
to
parte
that.
order.
We are agreeable.
And you are agreeable. What is the effect of that?
Lock my
They are
property.
trying to sell the property.
Which
That is why.
joint development agreement?
ಹೌದು.
Our
They have
enforcement.
spent over 2 crores.
Our portion ಅವ್ರು ಮಾಡ್ಕೊಂತಾರೆ ಬಿಡಿ.
ಅಲ್ಲ, of
No, I'm the
portion
owner,
ಅಲ್ಲ.
my lord. I'm the
Owner
owner
of the
Property is
I'm
not
the owner.
developed still
He
because
has
they had
not
a
sought for
litigation
specific
pending which
performance.
they had suppressed. After that, they enter into another agreement. They don't register it. They say after the litigation is over, we'll register the agreement. They don't come forward to register. The documents are deposited with an advocate escrow. They take the documents on the pretext that it has to be produced in a suit. Then they don't give back the documents. A notice is issued.
1 minute. Have you raised the issue of maintainability
Yes,
before?
para 14 of my statement of objection, my lord.
It
I
is-
have
That
said-
application is pending?
They take up the contention before the trial court.
Now,
ಅಲ್ಲ,
1 minute, sir. 1
that
minute.
has been determined. ಅದಕ್ಕೆ ಹೇಳೋಣ.
Commercial OS ಬರಲ್ಲ ಅಂತ ಡಿಟರ್ಮಿನ್ ಮಾಡಿದ್ದಾರೆ.
ಮಾಡಿದ್ದಾರೆ.
now,
They have
no.
decided
What the trial court
I
says
am
is,
asking a simple question.
yes, my lord, what the
Did-
trial court says is a matter of trial, that's all. It's not a matter of trial.
I'll also join you in arguing the suit. Wait, sir.
Yes,
Now I'm asking,
yes,
did you file an application regarding maintainability?
yes.
Which application is that?
Now I have filed order 7 rule 10 my lord, for return of plaint.
Correct.
Now
Is that
pending.
answered?
No, that is pending, my lord.
Before which court?
Before the trial court.
39 1 and 2 court only.
Yes, same court I have
Right?
filed.
Now, this not to alienate, I will continue and I will direct the court to consider your application under 710. All right?
Kindly
Till that
see-
710 is considered, the order passed by the coordinate bench here will continue. I will fix 4 weeks' time to consider that application under order 7 rule 10.
And with regard to commercial.
Exactly,
dispute,
with regard to, because if it is not maintainable, any order would become without jurisdiction. So I will direct the court to consider order 7 rule 10, continue this interim order
Allah, may I submit
for
one
4
thing?
weeks.
My one
Unfortunately, the opposite side is not fair. Kindly see page 73. Page 73, paragraph 39 of the trial court order. May I read, please?
Is it answering the application?
Yes,
sir?
yes. it's-
Where is the answer to the application? Yeah, Ambala will
On the
consider.
application, they raised this thing, same contention is taken up before the trial court.
Where the issue frame ಮಾಡಿದ್ರ ಇದರಲ್ಲಿ?
Issue frame ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ, ಇನ್ನು ಆ ಸ್ಟೇಜ್ ಬಂದೇ ಇಲ್ಲ.
ಮತ್ತೆ injunction ಮಾತ್ರ ತಾನೇ.
ಹೌದು.
So therefore, my
In
lord,
that
the trial court
Same
says-
issue is raised in support
That
of
it's
his
a doubt.
contention, plaintiff relied decision of so and so. I've gone through the
No,
decision
now there is an application filed under order 7 rule 10.
last week,
That is pending.
last week.
Last year, ತೊಂದ್ರೆ ಇಲ್ಲ. Let that court consider. I will continue this order till that day. And if the order goes against them, the interim order will continue. Yes.
Lord, oblige.
Your
ಇಲ್ಲದ್ರೆ
lordship may
ಇಲ್ಲೇ suit
protect, no,
ಮುಗಿಸ್ಬಿಡ್ತೀರಾ
your
ನೀವು?
lordship may kindly protect me, my lord, to the, now I am the owner of the property. They have not even sought for enforcement of the specific performance. If the injunction will continue for next 10 years, my lord,
No, I'm not saying that.
then my
See,
lord,
710 ಆದ ತಕ್ಷಣ you have a remedy.
look,
it is rejected.
there are two, I'm telling you, the order 7 rule 11 is for return of plaint.
7 rule 10.
10 is for return of plaint.
11 rejection.
Now, my lord, now there are divergent findings of this honorable court itself, where one court has taken a view that order 7 rule 10 is maintainable, filed by a defendant, and the other is that it cannot be invoked by a defendant. Ultimately, my point is
Sir.
that
I have
How much-
distinguished that judgment and said who else can file order 7 rule 10.
Yes, your
That's
lordship's
confirmed by
judgment
Supreme
and
Court
just-
also. Yes.
Yes, then my application is pending. Your lordship may kindly direct the trial court. 2 weeks, my lord. 2 weeks is all it takes to decide
No
on
problem.
that. That's all, my lord.
Close. The petitioner.
Allah, may I submit one thing? He files an application for rejection of the plaint. And he also takes up the contention that it should go before the commercial court.
No,
That
710
is
adukene.
negated. Now he files
That's
this
not
application.
negated. That is not negated.
Blows hot and cold.
No, not at all. Sorry,
Allah, suit is
senior
not
counsel is
maintainable
now
at
not
that
being
end.
fair
One
to
kade.
the
No
court.
problem. Whether hange ide. Yes.
Suit is not maintainable at
No
that one
problem.
kade.
The petitioner is before this court calling in question calling in question concurrent findings of the trial court and that of the first appellate court, declining to grant injunction in favor of the petitioner under order 39 rule 1 and 2, and also the appeal filed under order 41. The heard so and so. The petitioner and the respondent are said to have entered into a joint development agreement. Certain dispute has arisen with regard to the joint development agreement, and the respondent landowner is said to have terminated the joint development agreement. The learned senior counsel Sampath Kumar, appearing for the petitioner, would submit that they have spent huge amounts over the landed property, and in the interregnum the joint development agreement is terminated, which is pending.
May I submit? Post the suit, it is terminated,
Sir,
not prior.
Before
It
receipt
would
of the
have a
summons, my
difference.
lord.
The learned senior counsel would further submit that post the institution of the suit, but before the receipt of summons, the joint development agreement comes to be terminated. Be those submissions as they are. This court has, by its order dated so 23 Allah.
July
by its-
23, July 23.
ಅದೊಂದು July 23. One ನಿಮಿಷ.
23rd, 26th of July
26/7/2023, a coordinate bench of this court, in terms of its order dated 26/7/2023, had passed the following order. The said order is in subsistence even today. The learned counsel for the respondent submits that he has also filed an application before the concerned court under Order 7 Rule 10 for return of the plaint to be presented before the commercial court. According to the learned counsel, the issue is purely a commercial transaction between the two, and the jurisdiction would lie only before the commercial court. The learned senior counsel would submit that while answering the application, the issue with regard to the jurisdiction is also decided by the concerned court. But however, the application is filed under Order 7 Rule 10 only a couple of days ago. Therefore, the said application is pending. In the light of the pendency of the application with regard to the jurisdiction of the concerned court as to whether it can continue the suit or the plaint will have to be returned to be presented before the commercial court, touches upon the issue of jurisdiction. Therefore, I deem it appropriate to direct the concerned court to dispose the application said to have been filed in IA, said to have been filed before the concerned court under Order 7 Rule 10 for return of the plaint within an outer limit of 3 weeks from today. In the light of the interim order as aforequoted subsisting in the case at hand, I deem it appropriate to.
Now objection no ಹಾಕ್ಬೇಕು.
Okay.
ಅಲ್ಲ 3 weeks.
ಅದೇ ಅಷ್ಟು ದೊಡ್ಡ
4 weeks ಮಾಡಿ.
ಬರೀ
4 weeks ಮಾಡಿ.
4 weeks from today. All right. The application till the consideration and disposal of the application as is directed, the interim order subsisting in the case at hand shall continue. The further orders in law would continue. Any further order would only depend upon the orders that would be passed by the court answering the application as is directed. All other contentions would remain open except the one that is answered in the case at hand.
One other submission. The trial court says in para 39 that unless conducting trial, it's very difficult.
Yes, so and so.
What the trial court in para 39 of its order.
Application
That should not come in the way ಅಂತ ಒಂದು clarify ಮಾಡಿ.
That cannot
One
be
minute. Any observation made by the concerned court in an order that is already passed rejecting the injunction will not come in the way or influence the order that is now to be passed on the application and order 7 rule 10 of the CPC.
Allah, they have not challenged the order.
That
They
will
have
not
not challenged
ಈಗ
this observation.
independent ಆಗಿ ಮಾಡ್ಲಿ.
Allah, they have not challenged this observation.
Now he will,
There is already an observation.
what will happen
There is
is,
already a
what
finding.
will happen is, he will copy it, paste it and
Allah, with
dismiss it.
due respect, it
No,
may
no, I
be
need not
incorrect.
challenge an
That is the
observation.
benefit
That's
I
the
will
law,
get.
my
That
lord.
is
I
the
can-
benefit I will get.
Sir, it is the question of jurisdiction.
Court, may I read this paragraph kindly?
It is a question of jurisdiction, sir.
Correct. The court follows the Supreme Court decision and says it's a matter of time.
Ambalal, what else
Ambalal,
it follows?
correct.
Yes.
There is a this thing because here, because of the litigation, they
I
have
have
suffered another order.
I have
They
myself,
suppress it.
I have myself distinguished it. Ambalal.
Rule 10.
3 years ಇಂದ ಒಂದು interim order ಇದೆ ತೋರಿಸ್ತೀನಿ ಅವ್ರಿಗೆ ಸೇಮ್ ಲ್ಯಾಂಡ್ there is an injunction operating.
ಅಲ್ಲಿ, yes.
Allah, in the event the application is dismissed, the order, this order should continue till
Other
the
subject to further orders. Court, the,
is specified.
the, after passing of the order as directed here and above, it is open to the concerned court to pass necessary orders on the submissions made by the counsel for the parties.
Yes.
ಈಗ 4 ವಾರ ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
Allah, with respect to injunction.
Sir, you have suffered concurrent orders and there is an order here.
Allah,
There is an order here granting not to alienate. ಅದನ್ನ
Allah,
continue
this
ಮಾಡಿ.
court in its wisdom said both parties shall maintain status.
Oh, no, there is no reason in that order. Yes.
Lord, I am appear for the respondent, my lord. Idrilli, I filed an application for vacating the interim order granted by this court, my lord. There is a concurrent findings, my lord.
39, 1 and 2. ಇಲ್ಲಿ ಏನು ಸ್ಟೇ ಇದೆಯಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
In respect of the position of.
Status quo ಏನಿದೆ?
Status quo ಇದೆ.
ಒಂದು ನಿಮಿಷ ಇದ್ರೆ.
Parties are directed to maintain status quo.
ಎಲ್ಲಿದೆ? Which date?
On 7/11/2023.
Yes, sir.
My lord, one submission. This is 4th round litigation. The earlier 3 suits has been dismissed for the same property, same cause of action.
Page.
That is only for the bare injunction, my lord.
ಇದು
This
ಬೇರೆ
suit may-
injunction,
No,
filed for
they are
declaration.
sought for a declaration.
No. This suit I have
Document, my lord,
sought for
document
declaration, my lord.
77 document ನ ಈಗ ಅವ್ರು ಡಿಕ್ಲರೇಷನ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. One submission.
Earlier round of
My lord,
litigation.
OS number 122/2013 dismissed. OS number 59/16 dismissed. OS number 47/19 dismissed. Now the present suit is pending. The
ಆ
first
ಮೂರು suit for what?
Injunction.
suit for injunction. But
is for
declaration
declaration.
ಕೇಳಿದಾರೆ ಮೇಲೆ ಡಿಕ್ಲರೇಷನ್ ಕೇಳಿದಾರೆ ಒಂದು
ಇಲ್ಲ,
ಸಬ್ಮಿಷನ್.
ಕೇಳಿಲ್ಲ.
ದಿ ಇಂಜಂಕ್ಷನ್
ಒಂದು ನಿಮಿಷ sir.
ಒಂದು ಸ್ವಲ್ಪ ದಿ ಇಂಜಂಕ್ಷನ್ ಸೂಟ್
ನಾನು ಅದನ್ನೇ ಹೇಳಿದ್ದು.
ಫಸ್ಟ್ ಸೂಟ್ RSA ವರೆಗೂ ಬಂದಾರ ಮೇಲೆ RSA is also dismissed.
Suit ಯಾವ first injunction?
ಫಸ್ಟ್ ಸೂಟ್ ಮಲ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ರೆ ನೀವು ಲಾಸ್ಟ್ ಪ್ಲೀಸ್ ಅಪ್ರಿಶಿಯೇಟ್ ದಿ ಮೈ ಡಾಕ್ಯುಮೆಂಟ್ ಮೈ ಅಪ್ಲಿಕೇಶನ್ ದಿ ಪ್ಯಾರಾ 54 ನಲ್ಲಿ ಇದೆ ಮಲ ವೆಕೆಟಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ನಲ್ಲಿ ಪ್ಯಾರಾ 54 ಸಾರಿ ಪೇಜ್ ನಂಬರ್ 54. The absolutely, my lord, my respectful submission, the petitioner has not come before this court with a clean hand. Because earlier for 3 suits.
Already I have mentioned that earlier suit, my lord, in my plaint, my lord. Kindly see the.
Clean hands.
Kindly finding of the trial court, my lord, in page number 40, my lord.
ಅಲ್ಲ my lord, one submission. 2 FIR ಆಗಿದಾವೆ because of this.
ಅದು ಹೇಳಿಲ್ವಾ?
ಇದರಿಂದನೇ ಸ್ಟೇಟಸ್ ಕೋ ಇಂದ.
ಸ್ಟೇಟಸ್ ಕೋ ಇಂದ FIR ಆಗಿದೆಯಾ?
ನಮ್ಮ ತೋಟಕ್ಕೆ ನುಗ್ಗಿ my lord ಸುಮಾರು 2,000 ತೆಂಗಿನಕಾಯಿ ಕಿತ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ಮೊನ್ನೆ.
2,000 ತೆಂಗಿನಕಾಯಿ.
2,000 ತೆಂಗಿನಕಾಯಿ.
ರಾತ್ರಿ
ಅಲ್ಲ ಓಪನ್ ಆಗಿ
2,000 ತೆಂಗಿನಕಾಯಿ ತಗೊಂಡು ಹೋಗ್ಬೋದಾ ಓವರ್ ನೈಟ್?
The respondent is a 80 years old woman.
2,000 coconuts taken away in the
because of we have got an interim order.
Because of interim order.
ಅವ್ರು ಹೇಳೋದು ಅಲ್ಲಿ ದೌರ್ಜನ್ಯ ಮಾಡೋದು ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ.
Yes, file ಮಾಡಿದ.
Therefore, my lord, RSA also dismissed on merits.
What did you do 2,000 coconuts?
False allegation, my lord.
What false allegation?
No, false. FIR ಇದೆ my lord. FIR 2 FIR ಇದೆ.
1000 ಒಂದೊಂದು FIR.
ನಾನು ಒಂದು ಹೊಡೆದಾಟ ಮಾಡಿರೋದು, ಒಂದು ಹೊಡೆದಿರೋದು, ಒಂದು ತೆಂಗಿನಕಾಯಿ ತಕೊಂಡು ಹೋಗಿರೋದು.
ಇದಕ್ಕಿಂತ ಮುಂಚೆನೂ ಸುಮಾರು FIR ಫೈಲ್ ಮಾಡಿದ್ರು.
ಸುಮಾರು ತೆಂಗಿನಕಾಯಿ ಹೋಗಿದ್ಯಾ?
Suit is pending. Let them continue, because interior matter in this is the nuisance arises.
SC also they have filed FIR.
This both courts concurrently find that reject the interim prayer. Both courts, trial court and also
both courts ಅಂದ್ರೆ ಅದೇನೆ ಇರಿದಲ್ಲ.
I request you last to kindly vacate this.
Status quo, my lord, until disposal of the suit.
What this?
In respect of the position of the
No,
scheduled
nothing
property.
doing. Yes.
I want to rely upon some other documents.
Rely. Come on.
I will produce.
No production. ಇದು ಪೋಸ್ಟ್ ಮಾಡಿರೋದೇ ಡಿಸ್ಪೋಸಲ್ಗೆ ಎಲ್ಲ 4 ವರ್ಷದಿಂದ ಪೆಂಡಿಂಗ್ ಇದೆ ಕೊಡಿ. Yes, come on ಮೆರಿಟ್ಸ್. ಇಲ್ದ ಇನ್ನೊಂದು 2000 ತೆಂಗಿನಕಾಯಿ ತಗೊಂಡ್ಬಿಡ್ತೀರಾ. ಫಾಸ್ಟ್.
But recently Supreme Court ಒಂದು
recently
recent judgment ಮರ
ಕೊಡಿ. You not got ತಂದಿಲ್ವಾ?
ಕೊಡ್ತೀನಿ.
If you not got the judgment of Supreme Court, take my judgment now. Yes.
Please.
We'll dismiss, we'll allow it.
You.
ಹೇಳಿ fast.
Kindly, I have filed application before revenue authorities, my lord. The mutation entries have changed in their name, but there are no records available in the there, my lord.
ಏನಾಗಿದೆ ಅದು?
Thereafter, I filed appeal before RTI, my lord.
ಏನಾಗಿದೆ? RTI
RTI ಹಾಕಿದ್ದೀನಿ, documents ಕೊಡಿ ಅಂತ.
Appeal before RTI?
ಅಲ್ಲ, ಆಮೇಲೆ
RTI appeal ಹಾಕಿದ್ದೀನಿ.
Available is documents are not available ಅಂತ ಅವ್ರು endorsement ಕೊಟ್ಟಿದ್ದಾರೆ.
ಆಮೇಲೆ
In what basis they have changed the mutation entries?
ಆಮೇಲೆ
Now appeal is pending before appellate authority, my lord.
Yes, anything else?
There is no records available with them.
Pending ಇದೆಯಲ್ಲ, ಏನು ತೊಂದರೆ ಇಲ್ಲ.
ಅಲ್ಲ.
This interim order cannot continue. It will be permitting, rewarding abuse. Anything else? The petition
may be maintained, my lord, until disposal of the
suit will be there until its disposal, not the interim order.
They will interfere with the position of the property of the
nothing doing. Yes.
petitioner, my lord.
The petitioner, the plaintiff, the petitioner plaintiffs institute OS OS 440 of 2022 seeking declaration and injunction against the defendants. The concerned court by a detailed order rejects the application under Order 39 Rule 1 and 2, thereby declining to grant temporary injunction. This is tossed by the plaintiffs before the First Appellate Court in MA 2 of 2023. The First Appellate Court also dismisses the application, dismisses the miscellaneous appeal by another detailed order going into the entire veracity of the claim of the petitioners. On these concurrent findings of both the courts under Order 39 Rule 1 and 2 and the order in the miscellaneous appeal, the petitioner plaintiffs are before this court. This court, in terms of its order dated so has directed parties to maintain status quo. The learned counsel for the petitioner submits that his case is dependent upon a particular revenue entry in which the mutation entry, which is of the subject land, which is mutated in favor of the defendants without there being any basis for such mutation. The learned counsel would further submit that he had applied under the Right to Information Act and no information about the basis on which the change of mutation entries happen is furnished to the petitioner. Thereby, the inference that he seeks to draw is that there is no basis for change of mutation entry. His entire suit is therefore based upon the said fact. The learned counsel for the said fact and submits that the interim order that was passed of directing parties to maintain status quo should be continued till the disposal of the suit. The learned counsel for the respondent would, however, refute the submissions in contending that the petitioner plaintiffs have filed not one but 3 suits. All the 3 suits, though were for injunction, have been dismissed, and those dismissals have become final. The subject suit is the 4th one, claiming declaration and injunction, a declaration as an extra relief. The learned counsel would further submit that the court's answering injunction have gone into great detail while rejecting the suits, and those rejections have become final. I have given us notes. The aforementioned facts are not in dispute. The petitioner has filed 3 suits is a matter of, plaintiffs have filed 3 suits is a matter of record. Though, albeit those suits being one of grant of injunction restraining the defendants from interfering with their possession. Those 3 suits have been dismissed. This is also a matter of record. Therefore, the relief of injunction that he sought throughout in those 3 suits have been turned down. After those suits being turned down, the petitioner now comes up with a declaratory relief seeking declaration and injunction. The basis is the same, the plea is the same, and the contentions are the same, except the contention of a revenue record or mutation being entered into the name of the defendants. In that name of the defendants, the learned counsel for the petitioner is right. The respondent rightly contends that there is no warrant to continue the status quo order. As in the teeth of the status quo order, there has been squabble between the parties, which has led to registration of FIR against the FIR against the plaintiff by the respondent. He would submit that the respondent defendants are in possession throughout, which prima facie merits acceptance due to the dismissal of 3 suits for injunction filed by the plaintiffs. In that light, there is no warrant to continue the interim order as the suit is at large before the concerned court. For the aforesaid reasons, the following order: the petition is rejected. The interim order, if any, subsisting as on date, stands dissolved. It is open to the petitioner and respondent to urge respective contentions before the concerned court. Ordered accordingly. Next.
Time limit may be fixed for disposal of the suit.
ಯಾವ ವರ್ಷದ sir suit?
22.
No sir. The trial court the concerned court shall endeavor to conclude the proceedings as expeditiously as possible.
All contention are open ಅಂತ ಇರ್ಲಿ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಯಾಕಂದ್ರೆ ಸೂಟ್ ಮೇಂಟೈನಬಿಲಿಟಿ ರೂಟ್ 11
ಹೇಳಾಯ್ತಲ್ಲ ಅದನ್ನ ಈಗ ಅಲೋ ಮಾಡಿದ್ರೆ
ಪ್ಲೀಸ್ ಪ್ಲಸ್
ಸೇಮ್ ಆರ್ಡರ್
11.
for direction.
Not that to deposit the amount, the critical amount.
This is a matter pertaining to the 138 proceedings, my lord, where
138 proceeding.
The joint memo was filed
there
before
was
the
a
magistrate
giant memo
court.
before the Adalat, my lord, during the COVID period. And at least we have been issued.
Who is the accused?
Accused is the respondent here, my lord.
You did not adhere to the settlement.
I could not pay because that there is no legally recoverable.
Why did you agree for the settlement?
Because of the other issues, my lord, which has been involved.
Then we will revive the 138 proceedings.
That is what I made an application. That is what I made an executing court to go and inquiry.
Executing court can't revive, sir.
You
You should file a petition under 482. Yes.
It can
In fact, they filed an application, writ petition before this.
revive and remand back to the original court to hold a trial.
But this is,
In this jurisdiction, I cannot.
but in fact, they challenged the order passed by the magistrate court by filing writ petition before this honorable court.
ಎಷ್ಟು amount ಇದೆ ಈಗ?
Page 15 lakhs. And in fact, he appeared before the executing court. Then he challenged the order
Liability is admitted?
Liability is admitted.
No, not admitted. Liability is never
Like a
admitted.
check nimdalva.
Check nande, but it has been involved so many other legal issues. I mean,
ಏನ್
civil issues,
check nimda?
Check
Check
nandene,
nimde
but
ತಾನೆ?
not given to the petitioner herein. It was
ಮತ್ತೆ?
given to somebody which has been misused by the petitioner.
Who
herein.
somebody?
Through a common friend, my lord, there are certain civil issues, my lord, where the property has been purchased.
ಇದೆಲ್ಲ all these swan songs should stop. ಅದಕ್ಕೆ 138 ಕೇಸ್ಗಳು ಇಷ್ಟೊಂದು ಆಗಿರೋದು.
Next year, F is
All frivolous grounds we are permitting you to raise. ಚೆಕ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಅಷ್ಟೇ.
ನಡೀಲಿಲ್ಲ ಬಿಫೋರ್ ಟ್ರಯಲ್
ನಿಮ್ನ ಯಾರು ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಳಕ್ ಹೇಳಿದ್ರು? You are signing the compromise document is admission of liability, further admission of liability.
That is the mistake which I have made
Mistake
earlier, my lord. Earlier, my lord, I made an filed a writ
Again
petition.
challenge ಮಾಡಿದ್ದೀರಾ?
Lord, you Lord, I have not, in fact, I filed an application Lord 21 to 11A. Lord, in fact, court has rejected my application holding that the inquiry is contemplated. But in fact, you Lord, can appreciate now. Earlier proceeding, the earlier orders, Lord, the trial court, the executing court has issued an arrest warrant without an application. That was challenged before the Honorable Court. Ultimately, that order was set aside. Therefore, I filed an application under 21 to.
That is rejected now.
That was rejected before the Honorable Court. Now, you will also kindly appreciate annexure F is my lord. In fact, he has challenged the order of the my lord, magistrate court saying that my lord, the joint memo is obtained by exercise of fraud. But thereafter, in fact, my lord, he filed a memo and withdrawn the writ petition. Now, you cannot say that my lord, that is that order is became.
Where is the order rejecting it?
Annexure F, page 47.
Page E order.
Annexure. No, E order, my lord.
Annexure A, my lord.
One ನಿಮಿಷ. Impugned order.
Impugned order will also be get at page 76 annexure L. Relevant page is not page 80.
ಓ ಅಚ್ಚ ಕನ್ನಡದಲ್ಲಿ ಬರೆದಿದ್ದಾರೆ?
ಕನ್ನಡದಲ್ಲಿ.
ಸರಿ, yes.
The reason recorded by the executing court is that it requires inquiry. Apart from that, the judgment letter has also filed an application under section 47, not contending that the request, the inquiry is to be conducted. Now that was both the application came to be rejected. Not against which he has filed the present application, present petition as subsequently. After the service of notice in the
Which writ petition is that?
Second writ petition 11.1.
Connected writ petition.
11.1.
Second one ನಿಮ್ದಾ? ಕಾರಣ ಏನು ಹಾಕಿರೋದು?
ಅದೇ same order in fact.
May I make a submission? Lord, earlier I made filed a writ petition for quashing for permitting me to withdraw the joint memo. That came to be withdrawn with liberty to avail remedy in the executing court only under section 47 of the CPC. That application I filed, which came to be rejected. Therefore, I am before this court in another connected writ petition. The another application, my lord, earlier there was in the executing court, there was an order of Dastagiri.
So you have not filed any application for revival of 138 proceedings?
He has not filed it. In fact, he has filed the writ petition before the Honorable Court.
I had asking to revival of.
Where is that application? Where have you filed it?
I had filed that is pending tomorrow, pending here once again. I had filed earlier.
Which
also.
court, sir?
In another court, my lord.
May submission. You will also kindly turn to annexure.
Yes. List the matter on 30th.
The same ground, my lord. In fact,
We'll see. List the matter on 30th. It actually should be revived. Yes, next.
Petition. Defendant's writ petition. Defendant's writ petition, my lords.
Any challenge?
The prayer is to confirm the trial court's order and to set aside the appellate's court order, my lords. 39 rule 1 and 2 application. Suit for injunction. Admittedly, land is vacant.
No, not admittedly. One ನಿಮಿಷ.
It's a vacant land. It's a vacant land, my lords.
ಅವ್ರು admittedly ಅಂತ ತಕ್ಷಣ dispose ಮಾಡ್ಬಿಟ್ಟು ನಾನು. Wait, yes.
My lords, my contention is the said land is a park premises, my lord.
Park
premises.
Park premises. Park.
Which was reserved as a park. And my lords, claiming under through KT Sundar, who is alleged to have.
ಈಗ ಅದೆಲ್ಲ ಬಿಡಿ, ಚಾಲೆಂಜ್ ಏನ್ ಹೇಳಿ? Don't argue the suit here.
Lords, my challenge is on the appellate's court order, my lords.
Concurrent finding,
No, my lords, divergent.
You are the
Status quo was
defendant.
granted by the
Stay was
honorable.
granted.
Status quo.
No,
Status quo was granted by the trial
Injunction
court.
is rejected first.
Status quo was granted, my lords. I didn't challenge that.
ಎಮ್ಮೆ ಹಾಕಿಲ್ವಾ?
ಎಮ್ಮೆ ಅವ್ರು ಹಾಕಿದ್ರು, ಅದರಲ್ಲಿ temporary injunction is granted, my lords. Like as main relief. I am not objecting status quo, my lords. My request is status quo may be continued, my lords. Even a direction may be fixed, my lords, for disposal of this one.
ಅಲ್ಲ, ಇಲ್ಲೇನೋ order of status quo is granted here.
Here.
Yes, Prakash sir.
No, my lord. This, he admittedly, my lord, the plaintiffs, they are, my lord, the activist of some, my lord, association. My lord, I have permitted them to, my lord, install Ganesha idol, my lord, during festival. It is my side. Now the suit is filed. My lord, when I said I wanted to put up construction, I obtained building license from the corporation and approval to the building plan. When I wanted to put up construction, my lord, on my site, which I have purchased under 2 registered sale deeds, my lord, these people, my lord, they have instituted a suit before the trial court, my lord, in 2021, my lord, they 22. The contention is that, my lord, the sites are the portion of a park and, my lord, the road. And they wanted an injunction against me, contending, my lord, but kindly see the prayer, your lordship, kindly see in the suit.
ಒಂದೇ
Different
ನಿಮಿಷ.
suit,
Just
that
one
is my
minute. ಪಾರ್ಕ್ ಅಂತ ಹೇಳಕ್ ಏನಿದೆ?
Let's produce
Page.
My lord, I pass on this. I have
page
given copy
83,
to-
annexure J, my lords.
I have given copy last occasion itself.
Annexure J, page 83, my lords. It is towards the left side. 63 and 64 are marked as park. What the learned respondents advocate, my lords, is producing is a building plan. Adernalli ಮತ್ತೆ layout plan ಹಾಕ್ಬಿಟ್ಟು
ಏನು ಚರ್ಚ್ ಆಫ್ ಸೌತ್ ಇಂಡಿಯಾದ ಇದೆ?
No, what, my lord, in this layout, my lord.
It's a
CSI
dwelling house
ಅಂತದಲ್ಲಿ?
layout.
Not
It is a
correct.
dwelling house
Not
plan,
they have-
CSI property.
not a layout
No, my
plan.
lord, they have given, my lord, the layout plan itself in this, my lord. Kindly see this. Apart from, my lord, the approved building plan.
ಏನ್ ಸರ್ವೆ ನಂಬರ್ ಇದೆ?
My lords,
64 and 65, my lord, site.
in site number is 64 and 65, my lords, which they claim as a site.
Where do you get that it's a park? In which document?
My lords, annexure J, page 83, my lords. Produce a map, layout map. My lords, may kindly produce annexure M and N, my lords, wherein
Page
they
ಹೇಳಿ
claim
sir.
under this title.
Page.
Page 83, annexure J, my lords. This is the layout plan. Towards the left side, my
Site
lords.
number?
My lords,
Numbers ಹೇಳಿ.
63 and 64, my lords. Towards left side, it is marked as.
ಪಾರ್ಕ್ ಅಂತ ಇದೆ?
Please, my lords.
My lord, this is not a, my lord,
Lords, may kindly
authenticated
produce
document.
annexure M and N, my lords.
My lord, kindly see the plan I have.
ಒಂದ್ ನಿಮಿಷ. ಆಮೇಲೆ?
Annexure M and N, my lords, page number 92. They claim under this title deed, they say this is an Akkupatra which is issued in the year 1980s, my lords. This is typed in Times New Roman font, my lords. High Court alla typing irlilla.
Typed?
This is 1989 document which they have claimed that Akkupatra was issued in their vendor's favor.
ಈ ತರ ಸ್ಟಾಂಪ್ ಪೇಪರ್ ಎಲ್ಲಿ ತವಾಗ?
1989 document, my lords. Even High Court didn't have computers or anything.
ಹಿಂಗೆಲ್ಲ ಹೇಳ್ಬೇಡಿ.
And the schedule also, my lords, very suspicious document, my lords, considering the cloud of title.
Yes, you are claiming under CSI, is it?
CSI, my lord, allotted to my vendor by way of Akkupatra. And my lord, she sold me under a registered sale deed. My lord, let us say that, my lord, my vendor had no title. The suit is for, my lord, injunction. What is the right of these persons?
Not my
So
suit, my lords.
they have no locus standi. What is the, therefore, my lord, kindly see the prayer, my lord, in the suit.
Plaintiff ಯಾರು?
Plaintiff is
Plaintiff is, my
respondent.
lord.
Respondent.
Plaintiff ಯಾರು? ನೀವೇ. ಅವ್ರ ರೈಟ್ ಏನ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ? ಅವ್ರು ಡಿಫೆಂಡೆಂಟ್ ಸರ್.
Yes, my lord.
ಮತ್ತೆ ನೀವು
Ma-
ಪ್ಲೇಂಟಿಫ್
ma-
ಡಿಫೆಂಡೆಂಟ್
no, no,
ಡೌಟ್?
Sorry, I am sorry.
ಹಾಗಾದ್ರೆ ಅದು ಸರ್ವೆ
My lord,
ಡೈಟ್ ನಂಬರ್ ಗ್ಯಾರಂಟಿ.
My lord, I stand corrected, my lord. My lord, my submission is, what is these people, my lord, they have no locus standi to, my lord, say that.
ಅದು
to
court will
challenge my
decide.
title, my lord. it is-
Court will decide,
No, my lord,
sir.
I understand that, but
They are not
they have no.
Plaintiff evidence.
ನೀವು ಪಾರ್ಕ್ ಹೋಗ್ಬೇಕಾ? ಮತ್ತೆ ಇರಿ. Yes.
My lord, my submission is, my lord, whether my vendor has got title or not, my lord, admittedly, the layout was formed by, my lord, the South India, my lord, church.
ಇದು
Church.
ಸ್ಟೇಟಸ್ ಕೋ ಇರೋದನ್ನ ಕಂಟಿನ್ಯೂ ಮಾಡಿ ಕಳಿಸ್ತೀನಿ ಬೇಕಾದ್ರೆ. ಇಲ್ಲ ಅಂದ್ರೆ ಪಿಟಿಷನ್ ಅಲೋ ಮಾಡಿ ಕಳಿಸ್ತೀನಿ. ಚಾಯ್ಸ್ ನಿಮ್ದು.
My lord, they have not challenged,
ಅಷ್ಟೇ.
my lord, status quo. My lord, what happened is, before the trial.
No
court-
third option.
No, my lord,
इसको लॉक कर दिया जाए ಹೇಳಿ.
kindly see my, the sketch I have produced. Kindly for a minute, my lord, your lordship. kindly.
ಬಿಲ್ಡಿಂಗ್ ಪ್ಲಾನ್ ಅದು.
No, not building plan. My lord, they have given, my lord, this layout plan also to identify in respect of which site the building license is issued. This is issued by corporation.
ಆಪ್ಷನ್
Kindly see.
3 ಇಲ್ವೇ ಇಲ್ಲ. ಆಪ್ಷನ್ 3 ಇಲ್ವೇ ಇಲ್ಲ. ಚಾಯ್ಸ್ ಇಸ್ yours. He is agreeable for status quo to be continued.
No, status quo. my
ಪಾರ್ಕ್
lord.
ಅಲ್ಲಿ ಗಣಪತಿ ವಿಗ್ರಹ ಹಾಕೊಂತಾರೆ
No,
ಬಿಡಿ.
no, my lord, your lordship kindly see the photographs I have
ಅದು
produced.
ಗಣೇಶ
along-
ಹಬ್ಬ ಟೈಮಲ್ಲಿ
No,
ಮಾತ್ರ.
Along with, my lord, your lordship kindly see these photographs. My lord, it is easy to say that it is a park and road and all, and my lord, impress upon the court to see that. I have
ಸೂಟ್ ಸರ್.
kindly.
ನೀವ್ ಹಾಕಿರೋ ಸೂಟ್ ಸರ್.
Who?
ಇಂಜಂಕ್ಷನ್. ಕೊಡಿ ಸ್ವಲ್ಪ ಮೇಡಮ್ ಫೋಟೋ ಕೊಡಿ.
Photos. Can it be, my lord, called as a park or a road? Kindly see this.
ಯಾವ್ದೋ ಪಾರ್ಕ್ ಕಾಣ್ತಾ ಇದೆ ಇಲ್ಲಿ?
No, it is not. Park is on the opposite side.
ಹಾ.
Opposite side, my lord. My lord, park is here, my lord. It is
ಇದು
park.
ಯಾವ ಫೋಟೋ ಯಾರು
64 and 65.
ಎಲ್ಲಿ ಯಾರು ಗೊತ್ತಾಗುತ್ತೆ ಇದು?
My lord, this is the, my lord, your lordship kindly see his, my lord, annexure J. Kindly see this along with annexure J, my lord, the.
ಎಂಟಿ ಸ್ಪೇಸ್ ನಿಮ್ದ?
Yes, yes, empty space.
ನಿಮ್ದ?
ಹೌದು.
ಸರಿ ಆಯ್ತು.
My lords, the present stage, my lords,
My lord,
is
may
for
I
plaintiff
submit this?
evidence.
My lord, is a suit for injunction. My lord, he says I have no title, I have no, my vendor has no title. My lord, vendor is Church of South India. My lord, if I have no title, it goes to the Church of South India, not to these people. My lord, I have allowed them to
ಸರ್ ಸೂಟ್
install.
ನಿಮ್ದು. You are
Therefore,
no, you are arguing
no,
as though he has filed a suit
no,
for
no,
declaration.
Not that.
ನೀವ್ ಹಾಕಿರೋ
No,
ಸೂಟ್.
I have given them permission to install, my lord, Ganesha idol. That is the mistake I have committed.
No, no.
My lord, because of that now
Don't say
they
it's a
want to
mistake,
say.
sir.
Now they contend that I have no title at all. My lord, your lordship is an estoppel. They cannot challenge my, I have given permission.
ಗಣೇಶ
They now
ಎಷ್ಟೊಪ್ಪಲ್ಲ?
No.
Then
Pardon?
ಗಣೇಶ ಎಷ್ಟೊಪ್ಪಲ್ಲ?
No, no,
Then?
for them, my lord,
Huh.
a tenant
ನೋ
cannot.
ಸರ್. ಎಸ್
My lord,
ಚಾಯ್ಸ್ ಎರಡೇ. ಕಿಸ್ಕೋ ಲಾಕ್ ಕರ್ ದಿಯಾ ಜಾಯ್ ಹೇಳಿ ಮಾಡ್ಬೇಡ. ಎಸ್.
My lord, may I submit? It is a suit for injunction.
ಮತ್ತೆ
No,
ಅದನ್ನ
no, ಒಂದ್ ನಿಮಿಷ ನೀವು ಹೇಳಕ್ ಬಿಡದವ್ರು ನಾನು
ಹೇಳಿ
ಮುಗಿಸ್ಬಿಡ್ತೀನಿ ನಾನು.
ಆಯ್ತು.
ಅಲ್ಲ ಈ ನೀವೆಲ್ಲ ನೀವು ಹೇಳಿದ್ದೀರಿ ಈಗ. I know I am under threat now either to see that, my lord, argue and
Yes, sir.
argue and suffer, my
Yes,
lord,
yes,
adverse order, or to, my lord,
ಅಷ್ಟೇ.
agree for the suggestion. My lord, I understood that. Before that, my lord, what I said, the suit is, my lord, the pleadings are complete now. Therefore, my lord, your lordship may say within 6 months, my lord, suit.
ಅದನ್ನ ಅವಾಗ್ಲೇ ಹೇಳಿದ್ರೆ.
ಅಲ್ಲ ಅದು ಹೇಳಕ್ ಹೊರಟದ ನೀವು ಬಿಡ್ಲಿಲ್ಲ.
ಬಿಡಲ್ವಲ್ಲ.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ.
ನೀವು ಗಣೇಶ ಅಂದ್ರಲ್ಲ ಅದಕ್ಕೆ.
After knowing the mind of the court, my lord, I can argue another half an
Prakash
hour.
sir is that I knew, yes. The petitioner is before this court calling in question an order passed by the first appellate court. You are the defendant, huh? Correct.
To defend it.
First appellate court, what did the first appellate court do? Status quo na?
It
Granted injunction.
Granted. My lord,
First
status
appellate
quo.
court granting temporary injunction restraining the petitioners from interfering with the possession of the plaintiff, the respondent herein, in MA 18 of 2023. The learned counsel for the petitioner defendant, who has called the said order in question, would take this court and submit several submissions with regard to the nature of the property which is claimed by the plaintiff. According to him, it is a park. According to the respondent plaintiff, it is not a park. It is purchased, allotted, huh?
Allotted to my vendor. I
It
purchased
is
from my-
allotted to his vendor by the Church of South India, and the plaintiff has purchased it from the vendor who was allotted, from his vendor who was allotted by the Church of South India. The learned counsel would further submit that he has permitted the usage of this space for during the Ganesha festival, for the Ganesha festival, and not for anything else, and it is his own property. The learned counsel for the petitioner defendant would submit that the very title is doubtful. Be that as it may, this court, coordinate bench of this court, by an order dated so and so, has directed parties to maintain status quo qua the property till the disposal of this suit. I deem it appropriate to dispose the petition by continuing the said order of status quo granted on 18/4/2024 till the disposal of the suit. Since the suit is for bare injunction and the bare injunction, I deem it further appropriate to direct the concerned court to expeditiously dispose the said suit is of the year? Where injunction and the suit is of the year 2023, I deem it appropriate to direct the concerned court to dispose the suit with an outer limit of 6 months. All contentions remain open.
22, suit is of the year 22.
22, yes. 6 months. Next.
13.
For the respondent.
Appear for the petition. In a suit.
Here for stay.
My lords, it's
Stay of further proceedings, my suit.
plaintiff's writ petition, the cross is also over, my lords. Now, in practically this.
Shall I submit or
writ petition is.
I have filed the suit for recovery of money. During the course of evidence, documents have been produced and have been marked also. There was amplification of pleadings which I am only seeking. That is, what are the invoices numbers and what was the amount paid is all, which they have also admitted in their cross-examination. I have placed it on record. In order to plead that, I had sought for an amendment. Only amplification, nothing, no adding, nothing.
In 617.
6 rule 17. Then a document was admitted by the other side during the course of cross-examination. The court refuses to mark it, saying it is a Xerox copy. He admits it in evidence, and when confronted in the cross-examination, I don't mark it because it's.
He'll stay there.
Stay. Nande suit.
Nimde suit, plaintiff.
Now they suit, they seek for interim prayer of stay.
I saw this
one year back, they file an application also for stay. The matter, they've not moved it up.
Let the court consider it. Application pending, the court will consider it.
No, this application is dismissed with this amendment.
Where is it?
Annexure T, Annexure F.
Page
32.
Page 32.
Lord, it's the 16th
All
suit which is transferred.
Yes.
16th suit was filed. It was transferred to commercial court in 2021. Court says that the matter is pending since 16, therefore I don't want this. And all these documents are already marked in evidence as Exhibit P1 to P32. Cross-examination is made by the other side.
Evidence has commenced.
Evidence has commenced, and I am.
What do you want to bring in now?
The invoices have been sent under which supplies have been made. Payments have been made under the bills.
When were the invoices sent?
My lord, they were in 2013-14.
Why did you not plead that earlier?
I have stated in my pliant, it is not amplified. Details of it, the period
You amplified by arguments. I will permit you to amplify by arguments because you already pleaded.
The details of this I am stating, which I have already produced the documents.
No problem. I will permit you to argue everything and in amplification.
And document mark madade idu mabtiyala.
Yav document mark madade. Evidence alli en madbek maadi tondre 617 I will not permit.
Document is admitted by the other side. Court refuses to mark it, saying it is a Xerox copy.
May I point out two things, my lord. One is, my lord, 16th suit. The amendment is sought to be.
617 I am not permitting. Concentrate on Xerox copies.
Please,
yes.
What I was going to say is that what the submissions also had to be in terms of the application, what the affidavit would say. My lords may also see 28, my lords, page number 28, which is the affidavit. That's all I was going to point out insofar as 6 rule 17, my lords. None of what the learned senior is saying has been captured in their affidavit.
That's all right. I am only permitting the counsel to amplify during his argument.
Why I'm saying that, my lords, in the original plain, there is nothing regarding these bills, these invoices, my lords. So there is no question.
What stops him from arguing all that?
Without pleadings, any amount of evidence is of no consequence.
It's not.
They having marked some bills already without any pleadings. I have not got an opportunity to file.
That's why I asked, what are those invoices of?
Invoices under which they made supply.
Yeah. 2013.
TNT.
2013. Suit is 2016. 617 is filed in 2024.
Yes.
Correct.
My submission is this, my lord. That is, I have stated in para 3 of the plaint, my lord may kindly see page number 11.
Plaint already?
There are transactions, these transactions have continued in between plaintiff and defendants from 19-1 to 23-9-2013.
You amplify this with regard to evidence.
I have produced the documents. They have cross-examined me on that. They have also cross-examined. My lord may kindly say page number 52, 50.
Let the admitted documents be marked.
Alla, first 28th of notice, page 28. This is the affidavit. Nowhere do they contend that it is an amplification of
That's all
pleadings
right.
that is.
That I will,
That is,
submission I will take.
Yes, page
Alla, it
51,
has to be an
sir.
affidavit.
617 I am not permitting, sir.
Please, Alla, even if an observation is being made that they are only amplifying, it is not their contention in the affidavit.
Now it is his contention.
It cannot be done on this because what 6 rule 17 also would say, my lord.
6 rule 17 I am not permitting, sir.
Alla, even an observation is what I would be aggrieved by, my lords.
Page 51, sir, no.
Advanso.
ಈ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಆಲ್ರೆಡಿ ಇದೆಯಾ? ಎಷ್ಟು ಕೊಡ್ಬೇಕು?
8 lakh
Alla, those are not the bills that are due. This is not even relevant.
8,16,000 with interest.
It is not their case that the amendment that they are seeking to introduce is what is due.
Yeah, definitely, please see it. They will
It
not
doesn't say that in the amendment.
Records not, my
It
lord,
doesn't
pen
say
is
that in the
I will,
amendment.
I will permit you to amplify those submission, whatever you have pleaded. But I will not allow you to amend the plaint to bring in those 2013 invoices because you are hit by proviso to rule 17, no doubt about it.
My lord, I only one.
Because they are all anterior to the institution of the suit itself. Due diligence fails, so rule 17 will kick in. Yes.
And I have one submission.
Proviso to rule 17. Yes.
My lord, may kindly see page 50 and I will leave. Page 50.
Yes.
ಪ್ರತಿವಾದಿಗಳು ನನಗೆ ಮೆಟೀರಿಯಲ್.
I'm there.
Yes. My lord, that is ಈ ಕೇಸ್ನಲ್ಲಿ ನಾನು ಅಗತ್ಯ ದಾಖಲೆಯನ್ನು ಹಾಜರುಪಡಿಸಿರ್ತೇನೆ. ನೆಕ್ಸ್ಟ್ ಒಂದು, ಪ್ರತಿವಾದಿ ನನಗೆ ಮೆಟೀರಿಯಲ್ಗಳನ್ನು ಕಳುಹಿಸಿದ ಬಗ್ಗೆ 37 ಇನ್ವಾಯ್ಸ್ ಕಮ್ ಡೆಲಿವರಿ ಚಲನ್ಗಳನ್ನು ಕ್ರಮವಾಗಿ P1 ರಿಂದ 30 ಇದು ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೆ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿದ್ರು ಅದ್ರ ಮೇಲೆ. ಈಗ ಡೋಂಟ್ ಸಿ ದಟ್ ಅಂತ.
ಅಲ್ಲ, ಇದೆಲ್ಲ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿದ್ದೆಲ್ಲ
ಮಾಡಿದ್ದಾರೆ.
You argue on that also, no problem.
That those documents can be looked into and.
The petitioner is the plaintiff, is before this court calling in question orders dated 11/12/2023 and 1/4/2024 passed in commercial OS 2 of 2022. The two applicants, the petitioner, the plaintiff institutes a suit in on 13/4/2016, a suit in OS 48 of 2016 seeking recovery of certain sum. After on the constitution of the commercial court, the matter is transferred to the commercial court, which is then renumbered as OS 2 of 2022.
Commercial OS.
Commercial OS 2 of 2022. The issue in the list is not with regard to the merit of the matter. In the subject commercial OS, the petitioner files two applications. One under Order 6 Rule 17 seeking amendment of the plaint, and the other the marking of certain documents.
Not the other. Another is that the court refused during evidence to mark the document.
And another order which the court has declined to accept the plea of submission with regard to the documents already marked. Insofar as the application under Order 6 Rule 17 is concerned, the suit is instituted in the year 2016. The invoices that the petitioner is wanting to mark, wanting to bring in by way of amendment under Order 6 Rule 17 are of the years 2013. If these documents were available in the year 2013, nothing stopped the petitioner from marking the same or producing the same. In the year 2016, at the time of institution of the suit, the Order 6 Rule 17, proviso to Rule 17 of Order 6 Rule 17 would mandate that the plaintiff should exercise due diligence at the time of filing of the suit. Since the documents are of the year 2013, and the application is filed in the year 2024 of a suit of the year 2016, there cannot be that the application should be allowed for the asking without demonstration that there was even with due diligence those documents could not be produced. That is not the affidavit that is filed before the concerned court by the petitioner. The learned counsel would now restrict his submission to amplification of the pleadings already made in the plaint with regard to certain invoices. The said submission would merit acceptance despite opposition from the hands of the respondent counsel. Therefore, the petitioner is permitted at the time of arguments to amplify those contents of the plaint contents of the plaint it is needless to observe that the concerned court would answer those amplified submissions as well. The other submission is with regard to
Documents marked already.
one నిమిషం. of the concerning the amplified submissions as well of the documents already marked. The the other submission with regard to marking of documents is borne out from cross-examination. Therefore, the permission to amplify the submissions where the plaint and the cross-examination would remain, and the petition would suffice, the said direction in the considered view of the court would suffice for the present in the light of the submission so made by the petitioner. In the light of the aforesaid observations, the petition stands disposed, ordered accordingly.
And the marking of document.
ಅದು ಹೇಳಿದ್ನಲ್ಲ,
ಅಲ್ಲಲ್ಲ ಅದರಲ್ಲಿ ಅವರು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದು ನಾನು ಮಾರ್ಕ್ ಮಾಡಲ್ಲ ಅಂತಾರೆ.
ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದು ಅದನ್ನೇ ಹೇಳಿದ್ದೀನಿ, ಅಡ್ಮಿಟೆಡ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಒಂದು ಪೇಜ್ ಒಂದು ಕೋಟ್ ಮಾಡಿಬಿಟ್ಟು ಮಾರ್ಕಿಂಗ್. ಎಸ್, ಅಲ್ಲೊಂದು ಫ್ಲಾಗ್ ಇದೆ ಮೇಡಮ್, ಹೇಳ್ತೀನಿ.
Lords, in serial number 9, my lord, what my lords dictated in serial number 9, my lord, if I may just.
You get him in his absence, nothing, no submission.
The submission was that after the suit it was terminated.
No,
ಅಲ್ಲ ಅವ್ರದ್ದು submission ಇದ್ದಿದ್ದು ಅವ್ರಿಗೆ notice ಬಂದಿಲ್ಲ.
You will not make any submission in his absence. After the matter is over, you get him and make any submission.
Submission ಅಂತ ಬರ್ತದೆ.
ಅದನ್ನ ಚೇಂಜ್ ಮಾಡ್ತೀನಿ ಬೇಕಾದ್ರೆ. ಆಯ್ತು.
Please. That they didn't receive the notice because then it will go against me in the trial.
All right, that I will correct. Yes.
I filed a suit for bare injunction, my lord, after hearing both the parties.
Bill number?
14. my lord.
Ah.
TA was granted.
Yen permission ಏನು?
Permission, my lord, the house is completed, my lord. So only house warming ceremony is pending, my lord.
ಅದಕ್ಕೇನು ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ? ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರಾ?
I have, I'll stay in, I have given an undertaking before the trial court, my lord, is at page 103, my lord. That in case if, my lord, if I don't succeed, I am going to demolish it, my lord.
Oh. Demolish ಮಾಡ್ತಾರಂತೆ ಬಿಡಿ.
That there is a road ಅಂತ ಹೇಳ್ತಾರೆ.
May I submit, my lord? There are two suits here, actually.
Don't argue this suit. He has given undertaking that he would demolish the property.
That's true, but before filing of the bare injunction suit itself, when the building was not erected, in fact, even the foundation was just coming up. At that stage itself, I approached the panchayat, which granted them the plan, saying that it is a road and I cannot access my property.
Where is that?
I have.
It's a road to access your property?
Yes, it is a road to access my property.
What kind of road is that?
It is a village panchayat road.
Public road?
Public road.
Where do I get that?
ಈಗ
ರೋಡ್ ಮೇಲೆ ಕಟ್ಟಿದಾರ ಇವರು?
ರೋಡ್ ಮೇಲೆ ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದ್ದಾರೆ. Encroach.
That is blocking your way?
It is blocking my way. Earlier there was a building.
Kindly see the photographs.
Photo ಏನಾಗಲ್ಲ, yes.
Their building plan itself has been cancelled by the panchayat also.
Where is all that? Objections ಹಾಕಿದ್ದೀರಾ?
Objections ನಾನು ML ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ.
ಅಲ್ಲ, ಇಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ ಏನಾದ್ರು?
ರಿಟಲ್ ನಾನು ಫೈಲ್ ಮಾಡಿಲ್ಲ
objections ಹಾಕಿ. List the matter on 28th, 29th, 30th. Objections, if any, by the respondent by then.
Please.
ಗೃಹ ಪ್ರವೇಶ ಸ್ವಲ್ಪ postpone ಮಾಡಿ. Yes. Yes.
ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ ಅಲ್ಲ.
ಪರವಾಗಿಲ್ಲ, ಗೃಹ ಪ್ರವೇಶ ತಾನೆ.
15 may I request for short passover. He is on his legs, my lord.
Short passover.
He's on his legs in court on 3 minutes.
Filed-
Matter.
We have filed an application, my lords, for a direction. If your lordship just sees the previous interim order granted by this court on 2012-2020.
1712 or what?
2012, my lords. 20th of December 2024.
ಒಂದೇ ನಿಮಿಷ.
After this, I have been depositing 25,000. I have
You're
taken.
the husband?
No, I am.
In-laws.
No, I am the in-laws, father-in-law, my lords.
Two husbands.
Because we don't.
Wait.
No, my lords, pursuant to this order, I have been depositing 25,000 in her account. I have also taken a flat and paying rent so that she can go there. She is not doing that and she still wants to stay.
Where are you staying?
In this house, in spite of this order. This was heard on our application for vacating stay. Because I am the father-in-law and father-in-law's brother. We had filed a suit. My lords, she should obey this order. That's why we have filed an IA that producing those documents and seeking a direction.
Why have you not gone there?
May I request for a passover, senior.
ಇಲ್ಲ ಪರವಾಗಿಲ್ಲ ಹೇಳಿ, why have you not gone there?
No, but it's a shared household. I have been there only.
ಅಲ್ಲೇ ಇದ್ದೀರಾ?
husband through the in-laws files a suit for injunction to evict me, my lords.
Husband thrown, my lords,
I have
there is, it
established
was
that throughout I
heard.
was there.
Matter was heard. An interim order is passed. Now the council, can the party say, I will not obey it? It is a shared household.
She's staying in the shared household.
That is why, my lord, that was their contention. That's how, my lords, it was, the order was passed after hearing that.
Allah, until disposal. This was respond number 1 shall provide 2 BHK rented accommodation to the petitioner in Mangalore city.
And continue to pay
Continue
rent
to pay
until disposal of this.
25,000.
Or pay
ಈಗ
some of.
2 BHK house ಎಲ್ಲಿದೆ?
ನಾವು ರೆಂಟ್ ತಗೊಂಡು ಅದು ಕೊಟ್ಟಿದೀವಿ. Please continue that order, my lords.
Okay.
Or pay 25,000 every month towards rent to the petitioner.
ಒಂದು ನಿಮಿಷ. Rented accommodation to the petitioner Mangalore city and continue to pay.
And then please continue.
Until disposal or pay 25,000 rupees every month towards rent to the petitioner.
Both I have done. 25,000 I am depositing it in her account so that whatever house we show, she will not reply. I have also taken one flat on rent. I am paying the rent. She doesn't want to go there. I am paying 25,000 that also.
ಯಾವ್ದು ಬೇಕು ನಿಮ್ಗೆ? You can't have the cake and eat it too.
My senior has the instructions, but may I request for a short pass?
Pass over.
Please.
Pass over doubt ಇವತ್ತು.
Then, my lord, some date you
Friday.
Please, motion.
At the request of the council for the petitioner list on Friday, it is made clear no further adjournment would be granted. ಎರಡು ಆಗಲ್ಲ. ನಿಮಗೆ ರೆಂಟ್ ಅಕಾಮಿಡೇಷನ್ ಬೇಕಾ ಇಲ್ಲ ರೆಂಟ್ ಬೇಕಾ?
We'll make it clear. We'll make my submission.
ಎರಡು ಆಗಲ್ಲ. Tell senior.
Please.
Earlier order is already there.
Please. But that was passed in her. My senior was not there on that day. That order has been passed.
Challenge ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
Please, please, I'm sorry.
That's not right.
Petitioner by me, madam.
Appearing for the respondent's matter.
Lord, in this matter, the respondent has filed a eviction suit along with the seeking arrears of rent against the petitioner, madam. After lapse of 1 year, they have filed the application under section 151 to seeking to pay the arrears of rent, madam. That application came to be partly allowed by the court.
You are the tenant.
I am a tenant.
ಎಷ್ಟಿದೆ?
Lord, total arrears of rent, Lord, 20 lakhs.
ಎಷ್ಟು?
20 lakhs 88,097.
ಯಾವಾಗಿಂದ ಕೊಟ್ಟಿಲ್ಲ ರೆಂಟ್?
My lord, my lord, they have paid from 2011, but suit filed in the year 2022. Previous last 3 years, my lord, they have not paid. When, my lord, I have filed an application, the trial court was passed an order.
My lord, in this
ಈಗ
matter, my lord.
ಏನ್ ಸೂಟ್?
Suit for ejectment.
Ejectment.
ಎಸ್ ಸರ್. ಯಾವಾಗ ಬಿಡ್ತೀರಾ?
My lord, in this matter, my lord, there is no admission in respect of the arrears of rent. They filed application on section 151 of CPC.
ರೆಂಟಲ್ ಇದ್ದೀರಾ?
Rental ಇದೀವಿ. Rental ಇಲ್ಲ.
ಹೆಂಗಿದ್ದೀರಾ?
ಅಲ್ಲೇ ಇದೀವಿ. Premise.
ಅಲ್ಲ, how did you enter into the
My lord,
premises?
in the year 2000, my lord, 2008,
How?
rental agreement ಆಗಿತ್ತು.
ಎಷ್ಟು ರೆಂಟ್?
ಅದೇ 2008 ಅಲ್ಲಿ. Then after 2010 ಅಲ್ಲಿ lease agreement ಆಯ್ತು. I paid 9 lakhs, additional 9 lakhs security amount that will converted into lease. There is no rent for that premises. Then, my lord,
it is not on rent.
After death of the father of the respondent, my lord, we have sought to vacate the premises, get back my
9 ಲಕ್ಷ ಕೊಟ್ಟಿಲ್ವಾ?
11 ಲಕ್ಷ ಕೊಟ್ಟಿಲ್ಲ. That's why we are residing in that. If they pay that 11 lakhs, we'll vacate the premises today.
For a moment, my lord, kindly see, I have filed a memo along with documents. In document, my lord, it is clearly shows that what they have done.
They have taken.
ಇಲ್ಲ 9 ಲಕ್ಷ ಕೊಟ್ಟಿರೋದಕ್ಕೆ ಡಾಕ್ಯುಮೆಂಟ್
11 ಲಕ್ಷಕ್ಕಿದೆ.
11 ಲಕ್ಷ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ.
Document ಇದೆ.
ಅದು ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
2 ಲಕ್ಷ 11 ಲಕ್ಷ.
My lord, one submission. My lord, we are not, they have paid amount from, my lord, in the year 2011.
ಯಾರಿಗೆ?
My lord, for a moment.
ಯಾರಿಗೆ?
ಯಾರಿಗೂ ಪೇಮೆಂಟ್ ಮಾಡೇ ಇಲ್ಲ ಇಲ್ಲಿವರೆಗೂ ಅವರು ಅರಿಯರ್ಸ್ ಆಫ್ ರೆಂಟ್.
11 ಲಕ್ಷ ಯಾರಿಗೆ ಡೆಪಾಸಿಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
ತಂದೆಗೆ.
But they have produced the document. They are not produced.
Agreement produce ಮಾಡಿದ್ವಿ lower total ಇದೆ.
That is the reason, my lord. For a moment, my lord, kindly
They
see, I
are
have filed a
taking
memo
that
along
forged
with
documents ಅಂತ ಅದೇ contention.
My lord, for a moment, my lord. I have filed a memo along with
Your
document.
father has permitted his stay.
In the year 2008.
In the year 2008.
Yes, my lord.
2011, he says it was converted into lease pursuant to lease
It is
agreement.
concorded document. For a moment, my lord, kindly see. That reason is this, my lord. They have admitted 15,000 rent. They have admitted rent also, they have not paid till today.
Where is the admission?
My lord, they have also filed in.
Where is the admission?
Please, my lord. For a moment, my lord, kindly see my document, my lord, memo along with documents. I have filed. The rental agreement dated 26/11/2010.
Lease deed.
Please, my lord.
A bracket ಅಲ್ಲಿ concocted document ಅಂತ ಯಾಕೆ?
My lord,
ನೀವೇ
it is-
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದು.
That is, they have done. For a moment, my lord, kindly see first agreement, my lord,
ಪೇಜ್ ಏನದು?
page number 11, my lord.
Concocted,
It is agreement executed by my father in favor of the.
rental agreement.
Please, my lord, rental agreement.
Lease agreement ಅಲ್ಲಿ
21 ಅಲ್ಲಿದೆ.
20?
21. For a moment, my lord, kindly see the my lord signature done by my father in the both the agreement and lease deed.
Page agreement.
And 11 and 21.
What's your father's name?
My lord, my father name is my lord Karegowda.
Huh?
Kadegowda.
ಕಡೆಗೌಡ.
Please, my lord.
ಹಂಗೆ ಇದೆಯಲ್ಲ?
No, my lord.
ಹಾ.
Then, my lord, it is created by document created by the defendants.
Signature same ಇದೆ.
Then, my lord, for a moment, my lord, kindly see next page, ink page number 22.
ಆಯ್ತು. When did your father die?
My lord, my father died on in the year 2012, my lord.
38, 2012.
12,
38?
2012,
This agreement is, lease agreement is dated
2010, my lord.
2010.
2010. Any document of payment of rent between
No.
this 2010 to 12?
They have not paid, my lord.
Any document?
No, my lord, they have not paid.
After 2012,
From 2019, my lord, as per, please.
after 2012, also they did not pay.
No, my lord.
Why did you keep quiet?
My lord, I regularly have approached. Then, my lord, they have filed a suit for partition, permanent injunction before
When?
the trial court.
When?
My lord, in the year 2015.
What
Then, my
happened
lord,
to
the
that?
suit was dismissed for non-prosecution. Later, my lord, they have filed in the year 2021 also filed a suit for permanent injunction. Then, my lord, suit, they have not stated earlier suit filed by the petition against me. My lord, even though, my lord, I have written a letter to the petitioners to vacate the scheduled property in the year 2022. They have not paid the arrears of rent, not vacate the scheduled property.
No. Why did you keep quiet from 12 to 2019? When you knew that they are not paying rents, why did you keep quiet?
My lord, they have regularly approached.
Why did you keep? 7 ವರ್ಷ ಯಾಕೆ ಸುಮ್ಮನೆ ಇದ್ರಿ? ನಿಮಗೆ ಗೊತ್ತಿದ್ರೆ ಇದು ಲೀಸ್ ಅಲ್ಲ ರೆಂಟ್ ಇದು ಅಂತ 7 ವರ್ಷ ಯಾಕೆ ಸುಮ್ಮನೆ ಇದ್ರಿ?
My lord, on that reason, my lord, I will take instruction. Kindly have done day after tomorrow.
Yes.
Not
So
7 years,
it
my
was a lease where your father had received 11 lakhs. You knew that, you kept quiet. ಆಮೇಲೆ you wanted to convert this. ಯಾಕಂದ್ರೆ ಅವ್ರು ಬಿಡ್ಬೇಕಾಗಿತ್ತಲ್ಲ.
My lord,
ನೀವು
they-
11 ಲಕ್ಷ
even though, my lord, as per the
11 ಲಕ್ಷ
agreement.
11 ಲಕ್ಷ ಕೊಡಿ ಬಿಡ್ತೀವಿ ಅನ್ನೋದಕ್ಕೆ ಇದು.
No, my lord, no, my lord. Even though after agreement, my lord, in the year 2010, the agreement was called in the year 2019. They have not paid in the 2019.
Lease
also.
agreement, sir.
My lord, 9
ಅದ್ರಲ್ಲಿ
years.
ಕೊಟ್ಟಿರೋದು ಲೀಸ್ ನಾಟ್ ರೆಂಟ್.
9 years, my lord.
ಅರಿಯರ್ಸ್ ಲೀಸ್ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಎಲ್ಲಿ ಬರುತ್ತೆ? ವಾಪಸ್ ಕೊಡ್ಬೇಕು.
In the agreement also, they have mentioned
Anyway,
every month.
produce something.
They have mentioned another 15,000 per month.
List the matter on 30th.
Interim order may be extended.
List the matter on 29th. Sorry, 30th. Interim order subsisting will continue to the next date. Yes, next.
Obliged.
17.
I appear for the petition, Lordship, face for the time, Lordship.
Why?
Just 2 days back, I received the file and NOC Vakalat. And also I request the respondent to give a copy of the application because earlier council has not given the vacating application copy.
The issue is this, my lord. Arbitration award came to be part in my favor. I filed commercial execution to recover it. They said the commercial court is not having jurisdiction.
Execution ga.
ಹೌದು.
It has settled principle. ಆಮೇಲೆ
Lordship, and
ಅದಕ್ಕೆ
also
ಇನ್ನೊಂದು
just-
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಇನ್ನೊಂದು ಕಡೆ ಹೋಗೋದೆಲ್ಲ ಇಲ್ಲ, ಅಲ್ಲೇ ಎಕ್ಸಿಕ್ಯೂಷನ್.
No, the tender document clearly says the. courts of
Document
Mandya-
ಬಿಡಿ, if it is question of law, it is settled. Anything else?
No, one more issue is, I just come to know there is a
I
MFA.
myself felt that execution is permissible with the
There
same
is a
court.
MFA pending, your Lordship, and it is posted for hearing tomorrow, your Lordship.
Right? List on 23rd.
Much obliged. Lordship, I
It is
request
in the
the
same
respondent-
stage, it is made clear, no further adjournment would be granted in the matter.
I request the respondent to give a copy of the application.
Yes. Next.
18.
I pay for the petition. My lord,
Who has filed vacating stay?
vacating stay, my lord. The respondents have filed the vacating
Obviously
stay.
respondent. There is no representation of the respondent who has filed an application seeking vacation of the interim order. List the matter on 30th. Interim order subsisting will continue to the next date of hearing.
19.
Petitioner, my lord, has filed suit for partition against the brother and the mother, my lord. My lord, the
What is the application, sir?
application for impleading, my lord, has been filed by
Are
respondent.
you the
number
family member?
They are not the family member, my
Oh,
lord. They're-
you have filed.
Yes,
Ah.
they have filed, my lord.
Ah.
Therefore, my lord, this is.
Why
covered
not
by
the family
judgment.
member?
Your lordship, we are the
Purchaser of some properties.
Huh?
Purchasers of the some items of the.
Not the purchasers.
Yes, yes.
Then
They are not even
FDP na?
This is not the preliminary degree, partition.
Come in
my lord.
FDP. Sir.
Yes, that is the law laid down by this.
Yeah,
court.
that is settled principle.
Settled
One
principle.
submission, your lordship, there's already one
No,
more. No,
one minute. Property purchased after the institution of the suit, before institution.
Before institution. of the suit.
Before institution.
Your lordship, there's one more suit pending between the same parties, your lordship, wherein we are the respondents, and they themselves have filed the suit for injunction and declaration. They have filed the subsequent, that is of the year 2020. 22, they filed one more this present petition, your lordship, wherein we are not met party, and they file it as a partition suit. And now they want to compromise it.
Yes.
May I
In
make-
our absence, they are going to compromise and get a collusive decree. Dispose of
Yes,
the
sir.
property to that.
There are two items of property, my lord.
No, this is purchased prior to the
They are
institution.
not purchased. They claim that they have taken, my lord, advance amount from my brother
produced the
and
sale
mother.
deed, my lord.
There is no agreement. There is no agreement, my lord. They have filed a specific
All
performance suit.
documents you have produced, madam.
I have produced the sale deed before this court, your lordship.
One, my lord, two.
If it is purchased after the institution of the suit, they will come only in FDP, in a partition suit. If it is prior to the institution of the suit, they will come in the PD itself.
That is the point, my lord. They have not purchased.
That is
it.
the law, sir.
My lord, your lordship may kindly see.
That the court will decide.
I have purchased in
But they cannot-
2017, your lordship.
That the court will decide.
May I make one?
Yes.
There are two items, my lord.
Yes.
Two items of the property,
Yes.
which is purchased by my father, my lord. He died intestate. My lord, one suit, my lord, which they respondent number 3 and 5 claiming to be the Uti's property, my lord. They say that they have taken advance, my brother and mother has taken advance amount without there being any agreement, my lord. They have filed a specific performance suit. It is pending before. Another suit, my lord, which is there, my lord, pending before partition suit being filed, is they claim that, my lord, my father's vendor, they have purchased from my father's
Those
vendor.
are matters of evidence, sir.
That is exactly, but now I'm.
ಒಳಗ್ ಬಂದ್ರೆ ಏನ್ ತೊಂದ್ರೆ ಆಗುತ್ತೆ ನಿಮ್ಗೆ?
My lord, they are coming in the way of partition, my lord.
They will
My
not-
share. My lord,
He will not claim everybody's share. Who is their vendor? Our share matra.
that is exactly, my lord. Now in preliminary degree, they cannot, that is the law, my lord.
Kodis.
My lord, annexure H, my lord.
Kodis. Page.
My lord, the page 66.
Sir, that is the order of the court. Which is that law, Kodi?
My lord, this.
Trial court order ತೋರಿಸ್ಬಿಟ್ಟು law ಅಂತ ಇದ್ದೀರಾ
My lord,
ನಿಮ್ಗೆ?
66, my lord, I have annexed the.
Yes.
Page 63 is the judgment of this court. Ink page 66, para 3 onwards, my lord, the facts similar to my case facts, my lord.
Relying on that judgment.
The contention raised by the mortgages were also proper and necessary parties for the adjudication of the suit. Objections were filed by the proposed defendant containing they were neither proper or not necessary party to the adjudication of the suit. The trial court, after considering the contention urged, rejected the application in terms of the impugn order on the ground that the defendant too had not indicated how the proposed defendants.
Give your judgments.
My lord, one more judgment I
1
want.
minute. Ilva?
There are division bench judgment, my lord.
Then we will allow the petition. You can't come empty handed.
Trial court order, my lord.
ನೀವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್
Nine, my lord. They are relying on the 2012 AR SCW 4677.
My lord, this
Page number
para
58.
61 and 62, my lord. They can come in the final degree proceedings. my lord.
That is a law, sir. That's not right. But these are purchases prior to the suit.
No, they are not purchasing. It with this
Prior to the
purchaser, my
suit,
lord.
they have
It is a
sold
matter of
all the-
evidence. Whether they are purchases or not is a matter of evidence.
It
Their
is a-
entry itself, you are wanting to bar, then give me the law.
My lord, if it is a purchaser, my lord, yes, my lord, they claim that they are the agreement holder. They are not even an agreement holder. They filed some previous suit, my lord. I am not the party to that.
Your
I have a share in my property. My lord, I have a
No,
share.
partition between family members, generally strangers cannot be allowed.
Yes,
But
that is-
if one of those members of the family has sold a joint family property
Let them show, my lord.
prior to the institution of the suit,
Let
then,
them show, my lord.
Yes,
If
yes,
it is
not
sold, my
only
lord,
one
there's no
member,
question
my
of it
all the
filing a
three,
suit.
all the three parties, wife and two children of deceased, they have sold the property.
where is the sale deed?
Yes.
Your
Sale
Lordship,
deed
I
is
have produced the
produced, my
sale
lord.
deed in my statement of objection, Your Lordship. Page number 7.
R5, madam, you?
Yes, Your Lordship.
Which,
That's my sale deed of year 2017, Your Lordship. Prior
one
filing of.
moment, madam, one moment. ಯಾರು ಇವ್ರು ಮೂರು ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸಾ?
Your Lordship.
ಯಾರು?
mainly-
ಭರತನ್, ರಾಜಣ್ಣ, ಗಣೇಶ್.
No, they are vendors, Your Lordship.
ಹಾ.
Your Lordship, kindly see page number 29.
Hereinafter
Your
referred
Lordship.
to as purchaser is Ganesh.
Yes, Your Lordship. 2017, I have purchased the scheduled property, Your Lordship.
Ah.
Lordship, kindly see page number 29, Your Lordship.
May I clarify?
Wait.
Lordship, that's a suit filed by petitioner and respondent number 1 against respondent number 4 and 5, Your Lordship, in the year 2020, seeking declaration.
Page?
29 of my statement of.
Seeking what prayer?
Declaration and injunction, Your Lordship, wherein respondent number 4 and 5 are the party to the suit.
Declare the sale deed executed by first defendant
Yes, Your Lordship.
null and void.
Yes, Your Lord. That matter is still pending, Your Lordship, for the evidence stage.
6/12 what is the date of this sale deed?
2017, Your
ಅದೇ
Lordship.
date ಹೇಳಿ.
6/12/2017.
Who are the plaintiffs in this suit?
The earlier suit, plaintiff is.
ಅಲ್ಲ ಇದು ಡಿಕ್ಲರೇಷನ್ ಕೇಳಿದಾರಲ್ಲ plaintiff ಯಾರು?
Petitioner and respondent number 1. Petitioner Kiran S. Narang, Naveen Narang are the respondent number 1 and 2 to this writ petition.
Lordship, may kindly take that.
Yes, sir.
Page 7, my lord, which they have showing. That is the part, my lord, these Bharatan, my lord. My father has purchased this property in the year 2006, my lord. Now they are claiming that Bharatan, who is, my lord, the GPA holder of my father's vendor, they have purchased this property. And they have, my lord, filed an injunction suit. I have filed a declaration suit that is pending, my lord. That's the GPA, my lord, is a concocted GPA that FIR is filed, that all those things are there. My lord, now.
Anyway, you produce the judgments and other things. List the matter on 30th. Yes. In the same stage, interim order subsisting will continue to the next date of hearing.
Good.
20.
May please. For the petitioners.
Dispense with production. What's the matter?
Now, my lord, for clubbing of two suits, my lords, both the suits, my lords, with respect to the same subject matter, were ordered to be transferred to the same court by the Honorable District Judge, my lords, in exercise of powers of section 24, page 82.
No, this come for dispensation. For the reasons indicated in the affidavit accompanying the application and being satisfied with the same, the certified copy, production of certified copy of annexure F and G stands dispensed. List on Monday in preliminary hearing.
Please.
Next.
Great. Interim order, it's there.
Interim order ಇದೆಯಾ?
ಹೌದು.
Interim order subsisting will continue. Vacating stay ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ, my friend also.
Order is there or not, I don't precipitate the matter there.
Then we'll close it, undertaking to.
Can dispose of.
Monday itself, it's a very short matter. I believe we both of us will not engage the court beyond 15 minutes.
15 minutes.
15.
ಅದೇ 15 minutes. Yes, sir.
My only thing is both cases should be clubbed together. If my
We'll
friend
see,
has
yes,
no
yes.
objection,
Monday.
I'll take up.
Monday.
Grateful.
21.
IA2 setting aside. LRs of disease, 8 petition.
I have not been served with the application, my lord.
ನಾನೇ ಎಲ್ಲರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ.
ಅದು ನೀವೇ ಹಾಕಿದ್ಮೇಲೆ ನೀವು ಸರ್ವ್ ಮಾಡ್ಬೇಕಲ್ಲ, ನೀವೇ ಸರ್ವ್ ಮಾಡ್ಬೇಕು. Then ಆಯ್ತು.
I will verify and make submission.
ಇದನ್ನು ನೋಡ್ಬೇಕಾ?
Oh, because I don't.
List the matter.
Respondent number 8
List the
has
matter on
died.
30th.
Respondent number 8 LRs only have filed an application.
List the matter on 30th. Copy ಯಾಕೆ ಕೊಡ್ಲಿಲ್ಲ? 30th, yes.
Interim order.
Interim order subsisting will continue to the next
But in
day.
this case, my lord, before your lord, my lord, for
List the
continuation
mat-
of interim
30th,
order, my lord, I
yes.
have, my lord. he has
30th.
challenged the-
Have you filed vacating stay?
Yes,
ಎಲ್ಲಿದೆ?
it is there.
Where?
It's listed also.
Where is it listed, sir? Where is it listed?
I have filed, my lord, I have filed.
You have
it on
filed, but is it listed?
I'll have to check.
Yes, list on,
I have filed it.
list on 30th, registry to put up the application seeking vacation of the interim order said to have been filed on 4/7/2025. Next,
IO, my lord, IO.
IO extends.
Number 4 and 5 in this case, I filed the application for vacating the interim.
The connected matter may be called here. A agreement said to have been executed by father involving the minors. Based on that agreement, they filed a suit for specific performance, showing my father as a minor guardian. Court has not believed my father, appointed an advocate as a minor guardian. Advocate has filed return statement, thereafter conducted nothing. Literally, ex parte decree was obtained. Then filed the execution, again showing me as a minor, even though I am a major. Then I come to know that all this collusive decree. Then I filed an application under Order 9 Rule 13 to reopen that suit, narrating all these facts, violation of Order 32, Rule 15. Now, they have executed the sale deed in the execution. Now, I am residing therein, ordering for delivery of possession. That has been challenged and stayed by this Honorable Court.
Yes, we'll hear it.
My lord,
We'll hear it. Yes, please. List the matter on 30th. Interim order subsisting will continue to the next date of hearing.
on the application, but I'll argue that on the
Other
application.
stage. You argue on 30th.
23.
Yes.
Two applications has been filed, one for additional the documents and another for seeking for
private
amendment of
respondents.
the petition
I
as well
have
as
served
the
the
prior.
copy. I will file my objections to.
Eradukku madbeka. Counsel for
Maybe
the
taken up earlier.
respondent, Gopala Krishnamurthy appearing for so-and-so seeks 2 weeks time to file statement of objections to the applications. Objections, if any, be filed by the 31st. List on 31st. Interim order subsisting will continue.
24.
Here for the respondent.
Petitioner, my lord.
I filed this IA for vacating stay. My caveat has been overlooked. I have not been shown.
Parallel matter is.
A very short point for
I know.
lordship's consideration. my lord.
ಈಗ
12A.
counter claim ಯಾರ್ದು ನಿಮ್ದು?
Num-
Counter claim is an independent suit by itself. PIM ಆಗ್ಲೇಬೇಕು. 12A
That is
mandatory
by
over,
sub-
sir. Anything
that is by
else?
sub-
ಅಷ್ಟೇ.
I'm relying on 2 judgments, my lord. Now, my learned.
Judgment act,
It's
this is
choice
the
that-
order.
ಇಲ್ಲ. Only, lordship may only hear me for 2 minutes. But now, my lord, my learned friend has relied on a judgment of the Delhi High Court which says even the counter claim only has to be mandatory. Adad ನಂತರ 2024 Calcutta High Court as well as the Delhi High Court gave 2 judgments which say it is not mandatory. I'll only rely on that, my lord. Yeah, okay.
Short research.
ಇದರಲ್ಲಿ para lordship may kindly come to para 21, my lord, which is at page.
No, if it's an independent claim.
But ಇದರಲ್ಲಿ, my lord, they say the very purpose of the act.
Correct.
Now, my lord, the counter.
Same party is going again for mediation.
Yes, my lord, the PM has been initiated in the first instance, we have been there. That is a failure. Now, second, now, my lord, even in 12A, there is a procedure prescribed for the claim, but in the counter claim, there's nothing there like that. And these judgments, my lord, 2024 ಕೊಟ್ಟಿರೋದು.
We'll answer this.
The Calcutta High Court also says.
List on Friday.
Because it will have ramification across all the
That's why,
matters. my lord.
precisely why I said Friday.
Correct.
Yes.
Interim order subsisting.
Interim order subsisting will continue to the next date.
Please, correct.
Because it becomes applicable to every proceeding.
Every proceedings, my lord. And the purpose of the act is to speedy disposal.
There is no order of this court
No, please.
No,
on this?
illa.
On this point, illa.
Lordship has the order.
Yes.
And purpose is to ensure speedy disputes.
Correct. I have myself held in one thing. When the suit is returned to the commercial court
Yes, ma'am.
and PIM had been, not PIM stricto sensu, mediation had been instituted by the OS when it is OS. It need not be again instituted when the plaint is returned and to be presented before the commercial court.
But in the Calcutta High Court says there's a time limit fixed for filing the return statement now. Now, if you send him for 3 to 4 months for again PIM, again that purpose that will.
No, that is, see, that is why we'll have
dash,
to,
Calcutta High Court has observed.
we'll see. Yes.
Great. Interim order.
Interim order subsisting will continue. Day after tomorrow we'll answer it.
Please.
Or ashte adre I'll reserve it and answer it. Yes.
I'll only refer to 2 paragraphs. Otherwise, judgment.
Not trouble, my lord.
ನೋಡ್ತೀನಿ.
Please.
No, if you want to argue, Friday
argue.
ಮಾಡ್ತೀನಿ ಬಿಟ್ಟು ನನಗೂ ಜಾಸ್ತಿ ಆಯ್ತು. Yes.
Okay.
Rest on Friday.
Respondents have moved the application for vacating the stay.
The counsel for the respondent has filed an application seeking vacation of the interim order is not present. 30th. Interim order subsisting will continue to the next date. Next.
26.
Petitioner. They filed application seeking vacating the interim order.
I'm for respondent number 4 minutes.
ಆಮೇಲೆ
I filed an application for vacating the interim.
ಆಮೇಲೆ
Lots. I have secured an injunction against petitioner.
divergent finding.
Concurrent finding.
Concurrent,
Of both the courts.
And they
They
have
said
not,
that they already filed an injunction suit and the interim order is in their favor. We have challenged it by way of MEA, which is pending before the senior civil judge. Now it is question of only regarding the ingress and egress to my property is concerned. I am owning certain lands, but they are owning more than 40 acres.
Status quo ಇರ್ಲಿ ಬಿಡಿ.
Immediately, ಬೇಕಾದ್ರೆ direction may be given to dispose of the suit, I will cooperate.
ಅದು ಯಾವ ವರ್ಷದ ಸೂಟು?
ಒಂದು 2022, 22, ಇದು 24.
lots.
All suits are injunction suits.
Lots. I have secured injunction against them in 2021. And the interim order, what has been passed in the injunction order against them, there is a categorical for finding of the court that they need not pass through my property.
Let's see. 30th. I vote till then. Next.
27.
Posting.
With regard to that,
What is this IA for posting?
Lord, for consideration of the interim
IA
order,
for posting ಯಾಕೆ?
it was before the vacation court.
ಏನ್ ಮೆಮೊ ಮಾಡೋದು ತೊಗೊಳಲ್ವಾ? ಸುಮ್ಮನೆ IA
ಅಲ್ಲ, B group ಅಲ್ಲ ಹೊರಟೋಗಿತ್ತದು. It had gone to B group, so therefore to consider.
bring it back to life ಇದೆನಾ?
Consider the application. Now there is
What
an-
application?
For stay, now there is an interim order. This is the.
Already an interim order.
There is an
Then
interim
IA so and so stands rejected. Yes. Next.
Page 53. This is the amount.
You filed vacating stay.
No, illa, they have not-
Objections were filed, my lord.
All right. We'll hear it then. ಏನ್ joint development agreement ಇದನ್ನು?
ಇಲ್ಲ, my lord.
No, no,
This is, my lord, amount
execution
is deposited
proceedings.
in execution. My lord, they would advance the case and seek for release without serving us a copy, it is released.
I think that's most unfair, my lord. We have sent them an email. We have placed it in our statement of objections. If they did not want to appear, it's their mistake.
Lord, please see page 53. What they would send is only an advancement application.
Yes.
Application for withdrawal of the amount, they would not, my lord, serve it to us.
ಈಗ amount is already withdrawn?
Illa, not withdrawn. There is a stay, my lord.
My lord, I'm only concerned with the submission made across the bar. That's not correct. I'm filing a memo.
Which is that application?
Lord, application I don't have, my lord. Advancement application is served.
No, application for withdrawing the amount.
That is not served, my lord. Let them show, my lord.
Where is the order, sir? Where is the application? You filed your objections.
Yes, my lord.
Is that application part of the objections?
Yes.
Which?
My lord, application for withdrawal.
Not withdrawal, yes.
Yes, that's at annexure B to the writ petition.
B.
To the writ petition at
petition
page
itself.
31. 31. They have produced it.
Yes, I've taken a certified copy and produced. This is not served on me.
So please see my, where's the court copy? No?
ಏನ್ ಮೇಲ್ ಕಳ್ಸಿದ್ರಾ?
Mail ಅಲ್ಲಿ advancement ಕಳಿಸ್ತಾರೆ.
Where is the proof of service?
Only advancement application is sent by mail. I admit.
Anyway,
that.
where is the proof of service?
Also. Oh. Where's the application? No. No, where's the service, what the court is saying, the service of this application? Oh, you filed this on the same day. My lord, what I'm informed, my lord, is that the advancement
Anyway,
application.
I have stalled withdrawal.
Yes.
Let the application be considered before the court. After hearing the parties, let it pass out.
My lord, I'll submit this, my lord.
Like
There are
urgent, ಅದು
two
ತೊಗೊಳಕ್ಕೆ.
aspects. One is, they did not appear in the court on that date. So either the court can rehear the application.
That's what I'm
And
telling.
pass an order.
Yes, that's all.
Without going into the merits.
No, I'm not
Alternatively,
going into the merit at all.
alternatively, my lord, I have given them 17.5 crores.
No, that court will decide.
No, what I'm saying, my lord, the only issue is, even today, they have not filed any objection statement in the form of the writ petition to saying why that money should not be released to me. I'm saying at best, my lord, I'll have to give a bank guarantee as a security. Because the award is in my favor. Section 34 order is in my favor.
Oh, you are a judgment debtor.
Yes,
I have filed an appeal.
37.
there's no
Pending.
stay.
What has happened to that?
There's no
There is,
stay.
my lord, a direction saying both the parties you try for a settlement, neither party will.
That's all
precipitate.
right. Settlement does not mean stay of the,
Neither party. will
you suffered at 2 fora.
Yes, my lord.
Then what are you trying to tell here?
My lord,
I
here,
will
what-
direct the court to consider the application and here,
Yes.
yes. The petitioner,
Only, we both should tell, my lord, that in the appeal, which fell from the court, was whether we should try and negotiate a settlement.
ಈ ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ.
No, but the thing is, we had undertaken not to precipitate the matter till the next,
No, now there is already an order here.
yes,
Restraining you from withdrawal of the amount.
yes,
I will direct the court to consider the application in 2 weeks
yes.
and pass necessary orders
Grateful,
thereon.
my lord.
That's all.
Great, yes.
The petitioner judgment,
Only on this application.
only
because
on
they-
that,
Yes,
sir.
because they have filed.
You
other
have come only on that application. Yes. The petitioner, the judgment debtor is before this court calling in question an order of the concerned court dated, one nimisham. Dated 3/5/2025, by which the office was directed to release 17.5 crores in favor of the respondent on an interlocutory application in IA-5 filed under section 36 of the Act of the Arbitration Conciliation Act 1996. The learned counsel for the petitioner submits that the two applications were filed on the same day. One seeking withdrawal of the amount and one advancing the case. The application that was filed seeking withdrawal of the amount was not served on him. It was only the application seeking advancement of the case that was served. Therefore, he was not present at the time when the order was passed. The learned counsel for the respondent Ajesh Kumar would, however, dispute the position, contending that the applications were indeed served upon the petitioners, be those submissions as they are. The application as they are, in the light of the contention that the application was not served upon him and the absence of the petitioner on the said date, it becomes prima facie an ex parte order directing the release of the amount in favor of the decree holder. Though the decree holder. It is also a fact that is to be noticed that the petitioner judgment debtor has suffered orders before 2 fora.
No, but one fora I have succeeded.
Yavrali.
He is not
34 I have succeeded.
Succeeded. They have
Yeah.
come in appeal.
They have also come in appeal.
Lord,
I have also come in appeal.
we should
because
be
it's a
clear to my
partial-
lord,
It's a
there are
partial.
two parts to it. There are
Before
two parts
A
to it.
fora and has partially succeeded in the appellate fora filed under section 34, and both the judgment debtor and the decree holder are before the division bench of this court in an appeal filed under section 37 of the Act. The issue now is with regard to an application that is allowed directing release of 17.5 crores in favor of the decree holder. In the light of the aforesaid circumstance of a doubt with regard to the service of notice and the consequent absence of the petitioner, I deem it appropriate to direct the concerned court to hear the application seeking withdrawal of the amount, to consider the application seeking withdrawal of the amount after hearing both the parties.
I may be permitted to file objections because objections.
Both the parties in accordance with law. It is open to the petitioner to file his objections to the application. It is needless to observe that it is open to the petitioner to file his objections to the said application. The said application shall, after hearing both the parties, shall merit consideration and its conclusion within 4 weeks from the date of receipt of the copy of this order. Till such time, the interim order of restraint granted by this court shall continue. The further orders would be passed by the concerned court. The interim order would continue only till the disposal of the application, which is directed to be concluded within 4 weeks from today, from certified copy.
Lord, factually, that amount of 17.5 crores and the interest payable was upheld by the arbitral tribunal and by the first
Merits
court.
ಮೇಲೆ ಏನ್ ಬರ್ದೇ ಇಲ್ವಲ್ಲ?
No, I'm just saying, because
It is made clear that this court has not answered any claim on the merit of the matter, either of the petitioner or of the defendant. All contentions would remain open to be urged before the concerned court. Yes.
28.
For petitioner minutes, IA for dispensation, come up on IA for dispensation.
Allowed. List on Monday, interim order ಇದೆಯಾ?
Interim order ಇದೆ.
Vacating stay ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿಲ್ಲ.
Application is filed.
ಹಾಕಿದ್ದೀರಾ? ಎಲ್ಲಿದೆ?
ಹಾಕಿಲ್ಲ.
The petition respondent submits that application is filed seeking vacation of the interim order. The registry is directed to put up the said application, list the matter. ಎಲ್ಲಾಗಿದೆ? Register put up the application so filed seeking vacation of the interim order, list on 30th.
Copy also maybe served.
Interim order subsisting shall continue to the next date of hearing. Yes, next.
29.
I appear for the respondent number 2, my lord, in this. Only yesterday I filed my wakalatnama, as well as I may be permitted to file the detailed objections, as well as the vacating application also.
Objections,
But up to
however
vacating-
detail you want, you can.
Allah, please, because this is lordship's full bench judgment is also there in the file with respect to the conversion of the land.
Respondent number 1 and 3, my lord, do not been served with the entire copy.
Man, Mohan, what is all this?
I could, no difficulty. Should have gone with the notice, I'll serve again, no difficulty.
Yes, the petitioner, interim order ಇದೆಯಾ?
Yes.
But this is a matter wherein not
I have granted.
PTCL proceedings, my lord.
That's
They have
regarding
lost
only conversion, my
up to the Honorable Supreme Court.
Oh.
No,
After which, my lord,
That's a wrong submission, my lord, because the apex court has not gone to the matter. Only with respect to the limitation they passed and the dismiss the petty application. Not into the matter.
Note,
Please.
Application ಹಾಕಿದೆ, vacating stay ಇಲ್ಲ ಅಲ್ಲ?
ಇಲ್ಲ ಏನಿಲ್ಲ.
R2 ಗೆ ಯಾರು appear ಆಗ್ತಾರೆ?
None.
Learned counsel so and so undertakes to enter appearance. You already filed wakalat?
Yesterday.
Has entered appearance for the second respondent. Registry to print the name of so and so as appearing for the second respondent. List the matter on 30th. Interim order subsisting will continue to the next date of hearing.
Great.
Again on 30th, interlocutory applications on vacating stay will be at the top. Yes.
Very well.
Orders number 30.
Yes. Criminal petition. ಏನ್ letter ಮಾಡಿ?
Extension. Thank you.
This court had, by its order dated 4th November 2024, directed the concerned court to dispose the petition as the issue was of the year 2015. A communication is now sprung from the concerned court seeking extension of 2 more months though the reasons in the communication is hardly satisfactory. In the interest of justice, I deem it appropriate to grant 2 more months from today to conclude the proceedings as was directed. Any further communication for extension would be viewed seriously. Yes. Next.
31.
This is the matter, my lord, last date of hearing, lordship's order for the calling of LCRs. with respect
Correct,
to the
correct.
Private
Yes.
complaint.
ಬಂದಿದೆಯಾ ಮಾಡಿ? ಓ, ಇದು ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಒಂದು ಎನ್ಕ್ವೈರಿ ಆರ್ಡರ್ ಮಾಡಬೇಕು. ಅಲ್ಲಿ ಫೈಲ್ ಇಲ್ಲ ಅಂತ ಬಂದಿದೆ.
ಹೌದು ಮೇಡಮ್.
So one inquiry has to be ordered.
Yes, my lord.
We will,
Meanwhile, my lords, we are
we'll
ready
pass
on-
some orders. Yes.
Meanwhile, we are ready
Yes,
on merits.
administrative side ಮಾಡ್ತೀವಿ.
And meanwhile, we are ready on merits, my lord.
Huh?
Senior, we are ready on merits, my lord.
No, sir. First we will see where did the file go. Yes. We'll pass an order.
And we have a certificate copies up to the December, my lords. Even we have also applied the certificate copies before the concerned court. And they have also given similar
We'll
acknowledgement
see,
to
we'll
that
see.
also.
Don't worry. Yes. Next. Much more.
32.
Next week.
Yes.
List on 25th ಅಂತ ಮಾಡಿ.
32.
490 offense, parties have settled.
Settlement ಆ?
Yes, my lord.
ಆಗಿದೆಯಾ?
ಆಗಿದೆ sir. Mediation agreement ಕೂಡ draw ಆಗಿದೆ. Page number 16. Page number 16 is a
Learned counsel so and so submits that she has entered appearance for the respondent complainant. Where is the husband? The respondent complainant. Yes, we'll close it. Tejesh,
Please, my lord.
settlement ಅಲ್ಲಿ.
My lord, page number 16, my lord, Annex C. Mediation agreement, my lord. Relevant para is at page number 18, para number 7, my lord.
The marriage has been dissolved.
Dissolved.
And totally 16 lakhs is to be paid to her.
Chetan. Third.
My lord, 4 lakhs needs to be paid.
The learned counsel for the petitioner hands over ಎಷ್ಟು?
4 lakhs, my lord.
What is-
Remaining 4 lakhs have to be paid.
That is remain.
Remaining 4 lakhs ಎಷ್ಟು? 8 lakhs.
16 lakhs.
ಈಗ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
12 had been received and 4 lakhs.
Now 4 is now
received.
received. The learned counsel for the petitioner hands over a demand draft of rupees 4 lakhs. That was the remainder of the settlement of the amount of 16 lakhs. The same is acknowledged by the complainant who is present before the court and identified by the counsel for the complainant. ಅದೊಂದು ಹಾಕ್ಬಿಟ್ಟು ಆಮೇಲೆ yes.
Order sheet signature.
Signature ಬೇಕು ಎಲ್ಲಿ?
33.
Rectification of office
Let's,
objections, early hearing.
Small mistake.
2021 early hearing ಯಾರು ಹಾಕಿರೋದು?
ನಾನು ಹಾಕಿರೋದು.
Admit ಆಗಿದೆಯಾ? Early hearing
notice
stands
has-
rejected, list the matter on 23rd in preliminary hearing.
Settled.
Settled.
Settled before the trial
Sir,
court,
ಕೊಡಿ.
my lord. Because of the
ಕೊಡಿ. We'll
pendency.
dispose this suit. The
please.
learned counsel, ಬರ್ಕೊಳ್ಳಿ. Learned counsel appearing for the parties would submit that the matter has been settled out of court.
My lord, it is settled, but we have to report in the trial court.
Sorry.
In view of the,
Is settled between the parties and the parties are wanting to report it before the concerned court. The only impediment that the parties are now facing is the pendency of the subject petition and subsistence of the interim order. In the light of the settlement arrived at between the parties and the only issue of it being placed before the concerned court, I deem it appropriate to dispose the petition with a direction to the concerned court to consider to pass appropriate orders on the settlement being placed before it.
So far,
before that, my lord, this impleading order has to go, my lord.
Which impleading?
This,
In the light of the said settlement arrived at between the parties,
They are not the family.
arrived at between the parties and the arrived at between the parties, the application, so the impugned order as a matter of form stands quashed.
Please.
So far as the impleading applicants liberty may be.
ಏನ್ ಲಿಬರ್ಟಿ ಸರ್?
ನಾನು ಇಂಪ್ಲೀಡ್ ಆಗಿದೆ ಸುಮ್ಮನೆ
ಎಲ್ಲಾಗಿದ್ದೀರಾ?
ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಅಲ್ಲಿ ದಟ್ they have been challenged.
ನೀವ್ ಯಾರು? ಅವ್ರು ಯಾರು?
Impleading applicants
They are
where they
impleading
ಯಾರು?
he claimed that we are the owner of the scheduled property.
ಅದು ಬನ್ನಿ, FDP ಬನ್ನಿ. Yes. Next.
Present, the respondent who.
Rectification office objections.
ಅಪ್ಲಿಕೇಶನ್ ಇವರು ಆಮೇಲೆ NOC ಹಾಕಿ ಬಂದಿದ್ರು, ಅದರಿಂದ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ, ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಐ ಹ್ಯಾವ್ ಆಲ್ರೆಡಿ
ಕಾಪಿ ಬೇಕಾ?
ಅಲ್ಲ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾಗತ್ತೆ ಎಲ್ಲಾರ.
ಇಲ್ಲ, ಅವ್ರಿಗೆ ಅಲ್ಲಿ ಸರ್ವ್ ಮಾಡಿದ್ದೇನೆ ಸ್ವಾಮಿ ಅದು.
ಆಯ್ತು ಸರಿ, ಕಾಪಿ ಕೊಡಿ. Counsel for the petitioner shall serve the copies of the applications upon the counsel for the respondent. 30th. Yes.
ಸ್ವಾಮಿ ಅದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಫೈನಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ 29th ಇದೆ. ಸೊ
29th.
It is on
28th. List
with regard to DNA test.
20. ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ ಸ್ವಾಮಿ.
DNA test, he filed
Partition
application for
suit
DNA.
ಅಲ್ಲಿ-
In a suit for partition, he cannot, because my lord, we have filed, number of documents so that we are the brothers.
ಯಾರು DNA ಟೆಸ್ಟ್ ಕೇಳಿರೋದು?
ಇವ್ರು ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಡಿಫೆಂಡೆಂಟ್. ನಾನು
Defendant ಕೇಳ್ತಾ ಇದ್ದೇನೆ. He has said no objection, but the trial court says that even though the plaintiff says that he has no objection, still I will not permit.
Even I will not permit.
No, because there is.
Even I will not permit.
My lord, the reason is this, the dispute is with regard to paternity, my lord.
All right.
DNA
We'll
test
see
between.
on 28th.
8th.
Get ready with judgments.
Yes, it is, I have a judgment. I have a
Next.
Case. Petitioner, please.
petition become infractious, my lords, in view of the disposal of FDP, my lords.
Suit dispose ಆಗಿದೆಯಾ?
FDP, I have in this FDP, please lordship.
FD ಏನ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದೀರಾ?
And ನಾನು passing the order by the R2A, I am.
ಯಾವ್ದ್ರಲ್ಲಿ?
FDP court, please.
FDP ಇದೆಯಾ ಇವತ್ತು?
ಅಲ್ಲ,
ಇದೆಯಾ ಇಲ್ವಾ?
ಇವತ್ತಿಗಿಲ್ಲ. ಅಲ್ಲಲ್ಲ, my humble submission. ಅಲ್ಲಲ್ಲ, my humble submission, your honor. The
You
accepted.
avail any remedy available in law. CPC is not maintainable.
Allala, my humble submission, your honor, in the 1/3 share was allotted and.
Challenge ಮಾಡಿ sir. Challenge ಮಾಡಿ. The petitioner is before this court calling in question an order passed on an application in FDP 9 of 2020. The learned counsel for the respondent submits that by an order dated 7th June 2024, the final decree proceedings is closed. In the light of the closure, the present petition, which calls in question an application in the said FDP, which has now stood closed.
Allala, my humble submission, your honor, the allotment share with regard to will is concerned. They have upheld the will, and on the basis of uphold before this honorable court. Subsequently, the upholding the will, your honor, my share was deprived. I am the wife of the second respondent.
What should you do now? Challenge it, sir. Yes. Leaving open the remedy available to the petitioner in law, the petition stands disposed. Yes, next.
36.
For respond number 1 and 2, my lord. Plaintiff before the trial court.
36, sir.
Yes, my lord.
Again, unserved Shara, so and so, unserved returned postal.
They are the defendants before the trial court.
Show all the respondents who have not claimed or refused as served and their names printed in the cause list.
I have filed the application.
Vacating stay idea?
Yes, my lord.
List the matter on 30th under the caption interlocutory applications. Yes, next.
37.
I appear for the first and second respondents. My lords, the matter is settled before.
Is settled,
Yes, settled before the mediator.
The parties to the list were referred to mediation, and the report of mediation is placed before the court, which depicts that the parties have settled the dispute amongst themselves by drawing up certain terms of settlement. The said terms read as follows. Flag hakidini, more page. In the light of the settlement arrived at between the parties on the aforesaid conditions, both the parties would submit that the
Suit for eviction.
The suit be decreed in terms of the settlement, and the decree be directed to be drawn by the court. In the light of the settlement arrived at between the parties, the suit is decreed in the terms of the compromise. Yes. Next.
38.
I'm taking of steps.
Steps to be taken to respond number 10, 11, 12 and.
Third time, we'll vacate the interim order. You're not taking
Take, my
steps.
lord, during the course of the day, my lord.
May I
Today
make
itself
one,
I'll take.
may I make one submission, Mother? All the respondent number 10, 11, 12 and decision respond number 6 is no way concerned to this petition, Mother. Because.
I'll file necessary.
ಈಗಲೇ memo
ಈಗ ಯಾಕೆ?
ಈಗಲೇ
ಈಗ.
service of notice to
Moreover, may I make one submission? Already FDP proceedings, commissioner has completed the work, Mother, and he has submitted the report, Mother. In view of the interim order, Mother, the trial court has adjourned the matter, Mother.
I will see. Service of notice to 10, 11 and 12 is sought to be dispensed by the petitioner. The memo is accepted at the risk of the petitioner. List the matter on 20.
And also decision respond number 6 also, Mother.
List the matter on 23rd. Yes.
R6 or he has not required necessary, Mother.
Even R6 one. Deceased.
And of all the vacating application is.
ಅದಕ್ಕೆ 23. Yes. Next.
Please.
59.
I am for.
Lords,
My lords, I am filing the memo.
Oh.
Yes, sir.
Yes, sir.
There's some.
Lords,
ಇದರಲ್ಲಿ last time party ಬಂದು.
No, ಇಲ್ಲೇ ಇದ್ದಾರೆ ಹಿಂದೆ. Lords, the,
So I may be permitted a week's time. my lord.
ಯಾರು ನೀವು ಸಂತೋಷ?
Yes, yes, my lord.
ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೋ ಹಾಕಿ ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನು?
Lords, the defendant who was granted with the occupancy rights by the land tribunal sells the land in the year 2003. Lords, after that, a suit for declaration and possession is filed in 2021. Then that suit is withdrawn with liberty to file a fresh suit on the same cause of action. I have filed a suit for injunction in which an ex parte injunction was granted. When the application came up for consideration, an undertaking was given before the court that I will not interfere with the possession of the property. Lords, then the issues are framed in my suit and the matter is posted for trial. At that stage, they file a counterclaim seeking injunction. Earlier suit is for declaration portion.
We'll hear it on 30th. List the matter on 30th. Yes.
Interim order may kindly be.
Interim order subsisting will continue to the next date of hearing.
40. So far as the respondent number 2 is concerned, my lord, contesting respondent is the first respondent. And the
For the respondent in this.
Third time to take note. Who is second respondent?
second respondent, defendant number 2 before trial court. But applications which are impugned and on the basis of which the order is passed is by the first respondent. And I've
Emma.
please,
Illi.
I've also taken out, my lord, on 21/2/2025.
Suit for?
Suit for
Suit is
partition,
one for partition,
2015,
my
my
lord.
lord.
Parallel. What is under challenge?
Lord, recall and reopen application filed by the defendant number 1 under order 18 rule 17 and section 151 of CPC. Lord, the stage in which these applications are filed after plaintiff has addressed, I am the plaintiff before the trial court, my lord, my suit for partition. After the arguments have commenced, defendants also address their arguments. At the stage of reply arguments, my lord, after I've seriously taken up a contention and argued that the gift deed which the defendants are relying upon is not proved, they come up with his application to examine witnesses to the gift deed. And 2022 itself, my lord, evidence of the defendant, they themselves have undertaken no further evidence. And 2 years they keep quiet. I argue the matter.
List on 30th. A memo hakiyad. Counsel for the petitioner files a memo seeking dispensation of issuance of notice to the second respondent as the issue, the second defendant, the second respondent is not a necessary party. At the risk of the petitioner, notice is dispensed with. List on 30th under the caption interlocutory applications. Yes. IO continued. Interim order continues. Furnishing FPF third time R2 R.
Kindly be dispensed with. He's also one of
Second
the.
respondent is not a contesting party, only the first.
Same order. Previous model, same order. List on 30th. Interim order subsisting will continue to the next date.
Meanwhile, my lord, they've deposited 5 lakh rupees permission to withdraw the amount.
Deposit
The decree holder, decree was passed in the year 2018.
First occasion, your lordship, it seems that they have to file an application that they have.
Application ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ, vacating stay ಹಾಕಿದೀವಿ.
ಅದು withdraw ಮಾಡಕ್ಕೆ ಒಂದು ಹಾಕ್ಬಿಡಿ, ಆನ್ಸರ್ ಮಾಡೋಣ. Yes, 30th.
For the petition, my lord.
Memo for having served hand summons. Served?
It has been served.
Interim order ಇದೆಯಾ?
Interim order ಇದೆ.
ನೀವು ಯಾರಿಗೆ?
First respondent contesting.
ಬೇರೆಯವರಿಗೆ? ಕಂಟೆಸ್ಟಿಂಗ್ ನೀವು ಮಾತ್ರನಾ?
Yes,
ಮೆಮೋ ಹಾಕಿ.
yes, I'll file.
Dispensation
Dispens ಆಗಿದೆಯಾ?
All other have been served, my lord. Hand summons was also served to them.
Serve all of them are
Everybody is
served.
served.
Acknowledgement ಹಾಕಿದ್ರೆ ಆಗಿರೋದು. Counsel for the petitioner submits, the cause list indicates that all the unserved respondents have already been served. Therefore, filing of an acknowledgement would not be required. List the matter on 30th under the caption interlocutory application. Vacating stay ಹಾಕಿದಿರಲ್ಲ?
Status quo.
30th, yes.
Good.
Interim order subsisting will continue.
The status quo continue.
Whatever order.
Yes.
Yes, next.
43.
I'm offering for petitioner for R2 and R3.
Non-rectification office of IA1 ಏನು? What is IA1?
Vacating stay ಹಾಕಿದಾರೆ ಮೇಲೆ IA1.
Counsel for the petition respondent is granted a week's time to comply with the office objections qua IA1 of 2025.
My lord, interim order.
In the event the stand complied, list the matter on 30th.
My lord, interim order.
ಅದು ನೀವು ಕೇಳಿದ್ರೆ ಅಂತ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾ ಇಲ್ಲ.
Please.
IO, yes, next.
Lord's kind permission. Lord's,
Rectification of office objections,
My
what is
lords,
this?
The office objection was service of the application on the other side.
You
It
have
was
not
sent-
served.
It was sent by
Learned
email and
counsel
has been
submit,
acknowledged.
Bandidya. Counsel for the petitioner Abhilash Raju submits that the copy has been served, which is the only office objection. Yes, urgency, idea.
My lords, the urgency is only that the commercial suit is set down to final arguments. My lord,
When?
it was there today.
Next date.
It was there today and we've told the court that the matter is set down before the High Court today.
What drives you here?
My lords, it's the production of documents. My lords, an application filed under Order 11, Rule 5. My lords, I must say this candidly. I had originally filed that application, which was dismissed. Later, during the cross-examination, there were some admissions made by the witness, my lords, which provoked me to first issue a notice in accordance with Order 11, Rule 5 of the Commercial Court, the amended CPC order of the Commercial Court.
Yes.
It was denied by the other side, but they have custody of the document. That was never denied. They have custody of the documents, my lords, but the IA was again dismissed, saying that it was earlier filed.
We'll take it on Monday.
Please, my lords, I would request that.
List on Monday.
That's my request, ma'am. Trial court has said, depending on the date fixed, that will be adjourned. That's what I was informed.
List on Monday, the concerned
My
court.
request, ma'am, Monday, Tuesday, out of station, then
List the
some
matter.
other date.
One nimsha, Kumar sir. List the matter on 23rd. In preliminary hearing, the concerned court shall defer its proceedings till the next date of hearing.
Great. Obligation. Readings are complete. I've heard objections
I-
also.
ಅಷ್ಟೇ
Milord, apologies, Milord, 43.
ಆಗೋಗಿದೆ ಮೇಡಮ್.
Milord, please, ತುಂಬಾ ಕಷ್ಟಪಟ್ಟು ಅದು ಲಿಸ್ಟ್ ಆಗಿದೆ. Please, Milord.
ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ಮೇಡಮ್?
Milord, please.
ಎಸ್
Our petitioner.
30th ಹಾಕಿದ್ದೀನಿ, ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಎಸ್. Next.
For the petitioner, my lords, I may be permitted to serve on the counsel appearing for the respondents in the trial court, my lords.
The learned counsel of the petitioner is permitted to serve on the counsel representing the respondent before the concerned court.
Date may
And
be
file
fixed,
an
my lords.
acknowledgement of such service. List the matter on 6th August.
Shorter date was a short question, my lords.
Intermod idea.
Yes, sir.
Intermod subsisting would continue till the next date of.
The short date, my lord, may be taken up on 30th, my lords. Obliged.
Next.
46?
Present the petition in the matter, my lords.
R2, R3 ಯಾರು?
Hand summons may take it, my lords. Our ಒಂದೇ family, my lords, the cost.
ನೀವೇ ತಗೊಂತೀರಾ? ಕೇಳಿ ಕನ್ಸಲ್ಟ್ ಮಾಡಿ kind next week will. ಆಯ್ತು ಸರಿ.
Next week.
Counsel for the petitioner is permitted to take out hand summons upon respondents 2 and 3. List the matter on.
Interim order to be extended.
ಅದು ಗೊತ್ತು. Give it, yes. List the matter on 6th August. 6th. Interim order subsisting will continue to the next date.
Great.
47, post immediately after service of
Lordship,
notice
on
upon the.
9/6, they have filed a memo for dispensation for R3. Your lordships may kindly.
ಹೌದಾ?
ಹೌದು ಸ್ವಾಮಿ, memo ಹಾಕಿದ್ದಾರೆ.
Counsel for the petitioner is said to have filed a memo seeking
Counsel for the
dispensation.
petitioner has not filed the memo, my lord.
There is an order to that effect. They have also filed it. There is a direction to, please, your lordship.
Page madam.
9/6, please, your lordship.
Order ಆಗಿದೆಯಾ?
9/6/2025.
Kindly see the, my lord, the dispensation
madam.
application has been filed by the respondent, my lord. How it is possible?
Petitioner files a memo seeking dispensation of service of
No, I
notice
have
upon
not
respondent
filed. I
number
have
3.
not filed, my
As
lord.
no relief is sought against respondent number 3.
My lord, I have not filed.
ಅವ್ರ ಕಲ್ಲಿಗೆ ಬಂದಿದ್ರು ಸ್ವಾಮಿ, ಹಾಕಿದ್ದಾರೆ.
ಇಲ್ಲ ಹಾಕಿಲ್ಲ, ಯಾರು ಹಾಕಿಲ್ಲ.
ಎಲ್ಲಿ ಮೆಮೋ ಎಲ್ಲಿ? ಈಗ R3 ಯಾರು?
R3, no relief has
R3
been
is
sought
one of
against
the
her.
joint family member.
Who is R3?
R3 is a
R3
daughter.
is one of the joint family member, sister
What
of
is the suit? What is the suit for?
Suit is for partition and separate possession.
What is the order challenged?
The order challenged is application filed under Order 11, Rule 14 of CPC. The documents which are in possession of the defendants 1 and 2 are sought to be produced by the, under the application.
You are the plaintiff.
I am the plaintiff. Kindly
You
see,
can't,
my
you
lord, the
can't
gift
force
is
production of a document. Yes. Anything else?
My lord, kindly see the documents, my lord, they don't deny that the documents are in their possession.
Where?
The documents are in their possession, my lord.
Where
Kindly
do
see
they, where do they admit that the documents are in their possession?
Huh. Yes, your lordships may kindly take, my lord, page 72 of the gift deed.
Documents are in a possession?
Lordships may kindly appreciate. Here, the document which they are
kindly
speaking is the will. And that will is a registered will. Subsequently, the
kindly
said
take-
registered will has also been cancelled by
Oh,
me.
that's that matter,
Yes, please,
cancel.
your lordship.
Yes, yes.
And I am the defendant number one, the respondent number one before your lordship is the sole and absolute owner of the property. And this defendant number two, the respondent two is the daughter. Now they are filed an application for a direction to produce the documents, which has already been cancelled, which I am not in possession. Page number 33, if your lordships may have to kindly
My lord,
appreciate.
your lordships
They
may kindly
themselves have
see,
That
they
is
cannot
what
say
is
that
challenged.
They are not
Yeah,
in their
they have-
possession.
They themselves have stated that there is a criminal case registered by the mother and the daughter against the
ಈಗ
son.
R3 ಏನಾರು ರಿಲೀಫ್ ಕೇಳಿದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
R3
Application
is
is
one
the
of the
other
joint
one.
family member. My lord, now your lordships may kindly take.
Then I will vacate the interim order and await service for R3.
Why, my lord,
Anything else?
your lordships may kindly see, there
I
was
will
no
vacate the
question of
interim order,
vacating
will
the
await
interim
service
order.
of R3.
My lord, your lord, what is the
Post
reason to
immediately
vacate the
after
interim
service of
order, my lord?
notice
Your
upon the
lordships
third
may kindly
respondent.
hear
Yes,
me.
next.
My lord, kindly hear me. My lord, why other, my lord, your
Memo
lordships may
ಹಾಕ್ಬಿಟ್ಟು
kindly see.
petitioner sir dispensation ಗೆ now you are denying it.
My lord, your lordships may kindly see, I have
Where is
not
the memo?
filed. I
Memo
will
ಇದೆ ನೋಡಿ.
file an affidavit. My lord, kindly take that copy of that dispensation application.
ಹಾಕಿದ್ರು.
ನಾವು
ಇದೆ ನೋಡಿ.
ಹಾಕೇ ಇಲ್ಲ, ಯಾರು ಹಾಕಿಲ್ಲ, because your lordship may hold the inquiry with that. Because
Yes.
unless, my lord, we file an
List
application,
on,
thereafter we
list
have
on,
filed the
1
process.
minute madam. List on Friday in preliminary hearing.
Grateful,
Yes,
your
next.
lordship.
Interim order subsisting will continue till the next date of hearing. Yes, next.
It's 48, my lords, the copy is already served. Acknowledgement will be filed, my lords. The advocate who's on record, he's a government advocate, my lords. I'll undertake to file my wakalat. There is an interim order, my lords, it may be extended.
ಯಾರಿಗೆ sir? R1 and R2 ಯಾರು?
Their husband and wife, my lords, represented by the same council. Already served, my lords, but they've not yet appeared.
ಸರ್ವ್ ಆಗಿದೆ ಅಂತ ಎಲ್ಲಿದೆ?
Acknowledgement ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಇದೆ. I'll have the
Acknowledgement
acknowledgement
ಅಲ್ಲ,
also.
awaiting service of notice to R1 and R2 ಅಂತಿದೆ.
First office note says that we've not filed the
Appearing
acknowledgement.
before trial court.
Trial court. We've already served, but he's not appearing.
The learned counsel for the petitioner submits that acknowledgement haki. The counsel and for the appearing for the respondents 2 and 3 before the 1 and 2 before the trial court have already been served. A acknowledgement to that effect be filed or put up the matter immediately after service of notice upon respondent 1 and 2. Yes.
My request was
Interim order
28th,
subsisting will continue till the next date of hearing.
it's 28th, my lords, because they've already served. They only have to appear. I'll file that acknowledgement, my lords.
ಮಾಡಿ.
28th date ಆಗ್ಬೋದಾ ಅಂತ.
ಅದು ಲಾಸ್ಟ್ ತೆಗೆದುಬಿಡಿ, awaiting appearance ತೆಗೆದುಬಿಡಿ. ತೆಗೆದುಬಿಟ್ಟು ಲಿಸ್ಟ್ ಆನ್ 28th.
Grateful.
ಎಸ್
49.
ಸ್ಟೇ ಇದೆಯಲ್ಲ, ಮತ್ತೆ ಯಾಕೆ ಅರ್ಜೆನ್ಸಿ? ಲಿಸ್ಟ್ ಆನ್ 6th August. ಎಸ್
The application, my lords, is one for impounding.
6th August. ಎಸ್
His evidence has been stalled, so it has to be disposed of.
ವಿಲ್ ಸಿ. ಎಸ್ ವಿಲ್ ಲಿಸ್ಟ್ ಆನ್ 6th August. ಬರ್ಲಿ ಅವ್ರು.
My lord, petitioner, my lord.
I pay for
I seek
respondent
for a
number 8.
passover, my lord. They filed an application for vacating.
ಫಸ್ಟ್ ಇದೆಲ್ಲ ಏನ್ ಹೇಳಿ ಸರ್?
They are the co-owners of the property, all the respondents, my lord.
The contesting,
not
Respondent number
necessary.
8 is the
contesting
contesting respondent.
I'll delete, my lord. the rest of it.
ಮೆಮೋ ಹಾಕಿ.
Please, my lord.
ಮೆಮೋ ಬಂದ್ಮೇಲೆ ಮಾತ್ರ ಆರ್ಡರ್ ಮಾಡಿ ಅದು.
Please,
ಇಲ್ಲಾಂದ್ರೆ ನಾಳೆ ಮೆಮೋ ಹಾಕಿಲ್ಲ ಅಂತಾರೆ. ಎಸ್
Where they sought for.
ಫೈಲ್
injunction.
ಮೆಮೋ.
Please, I'll have it filed. May I seek for a passover, my lord? There is an.
ಫೈಲ್ ವೆಕೆಟಿಂಗ್ ಸ್ಟೇ ಇದೆ.
Please.
I had been filed the
What's the
application.
matter?
Right, they had filed a suit for injunction based on the term sheet. Where the term sheet, the amount which had been taken to be completed within 180 days. I had repaid the entire amount. I had produced the bank statement also. And there is no contract in.
We'll see. ಫೈಲ್ ಮೆಮೋ.
I'll file a memo, my lord.
ಮೆಮೋ ಕೈಗೆ ಬಂದ್ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡಿ, ಅಲ್ಲಿ ವರ್ಕ್ ಮಾಡಬೇಡಿ. At the risk of petitioner. Next.
Interim orders.
Interim orders, list on 30th, interim order subsisting will continue to.
Some of the respondents are on the bedridden.
On 30th will dispose it. Nimden housing.
Please, my lord.
Why are you troubling them?
My lord, it's a land, my lord. There's a term sheet entered into with him. There was a
But there is-
confidentiality clause which has been breached. So that is the dispute.
There is no contract itself is not there existing.
Next.
Grateful.
Disposal filed by so and so vacating stays.
For the petitioner's counsel.
disposal, my lord.
ಯಾವ್ದು ಮೇಡಮ್ ಇದು?
Sub-
ಆ ಮ್ಯಾಟ್ರ?
ಇಲ್ಲ, ಅದಲ್ಲ. This is fairly new, young, not Jurassic era.
ಹಾ.
There is a violation of
Suit
the
for-
interim order, my lord.
But suit for
interim order
injunction.
ಇದೆಯಾ?
Interim order. is
Vacating
not-
ಯಾರು ಹಾಕಿದ್ದಾರೆ?
We have filed vacating stay and
So what is this disposal filed by ours? ನಿಮ್ದೇನಾ?
please, my lord, they have violated the interim order and they're constructing day and night, my lord. They disposes to me and
Day
constructing
and
the.
night.
Lord, interim order was not to interfere with the position of the petitioners.
What is suit
It was
for?
Suit for bare injunction. I mean,
I was in
Injunction
possession, I
granted?
was.
injunction, your lordships have granted the.
Oh,
interim
there it was
injunction.
not considered?
There it was not. You only emergent notice was issued during vacation. So writ petition was filed. Your lordships after
Oh,
hearing.
my
my lord,
order, yes.
Please, your lordships granted 2 orders not to alienate and not to interfere with the possession.
Yes.
Their now concern, my lord, is that I have started construction in the property. If your lordship may kindly look at Annexure Z, which was a photograph at the time of filing the petition, I had filed.
Page?
Page number, my lord, 310, my lord. Color
Construction,
photographs which have been filed.
construction ಆಗೋಗಿದ್ಯಾ?
ಇಲ್ಲ ಇದನ್ನ ಇವರು ನಮ್ಗೆ they were interfering with our possession. That is why we had taken these photographs. This is how they had interfered. If your lordship may kindly look at the photographs, even the fence which was put up, those sheets have been removed by them. That is what now I am not.
Is it vacant land?
Vacant land. With one shed which was there.
But
Shed
out-
is also visible in the photograph. which I
Result
have.
of a partition suit, is it?
Please.
ನೀವು ಯಾರು family member?
No, my lord, I'm also appearing for the, one of the vendor and also purchaser, my lord.
When did you purchase?
I purchased in the year dated 23/4 to.
After
25,
the
my
suit?
After the suit. After the suit and there's a AC order, DC order. Now we are directed to go before the
Subsequently,
DC.
this suit is filed, my
Also,
lord,
madam,
wherein
the
the.
sale deed, if your lordship may kindly look at, it is a Annexure B, Annexure B, which is a sale deed which the my learned friend's client has purchased. It is property is in Kundalhalli, the ITPL main road. 59,000 is the value per square feet. They purchase it for 1 crore. Entire 8,000 square feet of 8,700 square feet of land is purchased for 1 crore.
Who sold it?
My paternal uncle's
So what can
legal
be
heirs.
done? What can be done?
No, our case is they did not have the authority to sell. And there is a decree already in my favor, that which is now a subject matter of a writ appeal. There was a writ petition filed. Writ petition, we have been directed to go before the DC, Deputy Commissioner, and urge our grounds. That is under the
We'll hear it.
judgment.
The memo for disposal stands rejected. IA for production, IA for dispensation, so and so allowed. List the matter on 30th under the caption vacating interim order.
Obliged.
My lord, till then, my lord, let them not put up construction, my lord, let them maintain a status quo.
ಇನ್ನೊಂದು ವಾರ, yes.
Please.
Next.
Kindly, my lord, status quo may be maintained, my lord, they have.
We'll see, yes.
And
It
also
construction
now-
complete ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Very temporary construction.
Now all the parties are present, my lord, it may be directed to the trial court to consider the IA itself, my lord, it may be disposed of with the direction to
Oh, it
consider.
was an ex parte rejection.
Please, my
Then
lord.
I'll direct you
It
to
can be
consider it. Could you-
directed to the.
Yes, yes.
My lord.
The petitioner is
Only
before.
observation, my lord, they should
No, no.
not take in
That I will
advantage of
direct the
the.
court to consider. madam.
Please.
The petitioner
One
is,
submission, my lord, the only humble submission is that, my lord, in subsequent to the interim order, they taken possession.
let the
My lord,
court,
that's-
let the court consider
As on
everything.
the
madam.
date of the filing of the suit, who is
That
in
court
possession has
will
to be
consider,
considered,
madam.
my lord,
Yes.
because.
The petitioner, the plaintiff in OS so and so is before this court, calling in question an order of the concerned court dated so and so, which declines to grant temporary injunction answering an application under order 39 rule 1 of the CPC.
There are 2 applications,
In
2 and IA3. Emergent notice.
2 applications. This court, in order to protect the interests of the petitioner, had granted an interim order which reads as follows. Counsel for the respondent has now entered appearance. Since the matter is at large before the concerned court, I deem it appropriate to dispose the petition with a direction to the concerned court to hear both the parties and consider the application under order 39 rule 1, 2 and the other application so filed by the petitioners on its merit. In the light of the interim order subsisting today, I deem it appropriate to continue the same for a period of 3 weeks and direct the concerned court to conclude the proceedings for 2 weeks and direct the concerned court to answer the application within 2 weeks from today. All contentions of both the parties shall remain open. It is needless to observe that the concerned court will answer the application in accordance with law after considering the submissions of both the parties. Ordered accordingly.
Status quo, my lord, because they're putting up.
Already there, madam. Yes, next.
51.
For respondent number one, my lord.
Undertake to file
This
wakalat for respondent.
preliminary issue in regard to the court fees concerned framed by the trial court. That is impugned order in the petition, my lord.
50?
51, I for respondent number one, or the plaintiff in the trial court.
PF ಯಾವ್ದು ಸರ್? R2 to R6?
I appear, I may be permitted to appear for the plea.
ಯಾರಿಗೆ?
Those people, this is an issue relating to framing of a court fee, and at my instance,
All right.
the notice to other defendants may kindly be dispensed with. Their advocates have already been served.
Memo.
Memo, I just will file it notes in the course.
ವಕಾಲತ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಆಗಿದ್ದಾರೆ ಆಲ್ರೆಡಿ.
Advocates ಆಗಲೇ serve ಆಗಿದೆ.
ಮೆಮೋ ಹಾಕಿ. Yes.
Serve ಆಗಿದೆ, it's already, we have served it.
Undertake to file wakalat for respondent number two, my lord.
Learned counsel so and so undertakes to enter appearance for respondent number 2 ಮಾತ್ರನಾ?
Two, my lord.
Registry to
filed
print,
wakalat.
registry to print the name of so and so as appearing for the second respondent.
Respondent number one filed wakalat.
One ನೀವು ಹಾಕಿ ನಿಮ್ಮ ಹೆಸರಿದೆ ಆಲ್ರೆಡಿ. ಎಸ್.
Notice to other respondents may kindly be dispensed.
ಮೆಮೋ ಕೊಡಿ.
I'll just will file
ಮೆಮೋ
it.
ಹಾಕದ್ಮೇಲೆ ಅದು ಮೆಮೋ
May kindly.
ಹಾಕದ್ಮೇಲೆ ಅದನ್ನ ಡಿಸ್ಪೆನ್ಸ್ ವಿತ್ ಅಂತ
May
ಮಾಡಿ.
kindly.
ಎಸ್.
Interim order may kindly be extended.
List the matter on 30th interim order subsisting will continue to the
May
next.
kindly.
Post immediately after service of notice upon respondents. ಯಾರಿದ್ದಾರೆ respondent? ನಿಮ್ದಲ್ಲ ಚೊಕ್ಕರೆಡ್ಡಿ ನೀವಿದ್ದೀರಾ?
ಇದು 51, my lord, I am
51 ಆಯ್ತು 52. Yes.
52, my lord, we are filing the wakalat, my lord, for all the respondents.
Learned counsel so and so undertakes to enter appearance for all the respondents. Registry to print the name of so and so as appearing for
There is
respondent.
a similar connected, similar matter. my
Number
lord.
ಕೊಡಿ. Tag this petition along with so and so. List them on 6th August.
Interim order.
Interim order subsisting will continue to the next date.
Great.
53.
My lord, I appear for the
Except
petition.
for the
My
case
instruction
with
is
the
that, my lord,
respondent
we
in
have
this case.
complied all the his objections.
Repetition is in practice, my lord.
ಸೂಟೆ ಕ್ಲೋಸ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಇಲ್ಲ.
ಇಲ್ಲ ಆರ್ಡರ್ ಗೆ ಪೋಸ್ಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಫೈನಲ್ ಡಿಗ್ರಿ ಫೈನಲ್
ಅದಕ್ಕೆ ಇನ್ಫ್ರಾಕ್ಚರ್ಸ್ ಹೆಂಗಾಗುತ್ತೆ?
ಅಲ್ಲ ಚಾಲೆಂಜಿಂಗ್ ದಿ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಕೋರ್ಟ್ ಕಮಿಷನರ್, my lord. Court commissioner was appointed and his report is submitted, my lord.
So
After
it
the-
becomes infructuous.
No, my lord.
List on Monday.
My lord.
Office objections overruled, list on Monday.
My lord, not to precipitate.
List on Monday in preliminary hearing, yes.
My lord, they are seeking for disposal of the petition, that FDP, not to precipitate, my lord.
No, my lord. No, my lord. Interim prayer is already infructuous, my lord. Interim ground.
So don't worry about that. The concerned court shall defer its proceedings till the next date.
No, my lord. Already.
ಅಷ್ಟೇ.
My lord, kindly
ಅದಕ್ಕೆ
see, my lord.
don't precipitate till Monday.
Please.
Yes. Learned counsel for the respondent undertakes not to precipitate the matter before the final decree, before the concerned court in FDP so and so till Monday.
My lord, on 30th, it is posted for a final order, my lord.
30th ಗಲ್ವಾ?
30th,
ಇದು ನಾನು ಹಾಕಿರೋದು Monday 21st ಗೆ.
Yes, please.
54.
Post immediately after service of notice upon respondents 3 and 4.
File wakalat for R2, my lord, my name may be shown. So
R2.
for R2.
R2, R3.
ಅಂತ ಇದೆ?
ಅಲ್ಲ ನನ್ನ ಹೆಸರು, I have filed wakalat.
Counsel so and so submits that he has entered appearance for the second respondent. Registry to print the name of so and so as appearing for the second respondent.
R3 and R4 are one and the same, my lord. Company representative,
ಹೌದಾ?
managing directors.
ಯಾರಿದ್ದಾರೆ?
ಅವರೇ ಇದ್ದಾರೆ.
ನೀವೇ ತಗೊಂತೀರಾ?
R3 and
R4,
ಇಲ್ಲ ನನಗೆ ಅದು ಕಾಪಿ ಇಲ್ಲ ಇಲ್ಲಿ. ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ.
Post immediately after service so and so. Next.
interim order may be extended.
Interim order subsisting will continue to the next date.
55.
Petition. Had someone served on the.
Post immediately after service of notice upon respondent 11 interim order.
File wakalat for R11, my lord, in the office.
Learned counsel B. Vachan submits that he has entered appearance for R11. Registry to print the name of so and so as appearing for R11. List on 6th August. Interim order subsisting would continue to the next date of.
Pleasure.
I filed application for vacating stay.
Appearing for petitioners, my lord.
Furnishing PF ಏನಿದೆ? R 5 to 7 ಯಾರು?
Allah, they may not be necessary party because the first respondent is the owner of the property. Let by suppressing.
Non taking of hand summons for service of notice. Interim order will vacate if you do this.
Extension, my lord. Arguing counsel is not well.
Oh, thank you. Yes. Needful be done by the 23rd. In the event the matter is listed again in the same stage without needful being done, the interim order would get automatically vacated. List on 23rd. Yes, next.
For the petitioner defendant, not only is the tag matter.
Non-compliance.
No, it's already complied. There's one office objection which has come up on council submission. Lord.
ಇದು
That
ಆ
may be
matter.
overruled. That may be overruled. Annexure came, Lord. There's no legible copy is what the objection is. On council submission, it's come. I'm not relying on it at all.
All right, we'll overrule, but hearing in this stage, preliminary hearing ಆಗ್ತೇನೆ Monday.
I will not take more than 10 minutes.
No, correct, but.
Lordship, I have it at 2:30. Not there's some urgency. The stay is operating for 30 days on their own submission. Today, not only is the tagged matter here, my
I
learned
suit
senior is also here.
2004
Pass
suit.
over.
Pass on. So great.
This 2004 suit.
Yes, Lord. The
Then
2004
pass
suit.
over.
Please.
Yes. Office objection, ಅವಾಗಲೇ overrule ಮಾಡ್ತೀವಿ. Yes.
58.
RERA order, my lord, is sought to be enforced.
No. It did not go before RERA.
I understand that, my lord. You will also kindly see, my lord, the nuances of the.
ಇದೇನು execution ಹಾಕಿದಾರಾ?
ಹೌದು.
ಯಾವ order ನ?
RERA order na.
RERA
And my lord,
order
there is
for-
one
wait,
second,
wait,
one
sir.
second, brother,
Sorry,
one second.
sorry.
My lord, I am certainly aware of one provision, my lord, rule. If your lordships could kindly have, my lord, RERA Act, there is one provision which enables Rule 26 of, my lord, the RERA rules, which reads, manner of implementation of order, direction or decisions of adjudicating officer, the authority as appellate tribunal. For the purpose of subsection 2 of section 40, every order passed by the adjudicating officer, regulatory authority or appellate tribunal, as the case may be under the act or rules and regulations made thereunder, shall be enforced by the adjudicating officer, regulatory authority or the appellate tribunal in the same manner as if it were a decree or order made by the principal. First thing is, my lord, they will enforce it as if it were a decree. Number second, my lord, the second part, decree, tribunal in the same manner as if it were a decree or order made by the principal civil court in a suit pending therein, and it shall be lawful for the adjudicating officer, regulatory authority
ಈಗ
or appellate tribunal.
ಬಂದಿರೋದು non-compliance of office objections.
78. Allah, my lord, they are going ahead. We will comply, my lord. But my lord, this
You
kind
should
of-
also have gone ahead and complied with the office objection.
We will, my lord, we will. But my lord, in the meanwhile, what happens, my lord? This mixes the jurisdiction, my lord. Tomorrow, civil court, my lord, will say, I will enforce all the orders of the decree upon an application, my lord. There is two things. One,
I think it is time that should be permitted. No order of RERA is being implemented.
I understand, my lord.
It
that's
is
part-
better this
I-
way it is implemented.
I understand, my lord. Equities, my lord, yes. But my lord, strictly going by law, my lord, law cannot be, my lord, extended to, my lord, this extent that the learned judge says, we will appoint, my lord, a particular verbatim, my lord, which, my lord, baffles me. Kindly, my lord, see paragraph number 7, my lord, what the learned judge says. My lord, this is
It
something.
does not. It does
There's
not
one
baffle
particular
me.
simile that is adopted, my lord. In fact, I was a bit taken aback by this simile. What the learned judge would say, that now on the cover of it, it looks, yes, there is bar of jurisdiction, but we will employ a particular, my lord, verbatim says, worm's eye view. I don't know, my lord. Of course, my lord, worm's eye view. I understand, my lord, worm's eye view or whatsoever the eye is. But my lord, that can't be that myopic, my lord, to say that I will execute the orders of the RERA appellate tribunal. My lord, now kindly see, section 40 is a complete, my lord, provision. And if section 40, the officers of the RERA are unable, they will send it for execution to the court. My lord, that part is provided under the rule. But my lord, where is the question of, my lord, party going to the execution court under order 21 and say implement this? My lord, it's not a decree transfer proceedings. I mean, it can't be stretched. for
Very
one-
wrong
one-
submission, my lord.
Wait, sir. And then, and my lord, in this case, on a peculiar fact, there is one more, my lord, dimension. They would come before this honorable court, seek a direction. This honorable court directs. Your lordships rightly observed that the RERA orders are not being implemented. My lords have issued, my lord, several directions directing the revenue recovery. Revenue recovery, my lord, also my lord, they can't be, my lord, traveling on many ways for the same relief. Now, my lord, at the orders of this honorable court, directions were issued. The RERA authorities, my lord, revenue recovery authorities have gone all across. They are seizing the properties. They are attaching the properties. That is, my lord, one set of facts. At the same time, my lord, civil court tomorrow initiates proceedings for the implementation and decree, deeming it as a decree.
Wait, all right. ಏನ್ ಹೇಳ್ಬೇಕು?
My lord, kindly page number 20 may be seen, my lord.
What for?
Of the appeal, it is a decree transfer. There is an order in between the order of a refund and the order which is impugned at this
We'll
court.
see. List
And
office objections ಏನು?
We will comply. Very minor office objection. 78 is also, my lord, the same matter.
Office, wait. Office objections Accepting the submission of the council and senior counsel office objections stand overruled. List the matter on Friday in preliminary hearing.
Much appreciated.
Yes.
78 is also same.
ಆಯ್ತಾಯ್ತು ಬರ್ಲಿ. Yes, next.
Till then, my lord, the execution.
ನಾಡಿದ್ದವ್ರಿಗೆ ಏನಾಗುತ್ತೆ?
Greatly
Yes.
obliged, greatly obliged. Much appreciated.
My clubbing application has been rejected, Your Honor. My-
Clubbing application rejected. Memo,
They are come on.
Time for the respondent.
respondent ಯಾರಿದ್ದಾರೆ? ಒಬ್ರೇನಾ?
Operation.
Clubbing application rejected. List on Monday in preliminary hearing. Learned counsel.
This is very simple
Acknowledgement.
matter, Your Honor.
The
Its own-
registry is directed to delete the indication of non-filing of acknowledgement. List on Monday in preliminary hearing. Next.
Excuse me, sir. Sir, my name is Shanti, sir. ನನ್ನ ಕೇಸ್ ನಡೀತಾ ಇದೆ ಇಲ್ಲಿ, ಆದ್ರೆ ನಾನು ಸೈನ್ ಹಾಕಿಲ್ಲ.
Don't interfere in the proceedings. Wait.
Okay, sir. 60.
For the petitioner, my lord. Notice has been served to the council appearing before the trial court, my lord. Last occasion I filed the
ಯಾವ ಕೇಸ್ ಇದು?
writ petition number 18/449. Serial number 16.
60.
Please.
R1 and R2 ಯಾರು?
R1 council representing the lower court serve ಮಾಡಿದೆ.
ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೀನಿ.
Entry ಮಾಡಿದ್ಯಾ?
Entry ಮಾಡಿದೆ.
List the matter on 30th. Awaiting the representation of R1 and R2 interim order subsisting will continue till the next date of hearing. Yes, next.
61.
ಸಾಕು, will continue. ಈಗ ಹೇಳಿ.
Sir, ನಂದು CRP number 792.
Who are you? Party in person ನಾ?
Party sir, ನನ್ನ ಹೆಸರು ಶಾಂತಿ ಸರ್.
Party in person ಅಡ್ವೊಕೇಟ್ ಇದ್ದಾರಾ?
ಇಲ್ಲ ಸರ್, ನನ್ನ ಅಡ್ವೊಕೇಟ್ ಇಟ್ಟಿಲ್ಲ ಸರ್. ಅದೇ ನನ್ನ ಪರವಾಗಿ KR ನಾಗರಾಜ ಅಂತ ಅಡ್ವೊಕೇಟ್ ನಮ್ ಫೋರ್ಜರಿ ಮಾಡಿ ಇಟ್ಟಿದ್ದಾರೆ. ನಾನು ಸೈನ್ ಹಾಕಿಲ್ಲ, ಏನು ಮಾಡಿಲ್ಲ ಸರ್.
ನಂಬರ್ ಕೊಡಿ ಅದು.
792/2024 ಸರ್.
ಗುರುವಾರ, ನೆಕ್ಸ್ಟ್ ಗುರುವಾರ ಬರುತ್ತೆ. 24th. Come on 24th. Yes.
The lordship can permission. Serial number 73. Have to
After. Yes.
ಕೇಳಿಸ್ಕೊಬೇಕಮ್ಮ ಕರೆಕ್ಟ್ ಆಗಿ.
List to 8th court matter. Wait, ಅದರಲ್ಲಿ ಬೇರೆ ಯಾವುದು ತಗೊಳ್ಳಲ್ಲ except preliminary hearing. All other matters next week ಅಂತ.
May I make an appeal?
Preliminary hearing ಮಾತ್ರ sir. Only preliminary hearing.
My lord is overboarded. I only request your lordship, Lord, 23 is concerned, date may be given, my lord. Some
No
urgency
dates.
is there, my lord.
Other court ಗೆ we will not give. ಎಲ್ಲ next week. Yes.
ಒಂದು ದಯವಿಟ್ಟು ಒಂದು ಡೇಟ್ ಕೊಡಿ, ಯಾಕೆಂದ್ರೆ ಪಾಪ ಅವ್ರು ರಿಟೈರ್ ಆಗೋರಿದ್ದಾರೆ. He is bedridden.
ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮೂವ್ ಮಾಡಿ ಸರ್. ನಾನು ಹೆಂಗ್ ಡೇಟ್ ಕೊಡ್ಲಿ?
ಮೂವ್ ಮಾಡಾಗಿ ಬಂದಿತ್ತು. ಅದು ಮೂವ್ ಮಾಡಾಗಿ ಡೇಟ್ ಬಂದಿತ್ತು, ಇವತ್ತು ಬಂದೋಯ್ತು ನಮ್.
Except between 11 to 15, I am not taking any other matter. All other matters will go next week. Interim orders ಇದ್ರೆ continue ಆಗುತ್ತೆ.
My lords, serial number 10 in this case, my lords, there is covered by orders, my lords, only one off subjection.
ಅಲ್ಲೇ.
There is urgency in this, my lord.
ಏನ್ urgency?
My lord is over.
1 minute, sir.
There is no
They are removing the guest lecture.
There is no interim order.
ಆಯ್ತಾ?
They are removing the guest lecturers, my lords. The power there, my lord. Only of the subject is, my lord, just the other district members are there.
ನೀವು ಒಂದ್ಸರಿನೂ ಬಂದಿಲ್ವಾ ಕೋರ್ಟ್ ಮುಂದೆ?
ಇಲ್ಲ, this is the first time.
ಆಯ್ತು,
Serial number 10, my lord.
Wait.
Serial number 6 also, my lordship.
ಇದೇ ಪ್ರಾಬ್ಲಮ್. ಒಂದಾದ್ರೆ ಎಲ್ಲ ಆಗುತ್ತೆ. ಅದೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡಿ. ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ 6 ಅದು ಗೆಸ್ಟ್ ಲೆಕ್ಚರರ್ಸ್.
It is, he has already retired, my refixation of salary, my lordship. For recovery of.
You take from that court, yes.
No, my lordship, because there
No.
urgency.
Yeah, I will not take anything. Only preliminary hearing 11 to 15. That's all. All pending matters I will not take.
My lord, I agree with your lordship, your lord overboarded. I only request is 26, one date may be given, nothing else, my lord.
No sir, date also I will not give.
ಅದು ಬೆಡ್ ರಿಟರ್ನ್ ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ ಪಾಪ ಅವರಿಗೆ.
ಅದು ಅಲ್ಲೇ ಹೇಳಿ, ಸೋಮವಾರ ಹೇಳಿದ ಕಷ್ಟನಾ ಬೆಡ್ ರಿಟರ್ನ್ ಅಂತ? Yes.
My lord, serial number 9 in the same.
1 minute, ಕರೆದ್ಬಿಡಿ ಮೇಡಮ್. ಪೃಥ್ವೀಶ್ ಏನು?
Discuss, lordship.
List next week. Yes. Next week. A week's time is granted to comply with the office objections. Next. Post immediately after service of notice upon 2 and 3. Next. Post immediately after service of notice upon respond 5 to 9. Interim order
6 appearing for petition, my lordship. In the copy has been already served, my lordship.
ಯಾವ್ದ್ರಲ್ಲಿ?
6, my lordship.
Office objection ಏನು?
Office objection, it is a small correction, my lordship. We are going to do it
Week's
today.
time is granted to comply with the office objections. Next.
My lord,
Next week ಎಲ್ಲ interim order ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. Yes. 1 to 4 ಆಲ್ರೆಡಿ ಇದೆಯಲ್ಲ. 5 to 9 ಗೆ notice is ordered. Post immediately after service of notice upon response 5 to 9. Heard learned senior counsel V. Lakshmi. Yes, ಆಮೇಲೆ ಪಾಸ್ ಓವರ್. Yes. ನೆನ್ನೆದ್ ಮ್ಯಾಟರ್. Yes.
Serial number 7. Lord, I have challenged the cancellation which is stayed by this honorable court. Lord, after hearing all the parties, my lord, interim order is granted.
ಅದೇ beneficiary of an illegal order ಅಂತ ಹೇಳಿದ್ನಲ್ಲ ಅದಾನೆ.
Lord, it is only an afterthought, my lord. After
where is
he has filed the writ petition, my lord, after the cancellation, where is the, my lord, writ petition? Lord,
Sir,
writ petition is
1
filed.
minute, sir. He was in a particular place.
Yes.
3 years.
Not yesterday's matter, my lord.
ಮತ್ತೆ ಅದು ಯಾವುದು?
ಇಲ್ಲ, ಇದು ನೆನ್ನೆದಲ್ಲ.
ಇದು ಯಾವ್ದು ಮತ್ತೆ?
ಇದು ನೆನ್ನೆದಲ್ಲ ಸ್ವಾಮಿ.
ನೆನ್ನೆದಲ್ವಾ ಇದು?
ಅಲ್ಲ, ನೆನ್ನೆದಲ್ಲ. ನೋಡ,
already have, yes.
BWSSB
Yes, next week. Yes, next.
Lord, interim order may be
ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ already insistence I have stayed.
Yes.
Yes. ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ?
No.
Yes,
My
yes.
learned
Next
friend
week.
may not be right.
Next week.
But
yes.
interim order may be extended.
Whatever order is there, that will continue. Yes, next. Both cases, yes. No, sir. Next, yes. Next week. A week's time is going to.
9 I appear for the petitioner counsel, my lord. My lord, the regularization has been rejected and now I sought to be relieved, terminated from the service, my lord. From 2011 I am working, my lord.
Kodi, madam.
Coordinate bench of Dharwad High Court has granted interim order, my lord. Annexure H, my lord. Page, my lord, page number 45. That is the coordinate bench in similar set. Page
The
40.
learned counsel for the petitioner submits that he is similarly placed to that of the petitioner in writ petition 103-445 of 2025, wherein the coordinate bench has granted an interim order of stay. The said interim order reads as follows, page 46. In the light of the said interim order, the petition, there shall be an interim order in the case of the petitioner as well.
No, office objection may be overruled. That is a
Office
site.
accepting the submission of the council, office objections overruled.
Much obliged.
Yes, next. ಅಲ್ಲಿ ನೋಟಿಸ್ ತಗೊಳ್ಳಿ.
That's fine. For the
ಅಲ್ಲಿ
petitioner, my lords, in
ನಿಮಿಷ.
this case,
I'll take notice for respondent number 1 minute.
R1,
R1 minute.
HCGP R1, 2 and 3.
Caveat has been entered. I have sought copy also.
Yes,
Please.
next.
my lord, then for the petition.
Then guest lecturer.
Page number 135, my lord, the appointment.
Office
of-
objection ಏನು?
Office objection, my lord, they have mentioned the citation in the prayer para, my lord.
Citation.
Yes, my lord, just a processing, yes, just I'll remove that, my lord. As per the judgment, my lord, just ask for the orders, my lord.
ಏನ್ ಗೆಸ್ಟ್ ಲೆಕ್ಚರರ ಏನಿದು?
Guest lecturers, my lord.
ವೇಟ್, ಗೆಸ್ಟ್ ಲೆಕ್ಚರ್ ಬೇರೆ 230 ಮೂವ್ ಮಾಡಿರೋದಿದೆ, ಅದ್ರ ಜೊತೆ ತಗೊಂತ. ಫಸ್ಟ್ ಫೋರ್ ಮಾಡಿ ಒಂದು 230.
Madam, may I make one sub- Madam,
11.
Madam, may I make one submission? That's serial number 5 in the order, sorry. There is a. Madam, lecture-
5 ಆಗೋಯ್ತು. ಎಸ್ ನೆಕ್ಸ್ಟ್.
Madam, it is retired. Madam,
ಸೀರಿಯಲ್
no,
ನಂಬರ್
they want to
11 ಏನು?
Madam, it is one time, Madam, you have to-
ನೋ ಸರ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿದ್ದೀನಿ, ಬರುತ್ತೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
Monday ಸ್ವಲ್ಪ urgent ಇದೆ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಸರ್. ಎಸ್.
Senior is out of station. Next.
List after 2 weeks at the request of the council appearing for the petitioner. Next. Awaiting service of notice to R3. Who is R3? Post immediately after service of notice.
This is two order.
What interim relief?
Your Lordship, the respondent number 2 has ordered for the deduction of 19,000 from the
No, yesterday I asked you, is it pursuant to a departmental inquiry?
Yes, Your Lordship.
Then that's a final order of penalty.
Your Lordship, the respondent number 2 has
Order
reviewed
detail.
the order without giving opportunity to the.
Not necessary, it's not a review order, madam. It is a consequential order to the order of penalty. Anyway, you take a chance there. List the matter next week. Yes. No representation. List next week.
Matter pertaining to not transfer, but I am an employee of not second respondent corporation.
What is that? KFCSC, Food and Civil Supplies.
Civil Supplies Corporation.
Ah.
Annexure C is the impugned order of transfer passed by the government.
Ah.
Similar matters.
Correct. ಯಾರು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ದಾರೆ?
State government has transferred. State government not done.
Covered.
Yes, covered.
I'll take notice for respondent.
The learned HCGP is directed to accept notice for
R1.
the first respondent. Counsel Shri Nandish Gaud accepts notice for the second respondent. The petitioner is before this court calling in question an order of transfer, a transfer pursuant to an order passed by the first respondent state government. Plethora of cases have been rendered, a plethora of orders have been rendered by the coordinate benches of this court or this court that the state government has no power to transfer an employee of the corporation. In that light, there shall be an interim order of stay as prayed for till the next date of hearing. Yes, next.
Petitioners are working as a
Guest lecturer.
Your Lordship may
Why would a guest lecturer is then position today?
I'll take notice.
You take notice, ಆಮೇಲೇನು?
Your Lordship may kindly peruse.
Have you not seen what is the latest law?
Lordship at annexure D.
ಅರೆ ವೇಟ್ ಸರ್, ಒಂದು ನಿಮಿಷ. ಅವ್ರಿಗೇನೋ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಅನೆಕ್ಷರ್ ಡಿ ಏನು? ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಗೊತ್ತು. ಎಸ್, ಅದು ಟ್ಯಾಗ್ ಅಲಾಂಗ್ ವಿತ್ ಪೇಜ್ 46 ಸೇಮ್ ಆರ್ಡರ್. ಅವ್ರದ್ದು ಒಂದು ಗೆಸ್ಟ್ ಲೆಕ್ಚರರ್ ಯಾವುದು? 10 ಸೇಮ್ ಆರ್ಡರ್ ಟ್ಯಾಗ್ ಅಲಾಂಗ್ ವಿತ್ ದಿಸ್. ಇಲ್ಲಿ ಯಾರ್ಯಾರು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದೇ ಮಾಡ್ಬಿಡಿ ಮೇಡಮ್.
All respondent.
ಅದು ನಿಮ್ ಸಾಹೇಬ್ರದ್ದು ಆರ್ಡರು, ಅದು ಯಾರ್ಯಾರು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವ್ರಿಗೆ ಟ್ಯಾಗ್ ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕ್ಬಿಡಿ. ಪೇಜ್ 46. ಎಸ್, ಅಷ್ಟೇನಾ? ಬಿ ಗ್ರೂಪ್ ಇಲ್ಲ. ಎಸ್, ನೆಕ್ಸ್ಟ್ ಆಲ್ ಅದರ್ ಮ್ಯಾಟರ್ಸ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಇಂಟ್ರಿ ಆರ್ಡರ್ಸ್ ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. next week. Heard partial ಅಂದ್ರೆ ಅಲ್ಲೇ ತಾನೇ ಮೂವ್ ಮಾಡ್ಬೇಕು. Yes. ಅಲ್ಲೇ ಕೇಳಿ. 230 ಮೂಡ್ ಎಷ್ಟಿದೆ ಮೇಡಮ್ 8 ಕೋರ್ಟ್? ಯಾವುದು ಬಂದಿಲ್ವಾ? ಸರಿ ಆಯ್ತು. 35 which list? Second list. If someone accepts it as covered, we'll close it.
My lords, I appear for respondent. It is covered by judgment, but I have to produce one schedule, which since it's a government PSU,
Next
I
week,
just
next
have
week.
to
Yes.
file it.
My lord.
Next week, move ಮಾಡಿ.
Kind permission, my lord. Serial number 20.
No, big group will not take. Big group will not take. Yes. ಒಂದು ತಗೊಂಡ್ರೆ ಆಮೇಲೆ ಎಲ್ಲ ತಗೋಬೇಕಾಗ. ನಂದೇ I am not able to finish. Yes. ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಹೇಳಿ will do. ಬೆಡ್ ರಿಡನ್ ಏನಾಗಿದೆ? 70 years ಬೆಡ್ ರಿಡನ್ ಏನಾಗಿದೆ? ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ? ಸಾರಿ? ಹಾ, ನೀವು ಟ್ರಿಬ್ಯುನಲ್ ಜಾಸ್ತಿ ಅಪೇರ್ ಆಗ್ತೀರಾ? ಹಾ, ಪರವಾಗಿಲ್ಲ ಹೇಳಿ. ಹಾ,
Senior is not in station, my lords.
Not in station.
Yes, my lords, we have already issued
Bed
an
ridden,
endorsement.
sir.
My lords, my senior is not in station, my lords. Due to his relative has hospitalized, my lords.
ನೀವು hospitalized?
My senior's relative, my lords.
ರಿಲೇಟಿವ್ ಇಸ್ ಹಾಸ್ಪಿಟಲ್.
Yes,
ಅವರು
my lords.
ಅವರು ಬೆಡ್ ರಿಡನ್.
In the early morning, my lords.
ಅವ್ರ ರಿಲೇಟಿವ್ ಬೆಡ್ ರಿಡನ್. ಎಸ್, ಆ ಕೋರ್ಟಲ್ಲಿ ಮೂವ್ ಮಾಡಿ.
In the last occasion also.
Same submission was made.
No, my lords, see, the senior is not present, therefore the matter is urgent, my lords. We are ready on that day, my lords.
All, you are ready on that day.
Yes,
You are
my
ready on that.
Yes.
Yes. ಅಲ್ಲೇ ಕೇಳ್ಬಿಡಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ. ನೋಟಿಸ್ ಆಗಿದೆಯಾ? ಬಿ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಇದೆಯಾ? ಕೇಳಬೇಡಿ. ಎಸ್, ಯಾಕೆ ಇನ್ಕಾಂಪಿಟೆಂಟ್ ಅಥಾರಿಟಿನ ಮತ್ತೆ? ಏನ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್? ಸೊ ಮ್ಯಾಲಿಫೈಡೆ ಸ್ಟೇ ಮಾಡಿಲ್ವಾ? ಅಲ್ಲೇ ಕೇಳಿ. ಎಸ್, ಎಸ್, ಬಿ ಗ್ರೂಪ್ 1 ತಗೊಂಡ್ರೆ ಆಮೇಲೆ ತಗೋ ನಥಿಂಗ್. ಎಸ್, ಕೊಡಿ. The petitioner is a subsequent purchaser, has neither demonstrated any subsisting title in site number 828 in survey number 54/1, nor has shown such site was ever excluded from acquisition. In the absence of such foundational assertions, let alone proof, the claim of the petitioner collapses under the weight of its own infirmities. Dismissed.
My lord, my submission, my lord, until we had an interim order of status quo that may be extended for 30 days.
Interim order of any kind, ಅದು ಬರ್ದಿದೆ. Interim order of any kind operating shall stand dissolved.
My lord, it was a status quo order only for 30 days. It may be extended.
I can't stay my own order, sir. Yes. Next, copy will be released by this evening. You can challenge it tomorrow. Yes.
Obliged.
Writ petition is allowed. The proceedings in execution so and so stand squashed in its entirety. Yes. Continue in my list. Furnishing of PF, issuance of notice to R1 and R2. A week's time is granted to do the needful. Interim order idre continue. Next. Same week's time is granted to do the needful.
Needful is done.
Counsel for the petitioner submits, needful has been done, office to verify. Entry ಮಾಡಿದ್ರೆ continue ಮಾಡಿ. Post immediately after service of notice upon the respondents. Entry ಮಾಡಿದ್ರೆ continue ಮಾಡಿ.
And summons was served.
In this case, my lords, I will undertake to file wakalat, my lords.
For R1 to R1
1 and 2,
R2.
my lords. Ravi Shankar, yes, my lords.
Learned counsel so and so undertakes to enter appearance for respondents 1 and 2.
IO may be,
Huh?
IO may be extended.
1 and 2. Interim order stands extended till the next date of hearing. Objections, if any, in the next 2 weeks.
Date may be fixed.
In the next 2 weeks, 6th August. Yes.
Please, my lords.
Much obliged.
In objections, if any, by the next date, list on 6th August.
My lords, for the petitioner, my lords, we have served the respondent counsel in the trial court, my lords. It's come for PF, my lords.
Interim order, yeah?
Please, my lords.
List on 30th. Interim order subsisting will continue to the next date of hearing.
Please.
An application for amendment of the written statement has been rejected. There are two parts in the amendment. One is withdrawing certain admissions made in the written statement. Then paragraph, we are also seeking addition of certain paragraphs. Two things could be done. One is, your lordship may look at it, whether deletion is permissible is one thing. Secondly, addition, your lordship can allow us because evidence is not.
It is my order.
Not your.
Issues are framed?
Yes, my lord, issues are framed and burden of proving those issues is on the plaintiff.
No, is it prior to the framing of issues
Yes,
that
yes,
you filed the
yes,
application?
Yes, yes. Your issues could.
Correct, ah?
Yes, your lord.
Issues are
I will permit it.
One submission.
In judgment?
Judgment alla.
Huh?
It was in the
At least clubbed in the 2018.
2018 itself, my lord.
ಏನಾಗಿದೆ?
ಮ್ಯಾಟ್ರ್ ಇದು ಮೂರ್ ಮ್ಯಾಟ್ರ್ ಕ್ಲಬ್ ಆಗಿದೆ ಒಟ್ಟಿಗೆ.
ಹಾ.
ಇವರು 1256 ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಮಾಡ್ಕೊಬಿಡ್ತಾರೆ. ಆಲ್ರೆಡಿ ಇಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಕ್ಲಬ್ಡ್ ಇನ್ 2018 itself, my lord.
Evidence has not yet commenced, ma'am.
It has been commenced, my lord, on their based on their submission.
Year 2018, the matter is evidence, your lord.
My lords,
Time bound case, my lord.
24 additional issues are framed.
and it's a time bound case, my lord. Wherein,
Who has fixed the time?
This
honorable
Where
court.
is it?
My lord, I have given the copy in the previous occasion itself, my lord.
Additional issues are framed in 2024. ma'am.
My lord,
Can I pass on the list of dates, my lord, so that it will assist your lordships to.
ಯಾವ 2019 ಅಲ್ಲೇ ಆಗಿದೆಯಾ?
Yes, your lord.
To conclude the suit. Yes, sir. Anything else, sir?
My lord, I would only say this, my
after
lord.
a lapse of 18 years, they have come with a
No,
amendment, my lord.
now there are two aspects
May
of
I read
matter.
the-
One is,
in their own.
one is, my lord, there is, we want to delete certain portions and replace it.
There are admissions, is it?
Admissions, they are,
Sure.
number one, that is one part of it. The other part of it is where we want to add few paragraphs to the written statement.
In those admitted portions
No,
being
not
deleted.
admitted, separately.
ಅಲ್ಲ ಕರೆಕ್ಟ್ ಸಪರೇಟ್ ಆಗಿ ಇದನ್ನ ಡಿಲೀಟ್ ಮಾಡಿ ಇದನ್ನ ಹಾಕ್ಬೇಕು.
ಇಲ್ಲ ಹಾಗಲ್ಲ, that is the separate. They don't relate to the what is admitted. That is not, see, what we, your lordship may kindly take the application at page 45. Just a minute, my lord, I would
Page
like to
number
show your
51.
lordship.
Suit is of the year 2006.
I understand, my lord, we understand.
Then if you understand, then
My lord,
nothing to understand,
my lord,
make you
the
understand.
written statement is one thing, my lord. Your lordships have great power in allowing.
Power ಇದೆ sir, exercise of that
ಇಲ್ಲ,
power is
50
what is important.
ಅದಿದೆ, exercise of power only I'm requesting. Your lordships could, the evidence has come in a connected matter, not in our matter.
Club ಆಗಿದೆಯಾ?
Club ಆಗಿದೆ. But
Anything else, sir?
issues are reframed in 2024. Additional issues are framed in 2024.
No problem, sir.
Because the burden of proving the issues is on the plaintiff.
He will prove, wait your is.
Therefore, my lord, no prejudice will be caused to him because your lordship sees the application. What we want to add is two paragraphs. Kindly look at that, my lord. Kindly look at that page 51, my lord, for a moment. Just take that. I will not trouble the lordship.
When was additional issues framed in which case?
In 2076. In 2076. ಎರಡರಲ್ಲೂ ಮಾಡಿದ್ದಾರೆ.
Additional issues.
ಹೌದು.
ಎರಡರಲ್ಲೂ ಬೇರೆ.
Order 14 Rule 5 application ಯಾರು ಹಾಕಿದ್ರು?
ನಾನು ಡಿಪೆಂಡೆಂಟ್ ನಂಬರ್ 8.
ಏನು for framing additional issues?
No. That was framed by, because after the, some of them were implemented subsequently and so many purchasers came on record. That's how it happened. Now the additional issues are framed on 23.
Suit for what?
Suit is for partition.
Partition suit, my lord.
So partition suit, my lord, please can be taken. No difficulty at all. Your lordship
Yes,
could.
counsel.
Your lordship can put me on terms.
OS
Put me on.
2076 issues were framed in 2013 itself, my lord. My lord, on their own
ಅಲ್ಲ
admission.
2076 OS ಯಾವತ್ತಾಗಿದ್ದು issues?
Issues 2019-7.
Then when did you file application under order 14 rule 5?
ಸಣ್ಣದಾಗಿ ಒಂದು ಇದು
Wait sir.
ಸಿನಾಪ್ಸಿಸ್ ಇದೆ ಇದು
ಕೊಡಿ
ನೋಡೋದು
ಅದು ಕೊಡಿ.
In 2076, plaintiff has filed the additional issues, Your Honor.
ಹಾ.
Plaintiff,
ಅದೇ
2076.
ಯಾವಾಗ?
24, Your Honor.
24.
24 ಅಲ್ಲಿ.
24.
ಐಟಮ್ ನಂಬರ್ 8 ಮೇಲೆ.
So if you want to file additional issues,
Yes.
amendment to pleadings ಬೇಡವಾ? ಬೇಕೋ ಬೇಡವಾ?
They are seeking
ಅಲ್ಲ
amendment to.
ಅವ್ರು ಏನಾರು ಕೇಳಿ ನೀವು ಅಡಿಷನಲ್ ಇಶ್ಯೂಸ್ ಫ್ರೇಮ್ ಮಾಡಿದ್ಮೇಲೆ do they not have right to defend by amending the written statements?
Once they have admitted the facts, my lord.
So that's all right. Why did you file additional issues then?
The-
For having filed additional issues and that accepted, they have filed amendment to written statement.
That additional issues is in the 2076, Your Honor. This amendment in the 1256.
ಕ್ಲಬ್ ಆಗಿಲ್ವಪ್ಪ ಎಲ್ಲ ಮತ್ತೆ ನೀವೇ ಕ್ಲಬ್ ಆಗಿದೆ ಎಲ್ಲ ಟೈಮ್ ಲಿಮಿಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ನಿಮಗೆ ಕನ್ವೀನಿಯಂಟ್ ಆಗಿ ಹೇಳ್ತೀರಾ. Once order 14 rule 5 is allowed in your favor, 617 should be allowed for that limited purpose.
Earlier.
We will say the admissions will not be permitted to be deleted, but addition of amendment ಮಾಡ್ಕೊಳ್ಳಿ. That I will say. Yes.
That it may be done.
ಎಷ್ಟಕ್ಕೆ 21 ಇದು?
ಹೌದು 66 ಇದೆ.
ಆಯ್ತು ಸರಿ. The petitioners are before this court, a petitioner is before this court calling in question an order of the concerned court which rejects the application in IA 77. ಯಾವಾಗ ಸೆಂಚುರಿ ಮಾಡಬೇಕು ಅಂತಿದ್ದೀರಾ?
Century ಆಗೋಗಿದೆ.
ಆಗೋಗಿದೆಯಾ? 104 ಆಯ್ತಾ ಈಗ?
ಇದ್ರಲ್ಲಿ 35 ಡಿಫೆಂಡೆಂಟ್ಸ್ ಇದೆ. ನಾನು ಇದೇ ಫಸ್ಟ್ ಅಪ್ಲಿಕೇಶನ್ ನಂದು.
Yes, yes.
ನಂದು ಫಸ್ಟ್
The petitioner, ನೀವು ಯಾವ ಡಿಫೆಂಡೆಂಟ್ ಸರ್?
ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 8 ಮೇಲೆ.
The petitioner, the eighth defendant, is before this court calling in question an order dated 29/6/2024, passed on IA number 77 in OS 1256 of 2006, rejecting the application filed by the petitioner under Order 6 Rule 17 of the CPC. The plaintiff respondent institutes suit for partition in OS 1256 of 2006. The case has traveled all over. The coordinate bench of this court in RSA 93 of 2012, which comes to be disposed on 19th March 2009, had directed the concerned court to dispose the suit within an outer limit of 10 months from the date of receipt of the copy of the order dated 19th March 2019. Not 10 months, but 60 months have passed by, but the suit is still pending, as applications after applications are being filed either by the plaintiffs or by the respondents. The issue is whether the application in Order 6 Rule 17 filed by the defendant number 8 should be allowed or otherwise. The learned counsel for the petitioner would fairly submit that the application is filed to delete certain admissions made in the written statement and incorporate certain amendments pursuant to the application under Order 14 Rule 5 filed by the plaintiff being allowed and an additional issue being framed before the concerned court. The learned counsel for the respondent would submit that if the admissions are not permitted to be deleted, and he would have no objection for the amendment to be allowed. In the light of the said submission, without going into the veracity of what is sought for, I deem it appropriate to dispose the petition, permitting the petitioner to amend the written statement only insofar as inclusion of paragraphs and not to the exclusion of the admissions that are already made in the written statement.
Can we come to page 52?
No, I am not going to do that. Yes.
No, one minute. What I am.
ನೀವೇ ಹೇಳಿದ್ದು admissions are to be deleted.
ಅದಕ್ಕೆ ಅದನ್ನ ಹೇಳ್ಬಿಡ್ತೀವಿ. ಪ್ಯಾರಾ 9A, ಪ್ಯಾರಾ 9B ಇನ್ಕ್ಲೂಡ್ ಅಷ್ಟೇ.
So in the light of the said submission, I deem it appropriate to dispose the petition, permitting the petitioner to amend the written statement only for inclusion, not for exclusion of admissions, as admissions which, in the light of the fact that such inclusions are not opposed to by the counsel for the plaintiff. For the aforesaid reasons, the following order: the order dated so and so stands quashed. The petition is allowed in part. Order dated so and so stands quashed. The order which rejects inclusion of amendments to the written statement stands allowed. The order which rejects the exclusions of admissions from the written statement stands sustained. Ordered accordingly.
But in this case, arrest warrant is being issued, my lord.
Because the petitioners are never appeared before.
ನೀವೇನ್ ಇಲ್ಲಿ
For the respondent.
ಬ್ಯಾಂಕಾ?
Shriram Transport.
They avail the loan, they defaulted.
My lord, I filed my objection, stated in the objections that I have no means to satisfy.
For that,
I have no means to satisfy the award. They have, I was a lorry driver, I had taken a lorry, my lord, that has been seized and sold, my lord, for the partly amount.
ಎಷ್ಟು ಟೋಟಲ್ ಲೋನ್ ಎಷ್ಟಿತ್ತು?
10,45,971.
ಲಾರಿ ಸೀಸ್ ಮಾಡಿದ್ರಾ?
ಹೌದು.
ಎಷ್ಟಕ್ಕೆ ಮಾರಿದ್ರಿ?
That I have no information about.
ಅವ್ರಿಗಾರು ಇರುತ್ತಾರ ತಾಳಿ?
All notices have been served.
ನಾನು ಕೇಳಿದ್ ಒಂದೇ ಕ್ವಶನ್, ಎಷ್ಟಕ್ಕೆ ಮಾರಿದ್ರಿ ಅಂತ. ಅದ್ ಬಿಟ್ಟು ಬೇರೆ ಏನೋ ಹೇಳ್ತೀರಾ? ನಿಮ್ ಲ್ಯಾಪ್ಟಾಪ್ ಅದನ್ನ ಹೇಳ್ತಾ ಇಲ್ವಾ?
ಇಲ್ಲ ಸರ್, ಮ್ಯಾಟರ್ ಇಲ್ಲಿ ಪ್ರೇಯರ್ ಇಸ್ ದೇ ವಾಂಟೆಡ್ ಟು
ಎಷ್ಟಕ್ಕೆ ಮಾರಿದ್ರಿ ಸರ್?
ಅದು
ಗೊತ್ತಿಲ್ಲ. ಆಸ್ಕ್ ಯುವರ್ ಲ್ಯಾಪ್ಟಾಪ್.
Without conducting inquiry.
ವೆರಿ ಸರ್ ಸ್ವಲ್ಪ ನಿಮ್ಗೆ ಹೆಂಗೂ ಮೀನ್ಸ್ ಇಲ್ಲ. ಏನದು ಅಸ್ಟ್ರಾಲಜಿ ಬಾಕ್ಸ್ ಇದ್ದಂಗೆ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ?
ಅದು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿದಂತ ಅದು ಇನ್ಫಾರ್ಮೇಶನ್ ಇಲ್ಲ ಸರ್.
ಇಲ್ವಾ?
ಇಲ್ಲ.
ಹಾಗಾದ್ರೆ
after calculating all the deductions including the sale of the vehicle, the 10,45,971 is the amount, wherein the execution court given the opportunity to appear before the Lok Adalat, no representation. They called for conciliation, no representative. Notice, cause notice served, they thrown the objection through advocate, never appeared before the execution.
ತಾರೇನೇ ಇಲ್ಲ ಅಂದ್ಮೇಲೆ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ?
They has to go and submit the day.
ಏನ್ ಮಾಡ್ತೀರಾ?
ಅವರು ಎನ್ಕ್ವೈರಿ ಕಂಡಕ್ಟ್ ಮಾಡ್ತಿಲ್ಲ ಅಂತ ಪ್ರೇಯರ್ ಸ್ವಾಮಿ.
ಏನು ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಆಗುತ್ತೆ?
ಅಲ್ಲ, ಇವರು ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಅಂತ
ಅದಕ್ಕೂ ರೆಡಿ ಇದ್ದಾರೆ.
ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ ಅರೆಸ್ಟ್ ವಾರೆಂಟ್
ಮೀನ್ಸ್ ಇಲ್ಲ
ಅಂತ ಹೇಳಿ ಅಲ್ಲಿ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರೆ ಲೆಟ್ ದ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೋರ್ಟ್ ಕ್ಯಾನ್ ಟೇಕ್ ಡಿಸಿಷನ್.
ಈಗ ನೀವು ಎಷ್ಟು ಲೋನ್ ತಗೊಂಡಿದ್ದು?
3 lakh and odd ಸ್ವಾಮಿ.
3 ಲಕ್ಷ ಲೋನ್ಗೆ ಎಷ್ಟು ಲಾರಿ ಮಾರಿದ್ರಿ? ಒಂದೇ ಲಾರಿ,
ಒಂದೇ ವೆಹಿಕಲ್.
ಎಷ್ಟಕ್ಕೆ ಮಾರಿದ್ರಿ?
ಮಾರಿದ ಅಮೌಂಟ್ ನನ್ಗೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಇಲ್ಲ.
ಅಲ್ಲ, ಮಾರಿದ ಅಮೌಂಟ್ ಅಲ್ದೇನೆ 10 ಲಕ್ಷ ಇರ್ಬೇಕು ಅಂದ್ರೆ 3 ಲಕ್ಷ ಲೋನ್ಗೆ ನೀವು ಒಂದ್ 30 ಲಕ್ಷ ಹಾಕ್ಬಿಟ್ರೆ
4 ವರ್ಷ ಅವ್ರು ಕಟ್ಟೇ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಕಟ್ಟಲೇ ಇಲ್ಲ.
5 ವರ್ಷ. 2014 ಅಲ್ಲಿ ಲೋನ್ ತಗೋತಾರೆ ಸ್ವಾಮಿ, 2015 ಇಂದ ಕಟ್ಟಿಲ್ಲ. ಕೋವಿಡ್ ಬಂದಿದ್ದು
ನನಗೂ ಗೊತ್ತು, ತಾಳಿ ವೇಟ್.
ಅವಾರ್ಡ್ ಆಗಿರೋದು 18.
That you need not look into the laptop and tell ಕೋವಿಡ್ ಯಾವಾಗ ಬಂತು ಗೊತ್ತು ತಾಳಿ. ಎಸ್.
2014 ತಗೊಂಡಿದ್ದು.
ಮತ್ತೆ ತಗೊಂಡ್ಮೇಲೆ ಕಟ್ಲೇಬಾರ್ದು ಅಂತನಾ?
Seized and
ಅದೇನು ಆಡ್ ಇತ್ತಲ್ಲ, fill it, shut it, forget it ಅಂತ ಅಷ್ಟೇ. ಫ್ಯೂಯಲ್ ಹಾಕ್ಸಿದ್ ಫರ್ಗೆಟ್ ಲೋನ್ ಓಡಿಸಿದ್ದಷ್ಟೇ ಕೆಲಸ.
ಅಕ್ಟೋಬರ್ 2018ಕ್ಕೆ ಆರ್ಬಿಟ್ರೇಷನ್ ಅವಾರ್ಡ್ ಆಗುತ್ತೆ ಸರ್. ಆರ್ಬಿಟ್ರಲ್ ಟ್ರಿಬ್ಯುನಲ್ ಮುಂದೆನೇ ಬರೋದಿಲ್ಲ ಇವರು, ನೋಟಿಸ್ ಸರ್ವ್ ಆದ್ಮೇಲೆ. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 2 times ಇದ್ಮೇಲೆ ಬರೋದಿಲ್ಲ.
ನೋ ಮೀನ್ಸ್ ಅಂದ್ರೆ ವಿಡ್ರಾ ಮಾಡಿ. ದಿ ಓನ್ಲಿ ಮೀನ್ಸ್ ಇಸ್ ದಟ್, otherwise we'll dismiss it.
As per
let the law take its way.
Yes my lord, I filed my objection my lord saying
ಯಾವುದಕ್ಕೆ?
execution petition.
ಈಗ ಏನ್ ಮಾಡಿದಾರೆ ಅಲ್ಲಿ?
They issued arrest warrant against me.
Obviously ಮತ್ತೆ ನೀವು ಹೋಗದೆ ಹೋದ್ರೆ ಏನಾಗುತ್ತೆ?
ಮೀನ್ಸ್ ಇಲ್ಲ ಅಂತ objections ಅಲ್ಲಿ ಫೈಲ್ ಆಗಿದೆ.
ಹೋಗಕ್ಕೂ ಮೀನ್ಸ್ ಇಲ್ವಾ ಅಲ್ಲಿಗೆ? ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಈಗ?
He is unemployed man.
ಯಾವ unemployed? ಇನ್ನೊಂದು ಯಾವ್ದೋ ಲಾರಿ ಓಡಿಸ್ತಾ ಇರ್ತೀರಾ?
And they vacated the premises, the last known to me, and they appears here. They are absconding.
You should search sir, where are they ಅಂತ. Anyway, ಅವರು ಕಟ್ತಾರಂತೆ ನೋಡಿ. He is ready and willing to pay the loan. That's what he is telling. I will provide the means.
I will ask the party to be present before the execution court. Arrest warrant may be.
When?
On the
next date in
17/7.
Nale. The learned counsel for the petitioner undertakes that the judgment debtor would appear before the executing court tomorrow. If in that light, in light of the said submission, The warrant of arrest hanging on his head shall stand suspended. In the event the petitioner would not appear tomorrow, appropriate orders would be passed day after tomorrow. List on 18th. Yes. ಏನ್ ರಿಪೋರ್ಟ್ ಇದು?
Option.
ನಿಮ್ದು ಇದ್ರದ್ದು ಇನ್ಸ್ಪೆಕ್ಷನ್
Inspection report of ROB, my lord.
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅವ್ರಿಗೂ ಕೊಟ್ಟಿದ್ದೀವಿ. ಅಲ್ಲ, it's not an inspection report.
ನೀವು ಒಟ್ನಲ್ಲಿ ಬಿಡಲ್ಲ ಜಾಗ.
ಅಲ್ಲ, ಬಿಡಲ್ಲ. ಒಂದೆರಡು ಪಾಯಿಂಟ್ ಹೇಳ್ತೀನಿ, ತಾವು ದಯವಿಟ್ಟು ಅದನ್ನ.
ಇವತ್ತೇನು ಹೇಳ್ಬೇಡಿ. ಲಿಸ್ಟ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ. ಎಸ್. List on Tuesday, sir, finally. I am seeking time, finally, yes.
Even I have submitted the photograph satellite images also, my lord, very.
Sunlight images?
In that report itself.
Oh, Google images?
Google.
Google is sunlight for you? Oh, all right.
Satellite.
Satellite. Adu okay. Sunlight yake?
Sunlight images also. Entry model rest.
Entry model will continue to the next date of hearing, yes.
I appeal for the petition this matter, my lords. My lords, petitioners, before your lordships, seeking for a limited prayer of restoration of FDP or liberty to file a fresh FDP, my lords. My lords, the crux of the matter is.
ಏನ್ ಮಾಡಿದಾರೆ ಈಗ?
Now, page number 24, my lords.
FDP is you want to withdraw?
No, they have withdrawn. The respondents have withdrawn. They wanted to alienate some property in the meantime. Tahsildar said there is a prakarana ನ್ಯಾಯಾಲಯದಲ್ಲಿದೆ. ಅದಕ್ಕೆ ಇವರು FDP ನ ವಿಡ್ರಾ ಮಾಡಿ ಮಾರಕ್ ಮುಂದೆ ಹೋಗ್ತಿದ್ರು. That's a crux of the story, my lords. I'm only seeking.
So what? ಈಗ ವಿಡ್ರಾ ಮಾಡಾಗಿದೆಯಲ್ಲ, ಇನ್ನೇನಾಗಿದೆ?
Now, my lords, I may be permitted to file a fresh FDP and time bound, my lords, suit is of 1998.
ನೀವು ವಿಡ್ರಾ ಮಾಡಿ ಏನಕ್ಕೆ ಬಂದಿದ್ದೀರಾ ಇಲ್ಲಿ ಹೇಳಿ?
ಅವ್ರು ವಿಡ್ರಾ ಮಾಡಿದ್ದು, ನಾನು ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀನಿ.
Oh, you are the plaintiff.
I am also one of the petitioners.
She is sailing along with me, my lords. So she is one of the daughter of my.
Now, who is sailing against you?
They are unrepresented today.
Today or all the time?
All the time, but they have come for the first time after objections compliance.
R2, ನೀವು ಯಾರಿಗೆ?
For R2A, my lord.
R2A.
Radha.
R1 to 3 ನೋಟಿಸ್ ಬಂದಿಲ್ಲ ಇನ್ನು.
ಇಲ್ಲ, one ತೀರ್ಕೊಂಡಿದ್ದಾರೆ. ಮುನಿವೆಂಕಟಪ್ಪನವರು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ.
ಡಿಸ್ಪೆನ್ಸ್ ವಿತ್ ಅಂತ ಆಗಿದೆ.
ಅದೇ ಅವ್ರು ತೀರ್ಕೊಂಡಿದ್ರು, ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ಮೇಲೆ ಡಿಸ್ಪೆನ್ಸ್ ಆಯ್ತು.
Yes, should we dispose it?
Please, my lords. My lords, adರಲ್ಲಿ one thing I would like to bring to my lordships. Page 24 is the order which has sought for setting aside. Now, with that, what will happen? Since the FDP is of 2012, I may be hit by delay and latches along with the other inconvenience as well. So, I may be permitted to.
We'll see.
Fresh.
We'll take it tomorrow in preliminary hearing. We'll pass orders tomorrow. Yes, list tomorrow in preliminary hearing.
Hearing for the respondent, my lord. Senior is on his feet and the next court almost kindly pass over.
Next court alla.
We've engaged the senior.
Which side? This side or this side?
This side.
This side.
That's a short issue. They had said that my lords had indicated that they should file an affidavit with their assets because each time they've taken time, they have closed down their office while the execution is pending.
Will you file affidavit, sir?
My lords,
Yelli Dhyan Chinnappa, sir.
he's not there, my lords.
Where is he? Next court. This has to be allowed.
My lords, kindly pass.
My lord, I will just point out to one thing because they shouldn't be urging the same point again. In the section 11 stage, in fact, it's my lord's order. They had raised the same objection. My lord's having. Please have para 14, my lord.
So what is this? 2021?
Yes, my lord. So at the time when the arbitral tribunal had to be constituted, they take the same objection saying you cannot have it in Bangalore because we are in Bombay. We were pressed, my lord, to come before my lords in a section 11 petition, which my lords decided, and the question is at para 14, which is their submission. In light of the vehement opposition to Bangalore being the center, I deem it appropriate to consider the issue with regard to jurisdiction, which is what they're raising again now. Then my lords go on to consider BGS Soma, and finally in 17, my lords may have the conclusion. It is not in dispute that the respondent company has its business or a branch at Bangalore where the petition is functioning. Therefore, it would not lie with the respondent company to contend that there is no cause of action at all for the petitioner to insist or contend that the seat of arbitration should not be Bangalore. In my considered view, in light of the true facts narrated here and above.
What are you challenging?
So now, my lord, the arbitration happened. They suffered an award. 1.27 crores has been awarded to me. I file execution petition 1 in Thane. The court is not functioning there. They do not come there. The seat court is Bangalore. I file an execution petition here. They come, my lord. They take time saying that don't issue warrants yet. And the day the court is hearing it on warrants, they say, we've closed our office, we've surrendered the lease. And then, my lord, they take time again. When I file an affidavit saying, now if they're saying there's no assets, let them disclose assets. Then they say, now that I've closed my office here and surrendered the lease, Bangalore does not have
This is
jurisdiction.
what you argued the other, yes.
Please, my colleague was, I was.
Not left any stone unturned.
Yes, my lord. They've, my lords had in fact indicated that should file an affidavit, and that's the only next option left. Otherwise,
No, let them not file. Why are you worried? We'll pass orders.
Please,
Not
my
on
lords,
concession, on merits.
One simple
Please.
submission, my lord. The execution petition that is pending at Thane, my lord, the same relief can be sought by them there. my lord.
please test that argument. They say that I will not tell you my assets here. You come to Thane, I will tell you there.
You can tell it here only. They'll take it and go to Thane.
My lords may have it reserved. They've
Pass over?
Pass over, my lord.
Pass over with Bada, Friday. Friday in preliminary hearing.
Please.
Great.
And I'm not going to adjourn on Friday. Yes.
I'm obliged.
For the respondent, my lord.
Yes, madam.
My lordship, we constructed all
39 1 and 2 na?
39 rule 1 and 2, my lordship.
ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
ಅಪ್ಲಿಕೇಶನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಕನ್ಕರೆಂಟ್ ಏನಿದು?
ಇಲ್ಲ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಎಂಎನು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಎಂಎ ಹಾಕಿದ್ರೆ ಎಂಎನು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
You are for the plaintiff.
Please.
1 and 2 rejected, MA rejected.
Yes, my lordship.
Then what?
ಸೀನಿಯರ್ ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಹಾಕೊಂಡು.
I am in possession, my lordship.
ಟುಮಾರೋ.
You are in possession.
Yes, my lordship.
Status quo ಇದೆ ಇಲ್ಲಿ.
ಅಲ್ಲ, ನಮ್ಮ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಎಲ್ಲ ಆಗಿದೆ ಸ್ವಾಮಿ. We produce the photographs, statement of objection. You filed statement of
Who are
objection.
sued for?
Permanent
injunction.
Finally, list the matter on 23rd. It's made clear no further adjournment will be granted in the matter. Interim order subsisting will continue till the next date of hearing. Difficult.
Please.
Yes.
For the petitioner, my lord. Suit is one for declaration as well as consequential relief of injunction. Initially, we filed an application stating that the court fees which was paid was insufficient. Thereupon, my lord, the trial court passed an order, my lord, that the court fee so paid is insufficient and directed the plaintiff to file to pay the necessary court fees. My lords may find that order, my lords, that ink page suit for declaration. Since the properties were coming under the municipal limits of Bangalore, the court directed
market value
market value ಕಟ್ಟಬೇಕು ಅಂತ court order ಮಾಡಿದೆ. That was not under challenge.
Where is that order?
That order, my lords, may find it at Annexure N, my lords, ink page number 117. The operative
Market value of that day or date of filing the suit?
As on the date of filing of the suit.
All right.
Plus,
ಈಗ ಏನಾಗಿದೆ?
thereafter, my lords, they paid a court fee of 1,26,000. We again objected, saying that the court fee is insufficient.
You serve on the council.
My lords, until then, my lords, let there be an order of stay, my lords.
Why, sir?
My lords, for this reason,
Why
now
should it
without
be?
paying the court fee, my
We'll
lords, the
see.
plaintiff is
Who is the
proceeding with the
contesting?
suit.
Who is the contesting? All plaintiffs.
Yes, my lords.
Petitioner to serve on the council representing the plaintiffs before the concerned court and file an acknowledgement of such service by the 18th. List the matter on 23rd and preliminary hearing.
My lords, until then, let there be an order of stay.
No,
my
sir.
lords.
Yes,
My
next.
lords, for this reason, my lords, now without paying the court fees, my lords,
Next Wednesday. Yes.
my lords, it may be taken up in the fresh matter.
Only in preliminary hearing. Yes.
For petitioner, my lord.
The
respondent number one.
The respondent number
R1 to R3, new appearance.
To R2, I may permit to file wakalat.
Learned Counsel V. Rangaramu undertakes to enter appearance for R1 to R3.
Only R1 and 2. 1 and 2.
1 and 2 matrana. R1 and R2. Registry to print the name of so and so is appearing for R1 and R2. Yes, next.
Interim order may be extended.
Objections ಆಗ್ತೀರಾ?
ಇಲ್ಲ, ನನಗೆ regarding the framing of the issues, additional issues they have failed. I look into it, I'll find, if anything is there, I will.
List the matter on 30th. Interim order subsisting will continue till the next date of hearing. Next.
Any date may be good.
30th. Heard the petitioner in person. There is no representation on behalf of the Respondent list on
My
30th.
Lord, I'm appearing for respondent.
Why are you on
seek
VC?
4 weeks. My Lord, senior is traveling, seeking 4 weeks time to file the statement of objections.
Senior is traveling, where are you?
I am with the senior, my Lord.
People, sir.
It has been 1
My
month.
Lord, petition is quite voluminous. We
They don't
seek
dare
4
leave-
weeks time to file the
not
statement of objections.
The evidence, my lord.
Stay ಮಾಡಿಲ್ವಾ ನಾನು?
Stay ಮಾಡಿದ್ದೇವೆ,
ಮತ್ತೆ ಇರಿ.
but
Yes.
I'm,
List the matter, list the
Sir,
matter
stay
on,
ಆಗಿದೆ.
list the matter on 6th August finally. In the event the objections are not filed by then, it would be construed that there are no objections to the petition. Yes, interim order subsisting will continue till the next date of hearing.
Obliged,
Next.
my Lord.
For petition.
Non-filing of
notes,
acknowledgement.
We have filed it, my lords, yesterday.
ಏನಿದೆ ಎಲ್ಲ ಬಿಡಿ ಏನು ಅಲ್ಲ ಜೇಮ್ಸ್
Format is not filed.
learned counsel ನೀವಿದ್ದೀರಾ?
ಇಲ್ಲ, maybe removed, my lord. GA has been served. It is showing as GA. So it can be.
Registry is directed to delete the indication of GA being served. The learned counsel submits that the order dated 36/20/25 has been complied with. List on 23rd.
Right of cross-examination, my Lord.
Pass over them.
By the day before yesterday.
Or day yesterday.
What is under challenge?
Right of cross-examination. What
Oh,
is-
that can't be. Pass over.
Pass over.
That can't be taken away. Adverse inference.
That's right.
Oh, no, sir.
And judgments are not.
Judgments what?
My Lord had asked me to bring
Correct.
some judgments on when adverse inference.
Which court has defined what is adverse inference?
No, except in Supreme Court in Ibrahimuddin says when it can be raised only after consideration of evidence at the end of trial. That's all.
Yes.
I'll be.
ಬೇರೆ ಯಾವ್ದಾರು ಇದೆಯಾ ನಿಮ್ಗೆ? You have any other matter here?
No, I have. I'm around.
No.
I'll be around.
Yes, Rajeshwar.
That's response counsel is present, my lords. My only difficulty is small property. They thought they'll buy their share by paying the other two shareholders. Somehow
Partition.
Partition.
Final decree
Final
proceedings.
decree proceedings.
FDP.
Last time ತ ಹೇಳಿದ್ರೆ ಅವ್ರು ಬರ್ಲಿ ನೋಡಿ ಸೆಟಲ್ ಮಾಡ್ಸೋಣ ಇಲ್ಲೇನೆ ಅಂತ.
I'll talk to my clients. I told him also.
Shivkumar sir idre, you will definitely get some.
No, I know Mr.
Both the learned counsel for the petitioner submits that the issue can be settled if the respondent should come forward. Counsels for the parties would submit that they would explore the possibilities of the settlement. 10 days time code left.
Please,
List the matter on 6th August. Settlement, if any, be reported by then. Till such time, the FDP let it not move forward.
But we are not going to precipitate.
The learned counsel undertakes that.
Order for appointment of a court sale, public sale auction gate.
Public sale, my lord, we will not conduct.
The sale, the auction shall not be conducted till the next date.
Yes.
ಎಲ್ಲಿ ಇವರು ಬೆಳಿಗ್ಗೆ ರೇರಾ ಮೈಂಟೈನಬಿಲಿಟಿ ಮತ್ತೆ ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Serial number 58 is.
ಕರೆಕ್ಟ್, ಅದ್ರ ಜೊತೆಗೆ ಇತ್ತಲ್ಲ.
Madam, this may be tagged along with.
ಪಾಸ್ ಓವರ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ. There are connected, there are two connected matters, my lords.
It may be posted on Friday along.
Same submission?
Same submission. Very same problem.
Same date.
Much obliged.
Friday.
Much obliged.
ಮೇಡಮ್ ಅದು ಸೀರಿಯಲ್ ನಂಬರ್ 58 ಜೊತೆ ಟ್ಯಾಗ್ ಮಾಡಿ ಲಿಸ್ಟ್ ಆನ್ ಅದು ಆಲ್ರೆಡಿ ಫ್ರೈಡೆಗೆ ಹಾಕಿದೆ.
79. In this matter, lords,
39, 1 and 2 rejected.
Rejected, affirmed. But the point is
Rejected,
this,
affirmed
by the first appellate.
ಮತ್ತೆ ಇದು 79.1
ಎರಡು ಅದ್ರ ಒಂದು 39, 1 and 2. One is 39, 4. We filed for discharge. It's the same thing. Concurrent finding. It's all right. The question is this. Earlier, lords, he had filed a suit for partition in respect of these properties. There was a compromise in which the suit scheduled property fell to the share of the brothers who have sold the property to me. After that, the second suit is filed. That is the question, Lord, which would fall for my lord's kind consideration. Clear the decree, Lord. I'll show. trial court records has been filed along with a separate memo.
Trial court records ಬಂದಿದೆಯಾ?
It is filed
Along with a memo.
Filed.
Copy is not.
Huh?
Copy is not.
Copy.
Now, suit for partition is decreed.
No.
Earlier, it is decreed by way of a compromise.
All right.
In which this property against which injunction, which has been sold to us now. In 2023 for a valuable consideration of 2 crores, after executing a power of attorney, that for that suit, my lord, he has filed an injunction. Earlier, for this very property, he had filed a suit for partition among his brothers.
This was not the subject matter, suit schedule property in partition.
This was the suit schedule property which fell to the share of the other brothers who have sold the property to me. That is the question.
Who are you, other brother?
No.
Then
I am the person who is plaintiff before the trial court.
ಅದು ಯಾರು ಅಂತ ಹೇಳಿ.
Brother,
one of the
Family member of the suit for partition?
Please.
All right, yes.
May I point out?
My lords.
One minute. Problem, sir, 1 minute. Now,
Please.
this particular property which you seek injunction of
Please.
was a subject matter or the suit schedule property in the partition.
Please.
To whose share did it fall?
It stands in the name of 3 brothers, my lords, including the plaintiff before.
That is the decree?
No, yes, my lords.
That is the decree of partition that stands in the name of 3 people?
Please.
Is that so?
Yes, my lords. Compromise petition also says that. And also, my lords, decree says that.
Compromise petition says what?
It says, my lords, this particular property, the 17 by 2P, that should stand in the name of 3 brothers, my lords, including the present plaintiff.
Now, who has sold it?
My brothers, my lords, and my father, who had executed my lord's sale agreement and also GPA. He passed away, my father passed away. Then GPA holder executes sale deed in his own favor, my lords.
Correct. That is after your father passing away or before?
After passing.
Then
Much after passing.
GPA is of no the validity of GPA goes once the executor dies.
Coupled with interest.
Coupled with interest, that is very contention.
It was coupled with interest. But
tested
may I
with-
point out page 133, my lord. This submission is contrary to the records. All this-
Clarification ಬೇಕಾಗಿದೆ. I have taken.
Alright.
Yes.
Page 133, my lords, in the trial court records.
Yes, sir.
But this property is 17/2, my lord. 17/P3, 133, page 1.
I am there, sir.
Left hand side.
133 statement of objections.
133 of the trial court records. Madam, court of trial court record.
133.
Yes.
Yes.
Lordships will kindly see, the below mentioned property has been allotted to 2 sons, namely Narayana and Nagesh, children of late Munish Ramappa with equal right. The persons who have sold are Narayana and Nagesh. He is Chandrasekhar. Now what they do, take advantage is.
ಅಲ್ಲ ಇಲ್ಲಿ ಚಂದ್ರಶೇಖರ್ ಹೆಸರೇ ಇಲ್ಲ.
ಇಲ್ಲ. Now what they do is, this property was initially not podi ಆಗಿದ್ದಿಲ್ಲ. Till podi is done, our 3 ಹೆಸರಲ್ಲಿ revenue records ಇದೆ, continue ಆಗುತ್ತೆ ಅಂತ there is a reference. For that they say it belongs to all the 3 of them. That lordships will kindly see next page 134.
No, I want to see the final decree. Where
The final decree always, please kindly see. That is there. This is a compromise memo. Final decree also.
Final decree drawn on the compromise.
It records at page 169. Kindly see page 180.
160?
169 is the final decree.
180 is it?
180. Below mentioned property has been allotted to.
ಎಲ್ಲಿ ಹೋದ್ರಿ 180?
180 only.
I am at 180.
After 16, serial number 16 ಆದ್ಮೇಲೆ.
Don't have page numbers also. That's a
180. Ink
Serial
page
number
number
16.
180.
I am at page 180. 180 is like this.
In my dosmas, there is no page number at all.
No, in trial court record.
ಇದು ಯಾವ್ದಿದು?
ಅದೇ ತಾವು ಓದಿ ಇಟ್ಟಿರ್ಬೇಕು.
ಮೇಡಮ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ, ಬಂದಿಲ್ಲ. ಇವ್ರು ಮೆಮೊ ಹಾಕಿದಾರಂತಲ್ಲ.
Along with memo.
Along with memo.
ಇನ್ನೊಂದು ಕಾಪಿ ಇದೆ.
ಕೊಡಿ ಅದ್ರಲ್ಲಿ.
This I'll find. Decree. Extra copy. But lordships get that page 180 I have pointed out.
The below mentioned property has been allotted to 2 sons.
allotted to 2 sons, namely.
What is that below mentioned property?
The property number, lords, that is.
It is not in dispute that it is the subject property.
That is not in dispute. Once, otherly lordships will get that 117 is it? 17 part, that lordships will get number at serial number 2. Now, what they take advantage, my lords, is there is a reference that till the podi happens, all the 3 numbers.
Where is that?
That is at next serial number 2.
Land in survey number.
As the said property is portion of larger extent of land in survey number 17, which is not yet coded. As such, all the three male children, Munishamappa, Narayana and Chandrasekhar and Nagesh, are decided to continue the revenue entries in respect, because this only, it was a larger extent, all the three names are, but specifically decree records that these two, this property shall fall to the share of Nagesh and Narayanappa. And thereafter,
So who has sold the property to you now?
this Nagesh and Narayan, father and other sons, except himself. But there are two persons. One is they have sold it and now they have set him up. Or he has after and the order 23 rule 3A bars a fresh suit if you want to contest this compromise decree. Now what the Honorable Supreme Court says is, by clever drafting, though you do not seek setting aside the this decree, but in effect, in order to give relief for him in the suit which has been filed for setting aside that sale deed in our favor, the court may have to interfere with this compromise decree, which has to go back to the same court. Now, I have paid consideration of 2 crores. I have taken possession. I'm in the midst of construction. Now, at this stage, this suit is filed.
Lords, in that, my lords, there is an earlier petition, suit filed between my lords, my father and my lords, his cousins, my lords. That suit came to me, my lords, compromised after 7 years of litigation. After that compromise, the property fell to the share of my father, my lords. Then my father treated it as a joint family property, my lords. Then leaving me, my lords, all other sons and my father execute, my lords, sale agreement and also, my lord, GPA. After that, my lords, I filed a suit.
Show me in the decree,
please, my lords,
that this particular survey number 17 fell to your share.
The only assertion is, my lords, all the revenue records
Fell to your share.
No, so it stands in the name of all three sons, my lords. That's
No
the
problem.
only.
Continue the revenue records.
Please, my lord. That's the only assertion, my lords, in the whole.
Sir.
Even then, my
Again,
lords, that's all.
My lords, again.
Between parties, my lords.
The injunction has been granted against, we are in possession since 2000.
No, possession is with me because I'll demonstrate
We
on
have
the
paid
records, my
consider-
lords.
taken
First
possession by virtue
appellate
of
court
sale
has rejected the appeal.
appeal.
First
On the
appellate
ground
court-
that all are tribal issues on the health. They don't go into
First
the
appellate
question
court
at
only
all.
says, my
One
lords,
second, sir.
all issues are tribal, my lords. And
Every-
suit is still pending, my lords. And all that we are
But
asking,
I am
my
in
lords, as on
possession.
today, let them maintain, my lords. Well, their contention is they have taken possession through the sale deed, my lords. Sale deed was executed after
But
filing a suit.
in
my
all
lords.
fairness, I want to make one submission. 1 second. But I have paid 2 crores for the 5 brothers. I am on instructions. I will deposit about 50 lakhs rupees at best. That will be the value before the trial court. It is not that we want to use it. Subject to the result of the suit. We are ready to deposit 50 lakhs rupees also.
So I will show two, my lords, 2 paragraphs in the sale deed, my lords, what they have produced, my lords. I will just read that, my lords. Not sale deed, they say, my lords.
ಈಗ ಅದು ಪರವಾಗಿಲ್ವಾ ಇಲ್ಲ ಡೀಟೇಲ್ ಆರ್ಡರ್ ಮಾಡ್ಲಾ?
My lords, I will just read that after that, my lord, what falls from my lords, my lords.
ಎಲ್ಲ ಸೇಲ್ ಮಾಡ್ಬಿಟ್ಟು ಸುಮ್ಮನೆ ಮತ್ತೆ
Not me, my lords. Leaving me, they have executed, my lords.
Family has sold it now. I don't want to
Leaving
say
me,
anything more.
they have executed. Now the brother says, my lord, I am entitled to 1/6 share.
I will consider. Yes. The heard the learned senior counsel Prabhuling
Let them
now.
deposit, my lord. Let at least some
Yes.
prayer.
Deposit.
The learned counsel, the petitioner heard the learned senior counsel Prabhuling Nawadgi and so appearing for the petitioner. The learned senior counsel takes this court through the documents appended to the petition. Will dispose it, Hangadre?
Please.
Madam, final order. Learned senior counsel, the issue that brings the petitioners before this court is the rejection of an appeal filed in MA 28 of 2024, whereby the order of declining to grant temporary injunction in OS 868 of granting temporary injunction in 868 of 2023 comes to be affirmed. Therefore, the defendants are before this court on a concurrent finding by both the trial court and the first appellate court. The learned senior counsel for the petitioner takes this court through documents appended to the petition to demonstrate that the property that fell to the share of the vendors of the petitioners have purchased the property. The learned counsel for the respondent submits that the compromise is entered into, leaving behind the plaintiff now, and all the revenue entries still stand in the name of all the 3 children. These are matters which have to be tried before the concerned court. The learned senior counsel would now offer that he would deposit 50 lakh rupees before the concerned court to demonstrate his bona fides. In that let status quo be maintained then.
No, that the order has to be set aside. The order
In
of
that case,
50
my lords,
lakhs. No, once
they
the
will sell
order-
it to third parties, my lords. All that, my lords,
You
trial
want-
court and also the first appellate court.
No,
have
no,
said
I
it.
am not with
Then
the.
we'll
If it goes
answer,
to third party,
properties are no
we'll
use to-
answer on its merit
Please, please.
better.
it will be difficult, my lords. It goes to third party.
Now also it's difficult for you.
No,
We'll
sale-
answer it
sale
anyway.
deed, my lords.
Yes.
No, no,
say,
they
my lords.
want to, my lord, with this injunction, conduct a ransom litigation. I do not want to say anything more than that.
No, every suit is
litigation
ransom.
ransom is.
Every
Okay.
builder will come and say that, my lords, all the my lords.
No, don't worry, I'm not swayed by that.
No, I'm absolutely.
Yes. Ashana?
Yes.
I will pass orders on Friday.
No, my lords,
Friday
in the
badwa?
sale deed, my lords, I will read 2 paragraphs, my lords.
Alla, Friday badwa?
Please.
Friday bad. Yes. We'll list it on Fridays.
Further.
Further hearing in Friday.
I request them to, my lords, provide a better copy, my
Hearing
lords.
on
There is no,
Heard so and so, ಏನು order ಬೇಡ.
there are no page numbers, nothing in this, all jumbled
ಕಾಪಿ
up.
ಕರೆಕ್ಟ್ ಆಗಿರೋ ಕಾಪಿ ಕೊಡಿ, ಯಾಕೆ?
Jumbled up.
Entire trial court, trial furnish it.
Watch.
ಪೇಜ್ ನಂಬರ್ ಇರೋದು ಕೊಡಿ. Bid and hammer.
Okay, for the petitioner, my
Ah.
lords. My lords, we got a favorable interim order on 28/3/2025. Now, we announced an auction on July 11th. So one of the orders that we've got from Google is they have to remove about 68 links from their index. We tried advancing the matter in May. The learned trial court judge refused to take our advancement application. We had to wait through the vacations. We advanced it again in June. And finally, it got advanced on 12th June. 1 month was given just for them to file wakalat and objections. We wanted the links to go off because the kind of art we sell is all about history and a lot of expensive art, my lords. So people who bid as well, they check the authenticity of each art. Now, these links that were surfacing on Google were really hurting our business, and we've not been
Why,
able to.
what kind of links were they?
So there are some newspapers that put fake articles about us, about the paintings, and there are several defamation cases that we've filed against them. But primarily the issue we have with Google per se is that first, anybody who wants to do any search.
Is there an order already by the court?
Oh, my lords. So what happened is thereafter we
We'll direct the
filed.
court to consider the application, pass
But the
orders
problem
within.
with the trial court judge so far is the trial court judge is playing a mediator's role. She's
Don't
telling,
worry, I will direct him to pass an order within 15 days.
please, my lords.
That's all.
Please, my lords.
ನೀವು ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
Wakalat, I'll file my lords.
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀರಾ?
In the trial court, I have filed my lords.
ಹಾ. ಇಲ್ಲ ಅಲ್ಲ ಸರ್, ಟ್ರಯಲ್ ಕೋರ್ಟ್ಲೆ ಕೇಳ್ತೀರಾ?
Yes, my lords, I am contesting this.
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀರಾ?
Objection ಹಾಕಿದೀವಿ, I have
The
also
court will
complied.
decide the application immediately. Yes.
Please.
That's all.
State from my
The application is contempt petition, so it may require.
Whatever application is there in accordance with law, court will decide. You have anyway contesting it.
Please, and I have also complied.
Early disposal ಅಷ್ಟೇ ಕೇಳಿರೋದಿಲ್ಲ.
ಅಷ್ಟೇ.
Yes. The petitioner is before this court seeking the following prayer. The petitioner is the plaintiff. Institutes a suit in OS 7269 of 2015 seeking injunction, na?
Please, my lords. No, it's a definite, yes, mandatory injunction and injunction,
And
permanent injunction. So it's a variant.
seeking mandatory injunction against the respondents, restraining them from publishing
of broadcast.
several links as indicated in the order. The suit is decreed, is it?
Suit is
Suit is
not
pending.
decreed, my lords. I number 8 and I number 9, which are injunction applications, came to be allowed.
All right.
So far as I number
In
8
in
is
the said
concerned-
suit, the applications filed for injunction is said to have been allowed. Despite the allowing of the application, it is the allegation of the petitioner that the respondent Google LLC is publishing those links which are detrimental to the interest of the petitioners. The learned counsel would submit that the petitioner has filed an application, miscellaneous petition in miscellaneous petition 618 of 2025 under Order 39 Rule 2A. The said petition is not being considered by the concerned court is the allegation despite the respondents entering appearance and objections hakidira.
I filed objections, they have marked documents already.
Filing objections in the light of the aforesaid prayer being only for an early disposal of the miscellaneous petition 618 of 2015, I deem it appropriate to dispose the petition with a direction to the concerned court to conclude to pass appropriate orders in miscellaneous petition 618 of 2025 within an outer limit of 4 weeks from today, if not earlier, and if not already passed,
Great.
ordered accordingly. Yes.
Great. For the petitioner, my lords. Lords, yesterday, my lords, we have filed an affidavit that the council, there was an order passed by this honorable court on 7/7, my lords, to directing us to furnish a copy of the petition to the advocate appearing on behalf of the respondent before the trial court.
Sir.
Alla, ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ, they have refused. To that effect, I filed an affidavit. It is not
Affidavit
put up to
ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀವಿ.
The learned counsel for the petitioner submits that the respondents have refused acceptance of notice. Therefore, the registry is directed to print the name of the respondent and show the said respondent as served. Again, problem ಆಗಿದೆ.
My lords, now, my lords, what has happened is that the
Interim order ಏನ್ ಕೇಳಿದ್ದೀರಾ?
Alla, interim order is to stay the entire proceedings before the trial court.
What is the order under challenge?
Order under challenge, my lords, is at ink page number 54, my lords.
What is that?
My lords, they had filed an application seeking to examine the plaintiff through their GPA. My lords, what happens is this, my lords, there was a pontiff to the plaintiff. That pontiff expires.
Pontiff to the plaintiff.
Yes, my lords.
Oh.
So that pontiff passes away. Thereafter, my lords, a new pontiff gets appointed. That pontiff, my lords,
New pontiff to the plaintiff.
Yes, my lords.
You don't like him?
Alla, ಏನಾಗುತ್ತೆ, that pontiff, he appoints another entirely a new GPA holder.
Oh,
Initially, it was one person. The second time, my lords, it's another person.
If you appoint a new pontiff to the plaintiff, he will appoint a new GPA only.
My lords, for a GPA holder to come and give evidence, my lords, he should have personal knowledge, my lords, in regard to the matter at hand. My lords, he is a person, my lords.
ಯಾವ ಮಠ ಸರ್ ಇದು?
My lords, ಶಿರೂರ್ ಮಠ, my lords.
ಈಗೇನ್ ಬೇಕು? ಆ GPA ಹೋಲ್ಡರ್ ಬೇಡವಾ?
ಬೇಡ.
ಬೇಡ?
Because the ಹಳೆ GPA holder, he had been examined already.
ಏನ್ ಇಂಟರ್ಮ್ ಪ್ರೇಯರ್ ಕೇಳಿದ್ದೀರಾ? ಫುಲ್ ಪ್ರೊಸೀಡಿಂಗ್ ಸ್ಟೇ ತಗೊಂಡು ಏನಾಗಬೇಕಾಗಿದೆ ನಿಮಗೆ?
My lords, ಇಲ್ಲ ಅಂದ್ರೆ it's at evidence stage.
We'll see. We'll give one date. List the matter on 23rd. In the event they don't appear.
18th, my lords, is the matter set down at trial court.
Take adjournment. You say your pontiff of the plaintiff is not available. Yes. Next.
Appearing for plaintiff in this matter, petitioner in this matter.
The previous occasion, they produced this document, Supreme Court. There, my lords, the issue there was nothing to do with this suit or the suit we are saying that they are a part of, my lords. What happened there was an interstate dispute, which we were not a part of, an interstate dispute between.
What is that you have sought?
Sir, they have sought to challenge the order.
Wait, sir, his guess.
Lordship, I have challenged the impugned order, IA allowing the application filed by the respondent number 1 to 14, Lordship, under order 1 and order 1, rule 10.
What's wrong with that?
Lordship, it is already adjudicated before the Supreme Court. The petitioner.
Supreme Court.
Supreme Court ಅಲ್ಲೇ ಆಗಿದ್ದು ಸ್ವಾಮಿ ಇದು.
ಏನಂತ?
ಇದು ಏನಂತಂದ್ರೆ petitioner is the fourth respondent in one night.
ನೀವು ಇಷ್ಟೊತ್ತು ಕೂತಿದ್ರಲ್ಲ, ಓದ್ಕೋಬೇಕು ತಾನೆ?
Lordship, kindly come to the page number 3 of memo, Lordship.
Memo?
They gave a memo on the
memo along with the document.
Because I had not been served, your lordship.
Serve everything on him.
Last date served.
I've looked at it, my lords.
Lordship,
it's an interstate dispute, my lord. What happens? They file an application before the BDA.
Lordship, this application, this petition is filed after the recent days, Lordship.
Recent what?
Recent means 24, in the year 2024. It is already adjudicated before the Supreme Court.
I am not even referring to that. He's talking about an acquisition matter that is pending before your lordship. There are 4 different litigations.
Which is pending before?
Lordship, it is simply filed, Lordship.
33172 of 2024.
Let's tag this petition along with so and so. List them both on Wednesday, 23rd. So both company, Purti.
Everything is covered in that.
Yes, Prakash.
This is amendment, my lord, of written statement. I am plaintiff before the trial court. It was heard, my lord, for
I know, that's what.
last occasion. My lord, the two things, my lord. The one is that, my lord, after commencement of the trial. my lord,
After framing of the
application is
issues and before framing of the issues. In ಯಾವ stage?
made. Now, my lord, after suit was posted for defendant's evidence, my lord, this application was made
By them.
by them. My lord, there are two grounds, my lord. I
That
have
is now allowed.
It was allowed. My lord, two grounds were urged. First one
No,
is.
I heard you on the last.
Yes,
occasion.
yes. Lord, I pass on this judgment. Lord,
Nande ಇದೆ ಕೊಡಿ.
Your lordship judgment, para 7, your lordship considered this proviso, the effect of proviso. And my lord, the ingredient, my lord, the.
ಅಷ್ಟೇ. ಇನ್ನೇನು ಇದೆಯಾ?
Amendment is only with reference to the order of the government, which according to them has granted conversion, but that is not the fact. And page number 116 annexure F.
Amendment ನಿಮ್ದಲ್ವಾ ಹಾಕಿರೋದು?
ನಾವೇ ಹಾಕಿರೋದು.
ಹಾ.
Amendment now sought for is to incorporate that the government has directed the deputy commissioner to grant conversion. The government has not granted conversion. 1997, the plaintiff.
When did you apply for conversion?
No, I have not applied for conversion.
ಅವ್ರು apply ಮಾಡಿರೋದು.
97 97 sale has taken place. After 22 years, suit has been filed. Page number 52, as you can see. This is the ground on which the suit is based. That the person who has been sold the property fraudulently, illegally, without authority of law. Now, the amendment is sought for is that while directing the deputy commissioner for conversion is sought to be incorporated in place while passing the order of conversion. Secondly, that.
ಅದರಲ್ಲಿ
No, my lord, your lordship
what
kindly
is
see.
going to happen in that?
My lord, page 89. My lord, in that judgment, my lord, your lordship considered, first thing is, my lord, that amendment is necessary for the adjudication of matter in issue. Kindly see page 89. Whether it is agricultural, non-agricultural, it doesn't have, my lord, any effect on the merits of the case. My lord, I wanted sale deed to be, my lord, declared as null and void.
Null and void.
Null and void. My lord, according to me, that the president of the plaintiff society sold it without authority. No, page 89, my lord, issues.
Why did you take 22 years to challenge it?
My lord, he was in the affairs of that society. I didn't know that. My lord, this is.
Who are you?
My lord, now we are, my lord, the new committee, my lord, elected, and we have taken charge. Thereafter we come to know.
ಈಗ 22 ವರ್ಷದಿಂದ ಅವರು ಮಾಡಿ
Nothing, my lord, land is in our possession.
ಅಲ್ಲಲ್ಲ, you would have set up everything in that land.
Nothing,
ನಿಮ್ಮ
my
ಹಳೆ
lord,
ಕಮಿಟಿ
nothing.
ಮೇಲೆ
My
ನೀವು
lord,
ಹಳೆ
nothing
ಕಮಿಟಿ ಮೇಲೆ
happened.
to develop an axe to grind, can you punish him?
No, my lord, it is in our possession. Even now, no improvement, no development is made. Still there, page 89, your
But
lordship.
there is already a sale deed.
Sale deed is there, my lord. Sale deed is, my lord, without authority. My lord, it is a society land. My lord, the government, my lord, we have purchased the land with
ಈ
the
ತರ
permission.
ಆದ್ರೆ ನೀವು ಅರ್ಲಿಯರ್ ಏನೇನ್ ಮಾಡಿದ್ರು ಅದನ್ನೆಲ್ಲ ಅನಲ್ ಮಾಡಕ್ ಹೋಗ್ತೀರಾ?
My lord, that is the merits of the, my lord, ultimately the court may have to, my lord, decide all these things, whether suit, there is an issue framed. My lord, your lordship kindly see page 89, issues are framed. The one of the issues is that whether the suit brought, my lord, is within the period of limitation or it is, my lord.
Let the court decide.
That is there, my lord. My submission is this amendment, my lord, which is made after 5 years after framing of issue.
ಅಯ್ಯೋ ಸೂಟ್ ಹಾಕಿರೋದೇ 22 ವರ್ಷ ಆದ್ಮೇಲೆ.
ಮತ್ತೆ? There is no, my lord, there is no merit, my lord, in the written statement, in the amendment to the written statement. My lord, I rely upon two judgments. My lord,
ಅಯ್ಯೋ
one
ಕೊಡಿ,
is-
give sir. ಎಲ್ಲ facts upon
ಕೊಟ್ಟಿದ್ದೀನಿ.
each facts, each case.
My lord, facts, my lord, will be, my lord, cannot be
Always different.
identical in all.
Always different.
But principles we have to apply, my lord.
Principles square the
Yes.
facts,
Yes,
not
my lord.
dehorse the facts.
My lord, kindly see page.
ಇದರಲ್ಲಿ though I myself felt that it cannot be done, due diligence
No, no.
ಈ ಕೇಸಲ್ಲಿ ಬರ್ಬೇಕು.
No, in this case, my lord, PW 1 and 2, my lord, cross-examined at length extensively,
No,
my lord.
sir.
And the written statement, my lord, runs into
ಹೊಸ
24
ಕಮಿಟಿ
pages.
ಬಂದು 22 ವರ್ಷದಿಂದ ಆಗಿರೋ ಸೇಲ್ ಡೀಡ್ ಎಲ್ಲ ನಲ್ ಅಂಡ್ ವಾಯ್ಡ್ ಅಂತ ಕೇಳ್ಕೊಂಡು ಅವರೆಲ್ಲ ಹೋಗ್ಬೇಕು. ಅಮೆಂಡ್ಮೆಂಟ್
Nothing
ಮಾಡ್ಲಿ
they have
ಬಿಡಿ.
not done, my lord. If
Amendment
suppose-
ಮಾಡ್ಲಿ ಬಿಡಿ.
No, suppose, my lord, they have made some
Sir,
development
you
or
new
something
committee
like that, I
members,
understand.
new committee members will always have an axe to grind against the old committee members if they are continuing for long time. ಅವ್ರು ಅದೇನೇನೋ ಮಾಡಿರ್ತಾರೆ, ಯಾರಿಗೋ ಮಾರಿರ್ತಾರೆ, ಅದೆಲ್ಲ ನೀವು null and
Nothing,
void
my
ಅಂದ್ರೆ?
lord. They are filed return statement and nothing happened. No third party right is created. No development is made. Lands are, my lord.
Anyway, that is the suit, let it go on.
My lord, one.
Amendment, also let
My
it go
lord,
on.
I read once,
Yes.
once, para 7, my lord.
Yes, sir.
My lord, in the.
ಗೊತ್ತು ಸರ್, ಹೇಳಿ. ಜಡ್ಮೆಂಟ್ ತಾನೆ
ಕೊಟ್ಟಿದ್ದೀನಿ.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್.
ಹೌದು.
Correct.
ಒಂದೇ ಒಂದು ಪ್ಯಾರಾ.
ಹೇಳಿ.
In the present case, the civil judge has not returned any finding that the court is satisfied that in spite of due diligence, the party could not have raised the matter before the commencement of trial. In so and so, this court observed in para 19 as under. It is the primal duty of the court to decide as to whether such an amendment is necessary to decide the real dispute between the parties. Only if such a condition is fulfilled, the amendment is to be allowed. However, proviso appended to the Order 6 Rule 17 of the court restrict the power of the court. It puts an embargo on exercise of jurisdiction. The court's jurisdiction in a case of this nature is limited. Thus, unless the jurisdictional fact as envisaged therein is found to be existing, the court will have no jurisdiction at all to allow the amendment of the plaintiff. My lord, here, my lord, there is no such explanation about the exercise of due diligence, my lord, in applying for return statement earlier to, my lord, commencement of the trial. The learned judge also did not apply his mind whether this, my lord, due diligence exercise is there or not. My lord, therefore, these two conditions must be fulfilled, my lord, to allow an application for amendment, that too after, my lord, trial in the suit is commenced. My lord, I also, my lord, add that the judgment, my lord, delivered by my lord. Para 7, para 7.
14 ವರ್ಷ ಆದ್ಮೇಲೆ.
No, what your lordship.
ಅದ್ರಲ್ಲಿ 14 ವರ್ಷ.
No, my lord, it your lordship, it is not said 7, kindly see.
Sir, 14 ವರ್ಷ ಆದ್ಮೇಲೆ.
No, your lordship said.
The facts ಇದ್ದಿದ್ದೆ 14 ವರ್ಷ ಆದ್ಮೇಲೆ.
Correct. ಆದ್ರೆ ಅದು 14 ವರ್ಷ ಎಲ್ಲಾ ಕೇಸಲ್ಲಿ 14 ವರ್ಷ ಅಂತ ಹೇಳಿಲ್ಲ ನೀವು.
ಎಲ್ಲಾ ಕೇಸಲ್ಲಿ 14 ವರ್ಷ ಇರಕ್ಕಾಗತ್ತಾ? What is all this?
What your lordship said.
Primary duty of the court to decide such an amendment is necessary to decide the real dispute between the parties.
This is not.
Now I'll tell you one thing.
Yes.
For his defense, everything becomes necessary because 22 ವರ್ಷ ಆದ್ಮೇಲೆ you sought to non-suit him.
Yes.
It is necessary and necessary. Anything else?
Filed, my lord, 28 pages written statement.
No problem, sir.
And additional written statement.
No problem, sir. 22 ವರ್ಷ ಅವ್ರು ಕವರ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ 28 ಪೇಜ್
Cross examination of PW1, my lord, for 2 years, my lord, they are cross examined.
We will permit one more year, sir. 22 ವರ್ಷ ಆದ್ಮೇಲೆ ಸೂಟ್ ಹಾಕ್ಬಿಟ್ಟು ಸೇಲ್ ಡೀಡ್ null and void ಅಂತ ಹೇಳಕ್ಕೆ.
Yes, my lord, 22 years.
There should be some
limit. We
limit.
have explained. 22
no,
years
sir.
we have explained.
How is it even entertained? I don't know. Yes. ಒಬ್ಬ ಹೊಸ ಕಮಿಟಿ ಬಂದು ಹಳೆ ಕಮಿಟಿ ಮಾಡಿದ್ದೆಲ್ಲ ಸ್ಟಾರ್ಟ್.
No, it is not like that.
No, it is like that only. ಏನ್ ಮಾಡಿದೀರಾ ಮತ್ತೆ?
My lord, it is a society.
No, I will permit him all defense, sir.
My lord, what happens,
sir?
sir?
22 years ಇಂದ ಯಾರೋ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಂಡು ಅವ್ರು ತಗೊಂಡಿರ್ತಾರೆ. ನೀವು ಸಡನ್ ಆಗಿ ನೀವು ಕಮಿಟಿ ಬಂದು ಅದು ಫ್ರಾಡ್, ಅದು ಸರಿ ಇಲ್ಲ.
Everything, my lord, the Supreme Court has said.
ಅದು ಪ್ರೂವ್ ಆಗಲಿ ಸರ್. ಅದಕ್ಕೂ ಅಮೆಂಡ್ಮೆಂಟ್, ಅದಕ್ಕೂ ಅಮೆಂಡ್ಮೆಂಟ್ ಗೂ ಸಂಬಂಧ ಇಲ್ಲ ಸರ್.
My lord, here, my lord, my submission is, my lord, I have examined 2 witnesses. My evidence is over.
No problem.
My lord, now the written statement, my lord, amendment is sought, it is allowed. Then, my lord, what happens is, they will recall, my lord, PW1 and 2 for further cross examination.
So what? ಮಾಡ್ಲಿ ಬಿಡಿ.
Then, my lord, it is dragged on. The suit is.
ಏನ್ 22 years ಇಂದ 22 years ಆದ್ಮೇಲೆ ಹಾಕ್ಬಿಟ್ಟು ಒಂದು ವರ್ಷ ಡ್ರ್ಯಾಗ್ ಆನ್ ಆದ್ರೆ ಏನೀಗ? Yes, anything else? The petitioner is the plaintiff, institutes a suit in OS 234 of 2018, seeking the following prayer. The prayer that is sought is to declare a sale deed that had taken place 21 years ago.
I'm sorry,
Alva.
A memo. I have got a right under section 105 of CPC.
ನಾನೇನ್ ಹೇಳ್ತಾ ಇಲ್ಲ.
Amendment ಬಗ್ಗೆ ಮಾತ್ರ. I withdraw the petition. I withdraw the petition with liberty to challenge. My lord, this as a ground of appeal in the event of, my lord, the decision in the suit goes against me.
Very fast.
Instead of inviting, my lord,
Yes.
Because your lordship is telling 22 years, 22 years, if it is percolated in the order also. Yes.
ನಾನು ಒಂದು 10 times ಹೇಳ್ತಾ ಇದ್ದೆ, you stopped it anyway. Yes, sir. ಇವತ್ತು ಪ್ರಕಾಶ್ ಸರ್ಗೆ ಟೈಮ್ ಸರಿ ಇಲ್ಲ.
Liberty may be.
ಅದು ಆತರ ಆಯ್ತು, ಇದು ಆತರ.
I have reached that stage.
No, no, I'm not, in the lighter way, sir. You should not mind, yes. The, ನಾವೆಲ್ಲ ನಿಮ್ ಜೊತೆ ಕಲ್ತವ್ರು. Yes. The learned counsel S.V. Prakash appearing for the petitioner after arguing the matter at length would seek leave of this court to withdraw the petition and avail of such remedy as is available in law at the appropriate time before the appropriate fora at the appropriate stage. With the aforesaid observation, petition stands disposed as withdrawn.
Lord, matter was also Lordship has heard. The amendment seeking an amendment.
Problem is I have heard everything.
Yes, my lord.
Yes.
Lord, in this case, my lord, the defendant files an application to incorporate one of the suit schedule property as one item as a suit schedule property. Lord, what has happened is in earlier suit.
617.
617. Read with section 151 CPC.
I thought always there.
Yes, my lord. And what has happened is in earlier suit, my lord, OS 12/2016, which is filed by one of the defendants. That in that suit, it was this property, this particular property shown as one of the joint family property. The present plaintiff, who was also a defendant in that case, has filed a written statement admitting that it is also a suit joint family property. Now, my lord, what has happened is after the death of the plaintiff in that suit get abated. Now, the present suit is only pending. So, I just made an application to incorporate that particular item as a joint family property in the plaint schedule.
ಎಲ್ಲ ಪ್ರಾಪರ್ಟಿ ಬರ್ಲಿ ಬಿಡಿ, ಪಾರ್ಟಿಷನ್ ಏನ್ ಪ್ರಾಬ್ಲಮ್?
Not by amendment of plaint.
ಮತ್ತೆ ಇನ್ಯಾವ ತರ?
How can he amend my plaint?
Oh, you're asking his purpose.
Please, please.
Sorry.
My lord, I have
No,
given
what
this-
happens
I have
is,
relied
I am
upon the
filing a
decision.
verifying of.
No, defendant asking the plaintiff to amend his plaint.
Because in the suit for partition.
Partition contemplates particular
I have
party
given-
amending
I
his
have relied
pleadings,
upon a
not
decision,
opponent's
my lord. I have
pleadings.
relied upon a decision. I have given a decision,
Oh,
my lord.
that
No, it is
decision
suit
is
for-
not
you
considered
are
this
saying
aspect, my lord.
partition suit ಅಲ್ಲಿ plaintiff is defendant, defendant is plaintiff.
Yes, yes.
True, my
So
lord.
one can ask the other to amend the plaint.
Yes, yes. That is what the, even the decision also says this.
That's what that decision base says. But my submission, you realize that is not a proper reasoning.
ಚೆನ್ನಾಗಿದೆ.
Because in a suit for
ಒಂದು
partition.
application ಹಾಕ್ಬಿಟ್ಟು ask the plaintiff to amend his plaint.
My lord,
I am
include
filing
one
a
of the
verifying
property.
affidavit stating that contents are
And
true.
one of the
And
property
it
as
is
a joint
against
family
my
property.
claim.
That is left out.
No, no, no.
There is no dispute
What
about that also, because they have filed a written statement. My lord, no, what has
Counter
happened?
claim ಬರಲ್ವಾ?
My lord, counter claim,
ಮತ್ತೆ?
it should
ಮಾಡಿ. Counter claim ಹಾಕಿ issue add ಮಾಡಿ ಅದ್ರಲ್ಲಿ ಅಷ್ಟೇ.
cross examination ಆಗ್ತಾ ಇದೆ.
the time of cross examination is filed, my lord. I am not
No, no,
saying that.
he
it is
knew
not
the fact
that.
in the earlier
Because-
suit itself. That is
Because
what
it
he
was
says.
not included, so when it has to be
Yes,
cross
my
examined
lord,
on that.
what has
as
happened
well.
is in the parallel proceeding, there is a direction. He is dragging on the case and the.
ಓ ಇದು
ಹೌದು.
ಟೈಮ್ ಲಿಮಿಟ್ ಕೇಸ್.
Time limit case. In fact.
ಟೈಮ್ ಲಿಮಿಟ್ ಕೇಸ್ ಅಲ್ಲಿ ಇವೆಲ್ಲ ಬರೋದು. ಟೈಮ್ ಲಿಮಿಟ್ ಇರೋದ್ರಿಂದ ಏನೇನೋ ಕೇಳ್ಬಿಟ್ಟು.
ಇಲ್ಲಿ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಗೆ ಹಾಕೊಂಡಿದ್ದಾರೆ. ಅಲ್ಲಿ ಟೈಮ್ ಗ್ರಾಂಟ್ ಆಗುತ್ತೆ.
It is
ಇದೊಂದು ರೀಸನ್
extended,
ಕೊಟ್ಟು
my lord.
ಇನ್ನೊಂದು
It is extended. Now it is 6
Yes,
months.
Harish sir.
Please.
ಕೌಂಟರ್
Millard.
ಕ್ಲೇಮ್ ಹಾಕ್ಬೇಕಾಗಿತ್ತು ಅವಾಗ.
My lord, my submission is, I rely
If you
upon a
wanted
decision.
the suit schedule property to be placed in the, placed as a
The plaint.
part of the partition, on counter claim
It's
ಹಾಕಿದ್ರೆ
by
ಬರ್ತಾ
separate
ಇತ್ತು
property,
ಅಷ್ಟೇ.
my lord.
Because counter claim is a separate suit by
But
itself.
now the counter claim, my lord, because the issues have been already been
ಮತ್ತೆ
framed.
ಅದು ಆಗಲ್ಲ ಅನ್ಬಿಟ್ಟು ಇದು.
My lord, may I make a one submission, my lord? May I be permitted to include this as a in a written statement?
No, that how
By
can that
making
be done
necessary.
ಅದೇ
here?
With
ನಿಮಗೆ
the
ಏನ್
liberty to do it.
ನಿಮಗೆ ಏನ್ ಬೇಕು ಅದ್ ಮಾಡಿ, ಆ ಲಿಬರ್ಟಿ
Liberty.
ನಾನ್ ಕೊಡಲ್ಲ.
With the liberty, because otherwise, my lord, this property will go out.
No,
To
that is my
exercise any
separate
liberty
property,
in
my
law,
lord.
sir.
My lord,
ಅಲ್ಲಿ ಆದ ತಕ್ಷಣ ಇಲ್ಲಿ ಬರ್ತೀರಾ ಹೆಂಗ್?
this decision may kindly be
This
looked.
property
Oh
was
no sir,
purchased.
I am not in agreement with this at all. Supreme Court.
That I rely upon this decision, my lord.
Supreme Court.
Not really. What?
Madras High Court
Madurai bench single
This
judge.
aspect ಇಲ್ಲ
Court of
ಸ್ವಾಮಿ.
Madras.
ಪರ್ಸುಯೇಸಿವ್ ಅಲ್ಲ.
This
Is a
aspect
para
was not
number 9, my
considered
lord,
there.
para number 9. It's case that in a suit for partition, all the
He is the
plaintiffs are
master of
defendants.
his.
My lord, that rule,
How many
general rule
status?
is not applicable to a suit for partition.
ಅದು ಎಕ್ಸ್ಚೇಂಜ್ ಆಫರ್ ಇದೆ ಅನ್ಬಿಟ್ಟು.
My lord, my response submission is, there is, because in a suit for partition, all are claiming against each
My
other.
lord, I am
So
swearing
all
the
are
affidavit
plaintiffs,
that
all are
plaint
defendants.
averments are
ಕೌಂಟರ್
true.
ಕ್ಲೈಮ್ ಹಾಕಿ ಸರ್.
My lord, counterclaim cannot be made now because.
Now it can't be made, so you want him to amend.
That is what is going to happen, my lord. It is also a primary consideration because if the property is included, even
What
the.
is going to happen? You should have thought of
My lord,
it.
my lord, what is
at the
what
outset.
I am saying is because
Submission,
if
my lord,
this.
this property
Sorry,
was purchased.
he is on a weak wicket. Wait.
I said-
Yes. Sir.
My lord, what else I'm going to submit is, what is the purpose of this amendment, my lord? It is for beneficial to all the parties because the plaintiff and
Not to
defendant.
me,
is all
not
the-
to me, it is my separate property.
that
Purchased
we
when I
can
was a
ask, my lord.
minor.
My lord, when he has
Purchased
admitted,
by the
my lord.
plaintiff
My lord,
and his
if
sister.
that being the case, my lord, may I make one more
ಅದಕ್ಕೆ
submission?
counterclaim.
Both of them are
Sir, I
daughters.
will make one more submission. The reason for rejection of this application is for the main reason that I have not filed any documents along with this application.
That is one of the
Reason,
reasons.
That
Sir.
finding is
One of the
not
reasons.
correct, my lord. Let me complete, sir, please.
Okay.
Please.
ನೀವು ಆರಾಮಾಗಿರಿ sir.
ಆಯ್ತು.
Yes. sir.
That reason is not correct because along with the application, I have
You
produced
forget
number
that
of
reason. I will not
I
take.
have also produced.
Sir, I will not take that reason into consideration. Even then I will dismiss it.
My lord, my actual submission is in the
Sir,
earlier suit.
you can't file an application seeking a direction to the plaintiff to amend his plaint.
In
You are a defendant.
in a suit, except in the suit for partition. That is my
ಇದು
responsibility.
ಬಿಟ್ರೆ ಆಗೋಯ್ತು. ಒಂದು ಆರ್ಡರ್ ಬರೆದ್ರೆ ಈ ತರ.
My lord, that may
We
decision
will
may kindly
generate
be
1,000
considered.
GMCPC cases here.
My lord, in a suit for partition,
No,
it
sir.
is not applicable.
No,
That is
no,
what
sir.
my respectful submission.
Suit for partition, if it is not applicable andre, the defendant should register a counter claim or
Lord,
whatever
that-
he wants.
that is not
If you have lost the
including-
opportunity of counter claim, now can you do this?
My lord, my respectful submission, the intention of the litigation is to end the litigation in a fair and justified
Correct.
manner.
We will
If
end this
prop-
case, I'll
if the-
mark it.
If this property is not included, no
No,
hardship
no,
would be
sir.
caused to anybody because even the plaintiff will also get a share. And in
I'll
the
work on
earlier
it.
suit, he has clearly admitted that it is a joint family property.
Further, how you want to deal with it, but I will not permit this amendment application. Anything else? One petitioner, defendant
Decision may
number,
kindly be-
withdrawn.
Sir, that decision may kindly be.
This decision.
Yes, ma'am.
Yes, sir.
Please.
File ಕೊಡಿ madam.
ಯಾರು ಅಂತ ಹೇಳೋಣ. ಅವರೇ ಹೇಳ್ಕೊಳ್ಳಿ.
The petitioner is defendant number.
Defendant number
Petitioner is defendant number 2
2.
in OS 35 of 2020. The suit is instituted by the respondents plaintiffs seeking partition and separate possession of the suit scheduled property which according to the plaintiffs are the ones belonging to the joint family. The issue in the list does not pertain to the merit of the claim of the defendant or the defense of the plaintiff as the case would be. The defendant number 2 files an application in IA 11 in the aforesaid OS seeking amendment of the plaint under Order 6, Rule 17. The amendment of the plaint that is sought, the amendment of the plaint,
Yes, please.
the said order, the said application comes to be rejected by the concerned court on the score that the petitioner has not placed anything on record or any document on record to demonstrate that it is a joint family property. It is therefore the petitioner defendant number 2 is before this court calling in question the said order. The learned counsel P.N. Harish appearing for the petitioner would reiterate the ground set out in the application to contend that in a suit for partition, the defendant and the plaintiff are on the same footing. Therefore, an application is maintainable at the hands of the defendant to direct the plaintiff to amend his plaint and would submit that documents were produced that it is a joint family property and the concerned court has erred in not taking note of the said fact. The learned counsel for the respondent would vehemently refute the submission to contend that the plaintiff is the master of his plaint and he would want the suit schedule property to be partitioned in a particular manner and has described those properties as being the joint family properties. It would not be open to the defendant to direct the plaintiff to amend his plaint as his submission. In reply, the learned counsel for the respondent petitioner seeks to place reliance upon the judgment of the learned single judge of Madurai bench of the Madras High Court, reported in 2010 4 SCC CTC 331, CTC current Tamil Nadu cases 331, to contend that an application under Order 6 Rule 17 to direct the plaintiff to amend his plaint can be filed by the defendant and the same can be allowed on the score that the defendant and the plaintiff in a partition suit are on the same footing, each of them are getting some share of the property. I have given my son. Therefore, narrated facts are not in dispute. The position of the parties before the concerned court also is a matter of record. The application is filed by the petitioner seeking under Order 6 Rule 17, not application is filed by the petitioner, defendant number 2, under Order 6 Rule 17, seeking amendment of, quote, not the written statement, but the plaint schedule property. The application comes to be rejected on the ground that there are no documents produced by the defendant to demonstrate that it is the suit schedule property. While the documents are available or not is not the issue. The issue is whether the defendant can direct the plaintiff to amend his plaint in an application filed under Order 6 Rule 17. Order 6 Rule 17. The Order 6 Rule 17 reads as follows. The provision of law is clearly indicative of the fact that a party who files an application can seek amendment of his side, either written statement or the plaint if it is filed by the plaintiff, the written statement if it is filed by the defendant. The defendant cannot direct the plaintiff to, therefore the defendant cannot direct the plaintiff to amend his plaint as observed herein above. The plaintiff is the master of his plaint and has depicted certain properties in the suit schedule. The respondent at the fag end of the proceedings cannot file an application under Order 6 Rule 17 seeking amendment of the plaintiff's plaint. It was always open for him to seek an amendment of the written statement, which according to the counsel for the respondent would take him nowhere. Counsel for the petitioner would take him nowhere. In that light, finding no merit in the petition stands rejected. The judgment rendered by the High Court of Madras is by learned single judge, and I'm in respectful disagreement with the same. Yes.
The defendant's writ petition. The plaintiff and the defendants are the neighbors.
39(1) and 2.
39(1) and 2. What I'm trying to say, my lord, is he lodges a complaint before the competent authorities. The competent authority issues a notice. He aggrieved by that, he files a writ petition. The writ petition is pending before this court. While the writ petition is pending before the court, he goes to the civil court, files a suit for a declaration that my building should be in accordance with the sanctioned plan, alleging the building bylaw violations. The trial court grants a limited injunction saying that you shall not proceed with the further construction, but you are permitted to paint and plaster and finish the matter. So, if learned aggrieved by that, he files a MA. The MA is allowed and with the blanket injunction order is granted to
you.
Against me.
Against to him. Yes, sir. Continue.
Then your lordship may kindly, the two questions that arise before the court is violation of building plans, building bylaws are not to be entertained by civil courts. It's beyond the jurisdiction.
Is that the allegation before the court?
No. Yes, it was taken.
It may be taken, but what is the prayer?
The prayer is your lordship may kindly see.
He is the plaintiff.
He is the plaintiff.
Declare. What is the prayer?
Your lordship may kindly say page 58. He doesn't allege his rights are infringed. Declare that the construction.
Yes, Sunil, how can the court consider whether it is in sanction plan, according to sanction plan or not?
It was only on a limited aspect. Sanction plan was with respect to ground, first and second.
Whatever it is, how can the civil court decide about all that?
It was not about that much for one.
Then what?
Let's kindly see. There is
one more minute. Which is that writ petition pending?
It is pending on the file of the coordinate bench. That is for demolition.
Page 57. 57 plaint 57. Your
page
57. Their plaint.
Plaint ಅಲ್ಲ ಸರ್, ರಿಟ್ ಪಿಟಿಷನ್ ಯಾವುದು?
ಅಲ್ಲ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದ ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಹೇಳಿದ್ದಾರೆ.
ಯಾಕೆ ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ವಾ?
ಹಾಕ್ತೀವಿ.
26219 of 2024.
That's pending before this court even today.
What is the order passed there?
That is to consider a representation to bring the construction in order. That is to the local planning authorities. I am a neighbor, my lords. I am a neighbor.
His neighbor.
I am his neighbor there. I am his neighbor there. I have alleged, my lords, there is a setback violation. My lords, I have alleged that the plan, the building, my lords, was a sanction plan was granted only with respect to ground plus 2 floors. Now it is already in the 5th floor.
ಓ ಅಷ್ಟೊಂದು ವೈಲೇಷನ್ ಆಗೋಗಿದೆ.
It's already in the 5th floor. And my lords, the panchayat officials were also.
ಅಲ್ಲ ಅಲ್ಲಿ ಪರ್ಮಿಟೆಡ್ ಎಷ್ಟು?
G+2.
G+2.
Yes, my lords. And
Who is constructing?
The the defendant petitioner here.
You have filed
Injunctions. Not that the.
now 1 minute. G+2 is the permitted.
G+2.
Now G+4 ಆಗಿದೆಯಾ?
G+4 ಆಗೋಗಿದೆ already. And he wanted to finish that.
1 minute. Tag the petition along with writ petition 26219 of 2024. List them both on Monday.
Please.
Will be now.
Will be.
Yes.
So I pay for the petitioner, the defendant's petition. This is the defendant's petition, my lords. What I'm challenging is the order of police protection that is granted in furtherance of an interim order that is already granted in favor of the plaintiffs, my lords. Because what has happened here is, your lordship may please see, my lords, the impugned order.
It is rejected, is it?
My lords, it is allowed. I am the defendant, my lords. I'm suffering this order of police protection from the plaintiffs, my lords.
So what?
My lords, what's happened is, it's an open land. There are a lot of raucous and rowdy elements that get out of the property at night, my lords. I have to
Police will protect, don't worry.
my lords, what's happening is, my lords, there's also an illegal order, my lords. Lordship, may please see, my
No,
lords.
don't worry about it. There is an injunction in his favor.
There is an injunction in his favor, my lords. My submission is, I'm not developing the property at all. His submission is, my lords, these are bald allegations that are made.
Forget that, sir. There is an injunction in his favor.
There is an injunction.
He is entitled to police protection.
My lords, he's entitled, my lords, my lords, he has to make out the case for that. He's not made out the case, my lords. All he said is there are JCBs and excavating materials. My submission is, my lords, none of that has actually happened, my lords.
Even without injunction, coordinate bench has said police protection can be granted under 151.
My lords, the thing is, my lords, Lordship may kindly take my submission on record that I will not develop this property, my lords. But let
So,
this order be,
I will not stay it, sir.
let this order be in abeyance, my lords, because
No,
my lords, this is being abused by them. Lordship, may please see the order, my lords, the impugned order at the operative portion of page number 26. My lords, what's happened is, I have produced photographs to show
There is
that
an injunction in his favor, you said.
there is an injunction.
Have you challenged it?
No, it's attained finality, my lords. I'm not challenged.
Huh?
It's attained finality. I'm not challenged. it.
Anything else, sir?
My lords, there's only 26, my lords, page number 26. My lords, paragraph number 12. It is argued by defendant number 38 to 3E, my lords, which is me.
Police protection ಗೆ ಇಷ್ಟೊಂದು ಆರ್ಡರ್ ಬರ್ದಿರೋದು ಜಾಸ್ತಿನೇ ಆಯ್ತು.
My lords, what's happened is, my lords, I have produced photographs to show that they are in violation of the interim order in respect of one property.
ಅದು ಅಲ್ಲಿ.
My lords, the honorable trial court has misconstrued this, my
This
lords.
is regarding PP, police protection.
Please, my lords. My lords, what's happened is the honorable trial court has misconstrued this to mean that I am developing my property.
I will undertake that you don't develop the property.
My lords,
But I
please see
will
this.
not stay or set aside this order.
Please see this. Please see this.
No,
my lords.
sir.
My lords, just 3 lines I'll read. Just 3 lines I'll read, my lords.
You have not challenged the order of injunction.
I have not challenged, my lords.
If
I have
you're
not
really
challenged.
not developing the property, you would have challenged it.
My lords, I'm not developing. My submission is I'm not developing the property at all, my lords. Here, my lords,
Then don't worry at all, sir.
Alla, they've.
Why are you worried? Police protection ಇದ್ರೇನು ಬಿಟ್ರೇನು?
Illa, if I'm going to clean the property, my lords, they're
ಮತ್ತೆ
misusing it.
ಡೆವಲಪ್ಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Illa, there is, my lords, what's happened is in the evenings there are a lot of rowdy elements that come onto the property.
You are
my
cleaning
lords.
the rowdy elements?
No, I have to ensure that they don't come onto the property. That is my only submission, my lords. Just please see, my lords, how the learned trial court has been misconstrued.
ಇಂಜಂಕ್ಷನ್ ಅವ್ರ ಫೇವರ್ ಇದೆ, ಅವ್ರು ನೋಡ್ಕೊಂತಾರೆ ಬಿಡಿ. Why are you
I am
worried?
in possession of the property, my lords. That is,
That's why you should have challenged that injunction.
my lords, for unfortunate reasons, it's not been challenged, my lords. This is the only, my lords, limited prayer I'm asking, my lords. I will make my submission, my lords, that I will not develop the property. My lords, let this order be kept in abeyance, my lords. To
It's better you develop the argument, no property.
Illa.
ಏನಿಲ್ಲ.
Illa, please see, my lords, 26. The photograph that I have produced, my lords, in respect of the property that they are
Photograph
developing.
versus photograph, civil code.
Illa, they have not produced any documents at all, my lords.
ಇಂಜಂಕ್ಷನ್ ಇದೆಯಲ್ಲ ಅವ್ರ ಫೇವರ್, ಫೋಟೋಗ್ರಾಫ್ ಯಾಕೆ ಕೊಡ್ಬೇಕು?
Allah, to show that I am doing something in violation of the violation
So
of
that
the order.
observation I will expunge, don't worry.
Illa, my lords,
But I will not
please
stay
see.
this order nor set aside this order.
Allah, the
If you had
photographs-
challenged the order of injunction, yes.
I have not challenged that.
You
my
could
lords,
have
but my lords,
definitely-
this order is being abused. That is the only.
Abused. Why have you not challenged it, sir?
Even if no, the police protection order is being abused, my lords. Only to that extent, my lords. I will. Let me take my submission on record that I will not make any development on the property, my lords.
Don't worry
it's
then.
barren land, my lords. I will not make any further development. It is
Don't
barren
know.
land. My lords, the photographs are also relied,
Oh,
misconstrued, my lords. There are no, they've not produced anything, my lords.
No,
All that
anything,
they've stated is.
anything else.
All that they've stated is there are JCBs and there I am digging the property. My lords. There are no photographs. In fact, I produced photographs to show that they are digging in their property in violation my lords, even though there's an interim order.
Complaint to the courts.
My lords, and the court has relied on these photographs. My lords. Other than my photographs which are used against me, there is nothing that the plaintiffs have produced. My lords.
You should have challenged the order of injunction. The petitioner,
My lords, I'll serve it on.
what you want to do? You want to withdraw?
No, I'll serve it on the respondents.
No, no, who is saying I'm issuing notice?
My lords, then,
No, sir.
on Friday, my lords, I have it on next week.
No, no, sir, nothing.
Any date next week, my lords. Next week, any date, my lords. I'll produce those photographs.
No, no, sir, nothing doing. The petitioner
My
is,
lords, I'll withdraw this.
after arguing the matter at length, petitioner seeks leave of this court to withdraw the petition, reserving liberty to urge all the contentions at the appropriate stage before the appropriate fora.
Good.
And in this matter, Honorable Court directed us to serve a copy to the advocate who is representing the trial court, my lords.
Madilva?
Nobody is representing, my lords. The matter is on 30th.
39 1 and 2 na?
Yes, my lords.
ಏನಾಗಿದೆ ಈಗ?
And my lords, interim.
ಯಾವತ್ತು ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಯಾವತ್ತು?
30th is.
Huh?
30th of this month.
30 ಲಿಸ್ಟ್ ಆನ್ ಮಂಡೇ ಇನ್ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್.
Interim order may be extended.
ಇದೆಯಾ?
House.
ಮತ್ತೆ ಯಾಕೆ ವರಿ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? List the matter on 6th August. Interim order subsisting will continue till the next date. Notice ಆಗಿಲ್ಲ ಅವರಿಗೆ?
Notice may be issued through court, my lords.
Emergent notice to the respondents, returnable by the 6th. Yes.
This case appearing for petitioner, your lordship.
Appearing for
Handsome source
respondent.
served on the 12 respondents, your lordship.
All 12
Appearing for
respondents.
respondent number 13, your lordship. Today I filed my wakalat, your lordship. Please time to file objections regarding this.
Learned counsel for the petitioner, counsel so and so. Learned counsel so and so enters appearance for R13.
Yes, your lordship.
Registry to print the name of so and so is appearing for R13. ನೀವು ಯಾರಿಗೆ ಮುರುಗೇಶ್?
For BDM.
ಅದೇ respond number?
7, your lordship.
7 na?
7.
Learned counsel Murugesh Charati accepts notice for the 7th respondent. ಆಮೇಲೆ await the PF ಕಟ್ಟಿಲ್ವಾ?
Note issue, hand summons ಆಗಿದೆ.
Lordship, you know, respond for
Hand
10,
summons
11
ಆಗಿದೆ.
and 14. I'm sorry, your lordship. Respond for 10, 11 and 14 also filed a wakalat.
14 to 16.
ಒಂದು ನಿಮಿಷ. 14 to 16?
10 and 11, your lordship.
14 to 16, 10 and 11, so and so enters appearance, 7 Murugesh Charati. Hand summons ತಗೊಂಡಿಲ್ವಾ?
ತಗೊಂಡಿದ್ದೀನಿ sir. Hand summons served on 12
1 minute.
respondents.
They await the
3
appearance of the other respondents. Counsel who have entered appearance seek 2 weeks time to file statement of objections. List on 6th August. Objections if any, by any, by then. The interim order subsisting would continue till then. Yes.
For the petitioner, your lordship. Lord, I appear for the respondent number 1. I've been served a copy in the morning, my lords. However, no annexures are produced along with it, my lord, no page numbering. ಹಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ
ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ಹತ್ರ ಹೋಗಿ ಕೊಡಿ.
Annexures, page numbers, nothing is produced.
ಕೊಡಿ ಪೂರ್ತಿ.
Copy, your lordship. I'll serve them the law. In
Ah,
fact, I
sir.
had instructed the counsel as well.
What's the matter?
This is with regards to the execution petition, your lordship. There was a money recovery suit that was filed against me. Defendant number.
Your JDR.
Yes, please, your lordship.
Yes.
My lords, one more submission. They have come before the executing court in the morning and have gotten the matter posted for mediation. My lords. It may be taken up any date after
Mediation.
2 weeks. It's gone to the mediation center already. The
The
executing
learned
court.
counsel appearing for the decree holder submits that the judgment debtors have sought the matter to be referred to mediation and the concerned court has referred the matter to mediation this morning. Therefore, list this matter on 6th August. Result of mediation be placed before this court on the next date, if any.
Please, your lordship.
Mandamus. Learned counsel so and so accepts notice for, ನಿಮ್ಮ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರಾ?
Copy.
Accepts notice for the respondent board. ಏನ್ ನಿಮ್ಮ ಹೆಸರು?
ಬಸವರಾಜ್ ಹಳ್ಳ.
So and so. A registry to print the name of so and so is appearing for the respondent 1 HCGP. A list on ಇದರ compensation.
No, my lord, there is a partition suit pending in the year 2022.
Private parties ಎಲ್ಲಿದ್ದಾರೆ ಇಲ್ಲಿ? ನೀವ್ ಯಾರು?
Parties, sir.
My lords,
Page 156.
GPA holder of whom?
146 में
Alla, GPA holder of whom?
GPA holder, GPA holder of one Bairegowda, my lords.
One by Regoda.
One, his name is Bairegowda. Page 157, my lords. Adರಲ್ಲಿ
ಅಲ್ಲಲ್ಲ only one ಬೈರೇಗೌಡ or ಫ್ಯಾಮಿಲಿ ಇದಾರ ಅಂತ
his family members, my lord, subject outcome of suit.
ಅವರೆಲ್ಲ ಎಲ್ಲಿ ಪಾರ್ಟಿಯಲ್ಲಿ ಅವರು?
They have not been made party because they are strangers. Is my stand before the.
GPA ಯಾಕೆ ಇಸ್ಕೊಂಡಿದ್ದೀರಾ ಅವ್ರ ಹತ್ರ ಎಲ್ಲ?
These are the two persons who are owners.
ಅವ್ರು ಸ್ಟ್ರೇಂಜರ್ ಆದ್ರೆ why did you take GPA from them?
No, not page. I have taken GPA from one Bairegowda and another person who have been made defendant in the suit filed by the strangers. Now, my lords, my submission is that Oppige Patra has been submitted before the SLAO. Subject outcome of suit and kotru paragilla.
Because compensation.
Alala. Iga the day when they enter GPA.
Compensation will be dependent on the outcome of the suit. Ad ಮಾಡ್ಬಿಡ್ತೀವಿ.
ಅದೇ.
ಮತ್ತೆ ಅಷ್ಟಕ್ಕೆ ಯಾಕೆ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ರಿ?
ಯಾಕಂದ್ರೆ my lords 2023 May was my order for.
ಈಗ ಯಾಕೆ ಹಾಕಿದ್ದೀರಾ ಹೇಳ? Suit outcome ಆದ ತಕ್ಷಣ GPA holder will take away the compensation and go. ಅಷ್ಟೇ. ಅವ್ರು ಇನ್ನೊಂದು ಸೂಟು ಇನ್ನೊಂದು ಪೆಟಿಷನ್ ಹಾಕೊಂಡು ನಮಗ್ ಬಂದಿಲ್ಲ ದುಡ್ಡು ಅಂತ.
ಅಲ್ಲಿ ನನ್ ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ ಅಷ್ಟೇ. ಬಿಕಾಸ್ ಟೈಮ್ ಬೌಂಡ್ ಆಗಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ರೆ ದಟ್ ವುಡ್ ಬಿ ಹೆಲ್ಪ್ ಸ್ವಲ್ಪ ಮಲ್ಟಿಪಲ್ ಲಿಟಿಗೇಷನ್ಸ್.
ಐ ಥಿಂಕ್ ಸದ್ಯಕ್ಕೆ ನೋಟಿಸ್ ಮಾಡ್ತಾರೆ.
ಪ್ಲೀಸ್.
HCGP so and so emergent notice so and so accepts notice for respond.
Please.
Yes.
Any date if my lord so fix?
Many date. 1st August.
Great.
Apply. For the cavator in this case, the decree holder.
Lord JDR's petition.
What is IS 7?
I am on a very weak wicket. I am on a very weak wicket, but before a good coach.
Weak wicket allu follow on ಆಗ್ಬಿಡುತ್ತೆ ಸರ್, ಹೇಳಿ ಪರವಾಗಿಲ್ಲ.
All that I am saying is, in IA number 7, I have filed a proposal that given some time, I will complete the decree.
Complete the?
I will give all the amounts, decree amounts.
ಎಷ್ಟು?
Total 4 crores is the decree amount. In that 1 crore 25 lakhs is already paid.
ಬಂದಿದ್ಯಾ?
2 crores 75 lakhs is pending. Now out of that, since I am a contractor, the LOC which is now remaining with the government is 7 crores. Out of which 3 crores is already attached.
Government ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗಿದ್ದೀರಾ?
Yes.
ಬರೋದೇ ಇಲ್ಲ.
ಅಲ್ಲ ಈಗ
ಸರ್ಕಾರದ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆದ್ರೆ ಬರೋದೇ ಇಲ್ಲ.
As my instructions are, in another 2-3 days, that around 2 to 3 crore rupees LOC will be released. Yes. Probably. So therefore, what I am saying is, I am also, there are certain other liabilities, my daily wages are there.
Sari,
so
yes.
Therefore, 30% of whatever I get, I will give you.
ಸ್ವಲ್ಪ wait ಮಾಡಿ, he has made all the arrangements with the government for release ಅಂತ.
May I submit?
30% of what I get.
30% ಕೊಟ್ಟಿದ್ದೀರಾ?
No, 30% of what I get, I will give it to him.
ಹಂಗ ನಾನು 30% ನೀವು ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಾ ಅಂತ.
May I submit?
3 crores is pending, Lord. If I get 3 crores, I will give.
May I submit?
ಹೇಳಿ ಸರ್.
There is no bona fide in the submissions made by the petitioner for the reason. The decree that was a compromise decree was entered into between the parties, agreeing that within 1 year from the date of the decree.
ಆಯ್ತು, ಈಗ 1.25 ಕೋಟಿ ಕೊಟ್ಟಿದಾರಲ್ಲ, he is depending on the government.
Please, may I submit? He has not complied with the order which has been passed by this honorable court. Hence, the interim order which was granted. Please note, which was granted in the earlier writ petition, which is still pending, was vacated with liberty to the decree holder to move the executing court. Each and every time when the money is coming, my lord, the petitioner herein is coming one or the other way to stall that the decree is stalled.
How do you know money is coming?
Please note, the concerned executive officer has submitted a report before the executing court officially that this amount is ready to be dispersed in favor of the judgment debtor, out of which is I am waiting since from 4 years seeking for the.
That executive officer has filed an affidavit before the
report has come.
A report, and report.
Now today, my lord, the honorable executing court has directed that money be deposited before the executing court. In that event, that will not be a problem to them, my lord. Now, my lord, in the earlier writ petition, they sought for an interim.
Executing court ಗೆ ಮಾಡ್ಲಿ ಬಿಡಿ. ಮಾಡ್ಲಿ ಬಿಡಿ.
That is the order. Today it has been passed, my lord. Now, my lord, apart from
correct ಆಗಿದೆ order.
Apart from this, my lord,
executing court has attached, and now today they have ordered that
ಏನ್ ಅಟ್ಯಾಚ್ ಮಾಡಿದ್ದಾರೆ?
The
3
amount
crores.
payable to the judgment debtor.
Oh, correct.
Since
That
from 3
attachment
years.
was ordered. Now that amount will be paid to the court.
Court.
Yes.
ಒಳ್ಳೇದು.
Now what I am saying is, what is coming in for me is around 2.5 or 3 crore.
Where is it coming?
Lord, day after tomorrow
You
probably.
are saying it's coming. No coming.
As and when it comes, Lord. Let
As
me
and
rephrase.
4 ವರ್ಷದಿಂದ it's coming.
Let me rephrase it.
Since from the
Lord,
date of the
3
compromise,
crores.
13 crores he has
Whatever
received.
I get in 3 crores.
ನೀವು ಗವರ್ಮೆಂಟ್ ನಂಬದ್ರೆ it will never come.
Lord, I
It will
also
only be
have to-
coming.
The
Lord, I
government
also
has
have to
reported
pay.
that 5 crore 41 lakhs is likely to be dispersed. Since from the date of the decree, my lord, he has on the record have
ಈಗ
placed
ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
that
Weak
the
wicket. Yes, yes.
Lord, I have challenged. the
13
rejection
crores
of
he has
my-
received. In spite of that one,
my
he has not paid
application.
except by the orders of the court.
ಎಷ್ಟು ರಿಸೀವ್ ಮಾಡಿರೋದು ಹೆಂಗ್ ಗೊತ್ತು ನಿಮ್ಗೆ?
I have obtained under the Right to Information Act. I have placed it on record before the trial court.
13 ಕೋಟಿ ಬಂದಿದ್ಯಾ?
Bandide, sir. Apart from that one, he has not paid that, he has not taken any initiative and shown the bona fides to pay that amount.
ನೀವೇನ್ ಕಾಂಟ್ರಾಕ್ಟರ್?
Contractors.
Contractor, my lord.
If,
I have.
ಏನ್ ಸಬ್ ಕಾಂಟ್ರಾಕ್ಟ್ the respondent is it?
no, my lord, I am the
He has
supplier of the
supplied,
good.
he has supplied a raw material to me. And there was a.
And my property
there
has
was a
been put
due.
into auction, my lord.
And
I have to
thereafterwards-
repay the
thereafterwards,
amount. my lord.
Whatever I
ಯಾವಾಗ-
come,
ಒಂದ್ ನಿಮಿಷ, ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಸರ್?
my lord, that's what the proposal, what
I
I
am
am
not
saying
going to
is,
interfere in
Lord,
this. Whatever court has now ordered is correct.
every time I get, Lord, money, 30% I'll give him right away.
ನೀವು
Let this
ಅಲ್ಲ,
petition be pending. before the
supplier
court.
ಗೆ-
Has been issued.
ಅಲ್ಲ, let this petition be
ಸಪ್ಲೈಯರ್
pending.
ಗೆ ದುಡ್ಡು ಕೊಡದೆ ಅವ್ರಿಗೆ ಆಟ ಆಡ್ಸಿದ್ರೆ ಅವ್ರು ಮಾರ್ಟ್ಗೇಜ್ ಮಾಡಿರೋ ಪ್ರಾಪರ್ಟಿ ಹೋಗುತ್ತೆ.
Lord,
The sale notice has been issued. my lord.
let the petition be pending before the court.
May,
Your lordships may record this. According to me, my lord, in 3 months' time, the entire decretal amount will be paid.
I'm not going to stay anything. We'll keep the petition pending, no problem.
With that undertaking, Lord, so
No
that
taking
3 crore
under it.
rupees, whatever comes in, even I have to pay. the
Whatever
other-
comes in will go out there, don't worry.
Lord, the other liabilities I have to bear.
ಎಲ್ಲರಿಗೂ ಹಿಂಗೆ
Daily
ಮಾಡಿದ್ದಾರೆ.
daily wages are there. Whoever have done work, this 3 crore rupees will go towards them. But irrespective of that, 1 crore 25 lakhs is already paid in last 1.5 months.
it is as
Two
of today,
LOCs,
3
three
crore
LOCs.
77 lakhs is the outstanding due along with
3
interest. my
LOCs.
lord.
ಸರ್,
Lord,
ಏನ್ ಮೆಹರ್ಬಾನಿ ಮಾಡಿದ್ರ? 1.25 ಕೋಟಿ ಕೊಟ್ಟು.
ಇಲ್ಲ ನಾನು
ಮತ್ತೆ?
ಮೆಹರ್ಬಾನಿ ಅಂತ ಹೇಳ್ತಿಲ್ಲ. ಅದಕ್ಕೆ ನಂಗೆ ಅವಕಾಶ ಕೊಟ್ರೆ ಅದನ್ನು ಮುಗಿಸ್ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ವಿ ಅಷ್ಟೇ.
ನೀವು ಅವಕಾಶ ಕೊಟ್ಟಷ್ಟು ಸಾವಕಾಶ ಆಗತ್ತೆ ಕೊಡೋದು.
No, my lord, your lordship may put me on terms here only. I am saying, my lord, 7
Today, the
crores-
order has
7
been passed by
crores
the.
work
ಈಗ ಆರ್ಡರ್ ಆಗಿದೆ ಅಂತಲ್ಲ ಬಿಡಿ.
Today order has been passed by the trial
order
court,
ಆಗಿರೋದು
directing
to
the
pay.
PWD engineer to deduct the
pay.
statutory dues and to deposit the entire amount before the
Correct
executing
ಆಗಿದೆ
court.
order.
Then
Today,
I would have myself passed this order.
Please,
Lord, I would not get anything. That's what I am saying.
ನಿಮ್ಗೇನ್ ಬೇಕು? ಕೊಡೋದು ಕೊಡಿ ಫಸ್ಟ್.
But there are other, then there will be multiplicity. of
sufficient means, my
situations.
lord, 13
There are
crores he has
other-
received.
Now let him come.
He will not stop until he gets his money, so don't worry. Yes.
Lord, that's my endeavor also.
Endeavor
Last-
failed.
From last 3 months. Lord,
Endeavor
we have
failed,
paid.
sir.
Lord, let the petition be.
Sir,
pending.
ಅವ್ರ ಕಷ್ಟನ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ
ನೀವು
ಹೇಳ್ತಾ
ಸಪ್ಲೈ ಮಾಡಿದ್ಮೇಲೆ ದುಡ್ಡು ಕೊಡದೆ ಅವ್ರು he will be put to great problems.
Lord,
ನೋಡಿ
every
ಅವ್ರು ಲೆಟರ್ ಮೇಲೆ ಲೆಟರ್ ತೆಗಿತಾ ಇದ್ದಾರೆ.
Lord,
Sale
every
notice.
time-
ಸೇಲ್ ನೋಟಿಸ್.
Lord, every time I
ಅವ್ರಿಗೂ
get
ಕೊಟ್ಬಿಡಿ
money,
ಸೇಲ್ ನೋಟಿಸ್.
ಕೊಡ್ತೀನಿ sir.
Lord, every time I get money, 30% I'll
I
give
have
him.
given them the,
ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಲೋನ್ ತಗೊಂಡಿದ್ದೀರಾ?
I have collateral property has been put to auction now.
You direct those asset reconstruction companies people to go to him. ಎಲ್ಲ ಅವ್ರು ಕೊಡ್ತಾರೆ.
Now, my lord, he is off the record, my lord. I may,
ಇಲ್ಲಿ ಏನ್ ಆಫ್ ಇಲ್ಲ ಸರ್, ರೆಕಾರ್ಡ್ ಎಲ್ಲ ರೆಕಾರ್ಡೆಡ್.
I don't have any concrete material to say this, but all my creditors are being rushed to the executing court saying that you are getting the money, repay us. He is, for my information, my lord, the judgment debtor is informing all my creditors.
Lord, therefore, every time I get my money, 35% I'll. pay.
Since from, my lord,
In
1.5
in
years.
next 3
Three
months.
times
his
the matter
entire-
was
his-
attached.
ಅವ್ರು ಏನಾದ್ರು ಹೇಳಕ್ ಬಿಟ್ರೆ ತಾನೇ ಹೇಳೋದು.
in
ಆಯ್ತು
next-
ಸರಿ.
in next
ನಾನು
3
ಏನೋ
months-
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಐ ವಿಲ್ ಟೇಕ್. ಏನಾಗುತ್ತೆ, ಐ ಆಮ್ ನಾಟ್ ಗೋಯಿಂಗ್ ಟು ಸ್ಟೇ ಎನಿಥಿಂಗ್. ಇವತ್ತೇನೋ ಬೇರೆ ಆರ್ಡರ್ ಆಗಿದೆಯಂತೆ, ಅದನ್ನು ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ.
Please.
ಅಲ್ಲ ಚಾಲೆಂಜ್ ಮಾಡೋದೇ ಬೇಡ.
ಬೇಡವಾ?
ಬೇಡ ಬೇಡ.
ಬಿಡಿ.
ಇಲ್ಲಿ ಏನಿದೆ ಐಎ ಇದೆ ಅದ್ರ ಪ್ರಕಾರವಾಗಿ ತಾವ if that accommodation can be made.
ನೋ 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 ಡಿಫಿಕಲ್ಟ್.
30% every time I will pay him. Lord. If 3 crores
You
comes
sit
in,
with
6
him,
lakhs.
you sit with him and get back. We'll list it on Wednesday next. List on Wednesday. ಅವ್ರ ಹತ್ರ ಕೂತ್ಕೊಳ್ಳಿ. ಮಾತಾಡಿದ್ರೆ ಮಾತಾಡಿ.
ಎಲ್ಲ ದುಡ್ಡು ಬಂದ ಮೇಲೆ ಕುತ್ಕೊಳ್ಳೋದು.
ಅಲ್ಲ, there is complete no bona fide in this.
Correct. No bona fides. Yes.
Or else I would have cooperated. Now application, my lord, they have filed. It travels beyond the decree to be payable next year up to August, my lord. They wanted to stall the execution proceedings.
I'm going to pay. I don't know why, my learned.
ಸರ್ ಇದೇನು ಸರ್ಫೇಸ್ ಇಕ್ವಲ್ 10% ಅಂತ ಹೇಳಕ್ಕೆ ಇಲ್ವಲ್ಲ ಡಿಗ್ರಿ. ಎಸ್ ಸರ್.
Please.
For the petitioner in this case, my lord. Lord, this is plaintiff before the commercial court has preferred this petition against the impugned order dated 18/6/2025, whereby the commercial court has rejected my
The
application.
petitioner is before this court calling in question an order dated 18th June 2025 passed in commercial OS 416 of 2024, by which the concerned court rejects the application filed by the petitioner seeking production of documents in order after the defense set up in the written statement. The said course of action is permissible in law as is held by this court in writ petition 10679 of 2025 disposed on 10/6/2025. In that light, further proceedings before the concerned court shall remain stayed. Petitioner to serve on the counsel represents the respondent in the trial proceedings and file an acknowledgement of such service. List the matter on 6th August. Yes. Yes, Latif. Sajesh.
Please, ma'am.
ಗೊತ್ತು ಅದೇ ದಟ್ ಮಾಸ್ಕ್ ಅಲ್ವಾ ಇದು ಮತ್ತೆ
Abatement.
This is that 185 which 187 which I dealt with ಅದೇ ಅಲ್ವಾ?
Yes.
93.1, my lord, notice is still awaited.
26th
Notice is awaited for this complaint.
ಯಾವ್ದ್ರಲ್ಲಿ
93.1 and 93.3.
ಸರ್ವ್ ಆಗಿದೆಯಲ್ಲ ಎಲ್ಲ 93.2 ಅಲ್ಲಿ ಏನಾಗಿದೆ?
93.1 ಅಲ್ಲಿ ಆಗ್ಬೇಕು.
ಆಯ್ತು ಸರಿ. Post immediately after service of notice to the complainant in 93.2 and 93.3. Put up immediately after service of notice. Interim order subsisting in all these cases shall continue till the next date of hearing.
First month.
ಇದಕ್ಕೆ ಇವತ್ತು ಬಂದಿದೆ ಡೇಟ್ ಇತ್ತು ಮನೆ. Let all these matters come on Thursday.
Please.
List the matter on Thursday. Urgency ಉಂಟಾ?
82 old matter, madam.
82 ಏನಾಗಿದೆ ಈಗ?
Good for partition.
One
What is under challenge? 711 in FDP.
ಅಲ್ಲ ಎಲ್ಲಾರ application allowed. Yeah, challenge the LR applications.
Why, sir?
My lord, she is nowhere concerned with an agenda. My lord, I'll explain the facts in brief, my lord. My lord, suit for partition is filed in the year 1986.
Let's see. Let it come on Monday. Monday in preliminary hearing. Admission, sorry.
Great.
Same 95, 96, 97, Monday.
My lord, serial number 96, my lord.
Monday, sir. Yes.
96. My lord, kindly direct to the petitioner, serve the copy, my lord. Copy kuda serve ಮಾಡ್ತಾ ಇಲ್ಲ.
Copy serve ಮಾಡಿ.
Decree ಆಗಿದೆ.
96.
Suit for eviction, my lord. 1.5 ವರ್ಷದಿಂದ ಬಾಡಿಗೆ ಪೇ ಮಾಡ್ತಾ ಇಲ್ಲ.
List on 30th.
Kindly
list on 31st.
Earlier list, my lord.
List on 31st, yes.
97.
ನಾವು ಇಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ 31st. 95 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
96 ಅಲ್ಲಿ
ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
My lord, serial number 96, my lord.
96
After the decree, suit for eviction, my lord. 1.5 ವರ್ಷದಿಂದ ರೆಂಟ್ ಪೇ ಮಾಡ್ತಾ ಇಲ್ಲ.
95.
It's submission.
1 minute. 95 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? 95 Monday. 96, 97 list on 31st. Interim order subsisting will continue.
97 on affidavit ಹಾಕ್ಬೇಕಿತ್ತು. ನನ್ನ ಮೆಮೋ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಎವಿಕ್ಷನ್.
ಓ ಇದು ಅಂಡರ್ಟೇಕ್ ಎಲ್ಲಿ ಮೇಡಮ್?
I filed my affidavit, my lord.
ಹಾಕಿದಿರಾ ಆಲ್ರೆಡಿ?
ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದಾರೆ. ಅರಿಯರ್ಸ್ ಆಫ್ ರೆಂಟ್ ಕೊಡ್ಬೇಕು. ನಾನು ಮೆಮೋ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಬಾಕಿ ಇದೆ.
No arrears of rent, my lord.
ಆಯ್ತು ಇದು 97 ಮಂಡೇ ಹಾಕಿ. 96 ಮಾತ್ರ 30th 31st. Yes, 230 matters.
Serial number 96, arrears of rent 1.5 ಲಕ್ಷ ಇದೆ.
Serial number 100, my lord, proposals have been exchanged with Somshekhar. Your lordships has directed the trial court not to precipitate the matter. The
Madam.
same may kindly be extended.
One minute. 98.
Lord, I appeal for the respondent.
Interim
Yes.
for
Lord, in
petitioner.
this case,
Yes, sir. 98 ಏನು?
I am for the petitioner, Your Honor.
ಆಮೇಲೆ
ಇದರಲ್ಲಿ section 10 respondent has filed the eviction suit, Your Honor. After that, I have filed the very same sale deed challenged before the senior division, Your Honor, by declaring the sale deed null and void. In that case, interim order has been passed in favor of the plaintiffs, Your Honor. Thereafter, the suit has been stopped because of the plaintiff has several times.
Section 10
Please stay the.
ಅಲೋ ಆಗಿದೆಯಾ?
Dismiss ಆಗಿದೆ, ಅದ್ರ ಮೇಲೆ ಬಂದಿರೋದು.
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆಯಾ?
Let me make one submission. 2018, a suit is filed for declaration and injunction in the principal civil judge Mandya. Before that, my lord, the suit is filed for eviction before the civil judge JMFC Mandya. All that, my lord, now in this case, a section 10 application is filed. I'm not seeking
That is rejected.
That is rejected. Let this matter be heard along with that matter, my lord. Let it be transferred.
ಎರಡು
My lord,
ಒಟ್ಟಿಗೆ
I have
ಆಗ್ಲಿ.
no objections for that.
ಎರಡು ಒಟ್ಟಿಗೆ ಆಗ್ಲಿ.
My lord, that declaration suit as in evidence have completed, both side evidence have been completed.
So what?
Nothing will not.
Neither that nor this ಆಗದ್ ಬೇಡ. ಎರಡು ಒಂದೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಒಟ್ಟಿಗೆ ಆಗ್ತಾ ಇರ್ಲಿ.
Please, my lord.
ಅಷ್ಟೇನಾ? ಸರಿ, yes.
Because. that is-
21 ಇಂದ ಅದಕ್ಕೆ ಪೆಂಡಿಂಗ್.
That is the reason, my lord.
The petitioner is before this court calling in question an order of the concerned court dated 3/6/2020 which rejects an application in IA2 seeking arrest of the suit in OS 61 of 2016. The learned counsel, the petitioner.
It's for, not for arrest, my lord.
Section 10 ಇನ್ನೇನಕ್ಕೆ ಬಂತ?
I'm sorry. I'm sorry.
Section 10 ಇನ್ನೇನಕ್ಕೆ sir?
That's right.
Yes.
I'm sorry.
The respondent plaintiff institutes OS 61 of 2016 for eviction on the basis of a sale deed dated 25/10/2013. The defendants therein filed written statement. Another suit in OS 55 of 2018 seeking declaration that the sale deed dated 25/10/2013 is null and void is instituted by the present petitioner, the defendant, in OS 61 of 2016. Therefore, the defendant petitioner files an application under section 10 seeking arrest of the suit in OS 55 of 2018 till the suit in OS 61 of 2016.
55 of 18.
In 55 ಅದ್ರಲ್ಲಿ ಹೇಳಿದ್ದು 55 of 18 ಅದ್ರಲ್ಲಿ ಹಾಕಿದ್ರಾ?
ಇಲ್ಲ, ಇದ್ರಲ್ಲಿ ಹಾಕೋ 61 ಅಲ್ಲಿ.
ಅದನ್ನೇ ಹೇಳ್ತಿರೋದು. 66 OS 61 of 2016 seeking arrest of the suit in OS 55 of 2018 till the conclusion of the suit in OS 61 of 2016.
The suit 55 because ಅದರಲ್ಲಿ
ಯಾವ್ದು ಸ್ಟೇಕ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಸೂಟ್?
ಇದನ್ನೇ ಕೇಳಿದ್ದು 61 ಅನ್ನೇ.
ಅದನ್ನೇ ಹೇಳಿದ್ದೀಗ 61 ಹೇಳಿದ್ನ 58 ಹೇಳಿದ್ನ?
55 ಹೇಳಿದ್ದಾರೆ.
ನೋಡ್ತೀನಿ ಬಿಡಿ. ಎಸ್, ಸೊ the learned counsel for the respondent H. Shanti Bhushan appearing for the respondent plaintiff submits that both the suits if arising out of the same cause of action can be tried together before the same court. The learned counsel for the petitioner is agreeable to the said solution as always. Solution rendered by solution submitted by H. Shanti Bhushan. In that light, I deem it appropriate to direct OS 61 of 2016 and OS 55 of 2018 to be tried by the same court, not clubbing but together. In the light of the aforesaid order, the order rejecting the application seeking clubbing need not be interfered with. It is, however, made clear that both the suits in OS 61 of 16 and 55 of 18 shall be tried together. Since the suits are of 10 years and 9 years and 7 years respectively, I deem it appropriate to infuse finality into those proceedings by directing the concerned court to conclude the proceedings within an outer limit of 6 months, if not earlier.
In OS number 55, already evidence concluded, but FSL report is coming.
In accordance with law, yes. Conclude in accordance with law. Yes.
Great.
In outer limit of 6 months, if not earlier.
My lord, this suit has to go senior division, my lord. OS 55 is in senior division, OS 61 is junior division.
It will go to the senior division only, yes. heard together before the court hearing OS 55 of 2018.
Great.
ಒಂದು ನಿಮಿಷ ತಾಳಿ ಕರಿತಾ ಇದ್ದೀನಿ ಒಂದು ನಿಮಿಷ.
For the respondent in this case.
Vacating interim order.
Yes, my lord.
List the matter on 30th under the caption vacating interim order.
Great,
Yes.
my lord.
Interim order subsisting will continue till the next date of hearing. 100.
100 ಅಲ್ಲಿ we have given the proposal to Somshekhar. 100 ಅಲ್ಲಿ
Settlement.
100 ಅಲ್ಲಿ I have given a proposal to Somshekhar, my lord.
Proposal to Somshekhar.
Regarding settlement.
Somshekhar, yeah.
ಸೆಟ್ಲ್ಮೆಂಟ್ ಆಗಲ್ಲ ಅಂತ ಇಬ್ರು ಅಣ್ಣ ತಮ್ಮದಿರು ಇಬ್ರು ಹೋಗ್ತಾ ಇಲ್ಲ.
ಪ್ರಪೋಸಲ್ ಹೋಗ್ತಾ ಇಲ್ವಾ?
ಪ್ರಪೋಸಲ್ ಅವರು ನನ್ಗೆ ಆಸ್ತಿನೇ ಬೇಕು ಅಂತಾರೆ, ಇವರು ದುಡ್ಡು
ಫುಲ್ ಆಸ್ತಿ ಬೇಕು ಅಂತ ಇದ್ದಾರೆ.
ಅಲ್ಲ ಫುಲ್ ಆಸ್ತಿ ಇಲ್ಲ, ಅಗ್ರಿಮೆಂಟ್ ತಂದು ಡಿಗ್ರಿ ಆಗಿತ್ತು.
ಆಯ್ತು.
ಏನು ಅಂತ ಅವ್ರ ಕಡೆಯಿಂದ ಏನು ಹೇಳಲೇ ಇಲ್ಲ ನಮ್ಗೆ.
ಯಾಕೆ ಹೊರಗಡೆ ಏನು ಹೇಳಿಲ್ಲ? ನೀವು ಎವಿಡೆನ್ಸ್ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ರು ಇವಾಗ.
The learned counsel for the petitioner submits that talks of settlement between the parties are on. Therefore, list this matter on 6th August. Interim order subsisting will continue.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಅನ್ಕೋಸ್ಕರ.
ಡೇಟ್ ಅಂತ ಹೇಳಿದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳಿದಾರ?
ಅಲ್ಲ ಇಲ್ಲಿ
ಅಲ್ಲ ಅಲ್ಲಿ
any order subsisting today shall continue till the next date of hearing. Next. 101.
My lord, I have come to petition my lordship. My lordship, during the tenure of the stay granted by the Supreme Court, election is conducted by the
Supreme Court.
There was a stay not to participate in church matter, my lordship. During the stay participating in the
Church
Supreme.
matter.
Yes, my lord.
Respondent yaru? Dr. M. Sunil Shastri.
Yes, my lord.
Church is not represented?
Church is represented, my lordship.
ನೀವೇನಾ?
No, I am for the no, my lord.
ಅದೇ ಹೇಳಿದ್ದು ಅವ್ರು ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ ಅಂತ.
No, my lordship.
My lord, I represent the respondent in this, my lord. Senior has undergone a surgery in this case, my lord. I require 2 weeks time to file my objections, my lord.
My lord.
My VC is not working, my lord.
Interim order ಇದೆಯಲ್ಲ?
No, there is no interim order.
There is a detailed interim order.
My lord, what is happening with regard to interim order? He is still holding the post, my lordship. With that observation, till the disposal of this person, he will not hold the administration post. That sentence.
My lord, my humble submission is 2 weeks time may be given. I will file objection. He has undergone surgery, my lord.
Where are you, madam?
My lord, my video is not working, my lord. I'm sorry, my lord.
Yes. List the matter on Monday in preliminary hearing.
My lord,
Yes.
next week, my lord.
No. Yes.
Then stay may be extended, my lordship.
Interim order subsisting will continue till the next date of hearing.
Much obliged, my lord.
Lord, I'm
For the petitioner, my lord.
102. ಏನಿದೆ ಸೋಮಣ್ಣ?
Suit is for bare injunction, my lord.
Ah.
I'm challenging the miscellaneous appeal, my lord. My lord,
ಏನಾಗಿದೆ?
I've been dispossessed of the property, my lord, merely by a private survey conducted by a subdivisional officer.
Interim order ಇಲ್ವಾ?
Interim order.
No, my lord, it's not a private survey. It is survey.
Survey by whom?
A government official.
Subdivisional officer. It is not a Hadbas survey, my lord. He applied for a private survey. It was conducted by a subdivisional officer.
Where is the report of survey?
Kindly see my objection, page number 11, my lord.
Lord, page number 74, my lord.
70.
One ನಿಮಿಷ.
My lord,
I will.
so far as.
My lord, I am in
land is
possession of the
concerned-
property.
We'll hear it on Wednesday. List the matter on Wednesday in preliminary. Heard the learned counsel Somanna KP and for the petitioner and the respondent Srimati Anita S.M. Patil. List the matter on Wednesday in preliminary hearing. Yes. Next.
It's appeal, my lord, for the respondent. Kindly have it.
In the execution petition, my lord, he files an application order 21/97. The order, my lord, the inquiry was ordered, page number 56.
Who is he?
Lord, he is the claimant to the tenant through one Geeta. Geeta is already files an application to seek 1 Rule 10 in the original
Interim order
proceedings
ಇದೆಯಲ್ಲ?
has been dismissed.
Kindly. List the matter on 6th August. Interim order subsisting will continue to the next date of hearing. Next.
Lord, memo is connected matter, my lord, notice may be
Pudi.
dismissed, R1.
Learned counsel 103(1) ಅಲ್ಲಿ files a memo seeking dispensation of issuance of notice to the first respondent, dispensed at the risk of the petitioner. Next. Yes, continue. ಅದು ಕರೆಕ್ಟ್ ಮಾಡಿಸ್ಬಿಡಿ ಮೇಡಮ್. Yes. Enter ಮಾಡಿದ್ಯಾ? List after 2 weeks IO. Next.
For the respondent in this case.
Enter ಮಾಡಿದ್ಯಾ?
Implements.
List on 30th. Yes, next.
I am for petitioner, my lord.
Enter ಮಾಡಿದ್ಯಾ?
My lord, on
Enter ಮಾಡಿದ್ಯಾ?
35 lakhs I have paid, my
I had
lord.
to make a payment of 9 lakhs more, my lord.
Not 9 lakhs, my lord. 6,70,566 balance amount I have to pay.
ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
I fell ill, my lord. Now I am not well. This month I have paid 15 lakhs rupees on second, this month, my lord.
ಆಯ್ತು, ಇನ್ನೊಂದು 15 days time ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಮಾಡಿ.
Okay, yeah, I will clear, my lord.
Yes, list the matter on 30th. The amount of 6,75,000 be cleared by, ಆಮೇಲೆ ಕೊಡಿಸ್ತೀನಿ ಸುಮ್ಮನೆ ಇರಿ. 6,75,000 be cleared by then. Yes, next.
Interim action, my lord.
Subject to the aforesaid interim order.
9 lakhs is due.
ಅಯ್ಯೋ, ಇನ್ನು 2.5 ಲಕ್ಷ ವೆಯ್ಟ್ ಸರ್. ಬಂದಿದ್ದ ದುಡ್ಡು ತಗೊಳ್ಳಿ ಫಸ್ಟ್.
Interim may be action.
The interim will be, yes.
Great, my lord.
The Madam Sons. Yes, next.
I seek for a 2 weeks accommodation.
2 weeks time, yes. At the request, next. Enter ಮಾಡಿದ್ಯಾ? List after 2 weeks IO. Enter ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ. Commercial suit was filed without exhausting the remedy of.
12.
My lord, Dhanbad judgment is.
No, ಮುಂಚೆ ಆಗಿತ್ತು ಅದು.
Paragraph 62 of the judgment, my lord. It says, my lord, that if there is an urgent interim relief.
Yeah, Dhanbad. Yes.
My lord, could be had.
List on Monday, preliminary hearing.
Great.
Yes, next. 2 weeks. Same.
I appear for respondent, my lord.
112.
My lord, in this case, Annexure D, page number 44, 45, in respect of that scheduled property is not served on me.
Serve ಮಾಡಿ sir. Yes. The learned counsel appearing for the petition will serve complete copies upon the counsel representing the respondent. Entry ಮಾಡಿದ್ಯಾ?
Interim.
List after 2 weeks, yes.
I served them, my lord.
ಇನ್ನೊಂದು.
Yes.
Yes.
The petitioner, my lordship. We have an interim order, my lordship.
You have.
Same may be extended.
Take it. Continue. Next.
Also, my lordship.
It can be disposed of, my lords. It's a mandamus.
Continue ಆದ್ರೆ continue ಮಾಡ್ತೀನಿ.
They may consider a representation
Next
and
4
dispose,
days.
my lordship.
ಯಾವುದು?
ಅದು 113 115.
113, 115 consider representation.
Yes, my lord.
ಆಯ್ತು,
My lord,
disposed. Yes.
No precipitative action during the.
ಕೊಡಿ, same order.
114.
114 ತಗೊಂಡಿಲ್ಲ ಮೇಡಮ್, wait. Yes.
ಇದರಲ್ಲಿ my lord, one second.
ಬರೀ ಅದೇ covered actually. Yes. Same.
38D.
38 ಇದೆ, same order. Copy.
1 year time ಕೊಟ್ಟಿದ್ದಾರೆ to consider. That's the only request, my lord.
1 year.
1 year.
1 year. Yes.
No alienations in the meantime, my lordship. They may allot it.
ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಲ್ಲಿ.
ಅದು ಇದೆ.
ಅದು ಇದೆ. Yes.
Everything is there.
Yes. Next. Interim order ಇದೆ madam?
I'm for respondent in this case, my lord.
Interim order is there? List after 2 weeks. Interim order subsisting will continue to the next date of hearing. Next.
Meantime, I'll file my objection, my lord.
Meantime, you can do anything, madam. Next, yes.
Please, my lord.
116.
This is covered by judgment, my lord. What?
Kodi. The learned counsel appearing for the petitioner submits that the issue in the list and is answered by the judgment rendered by the coordinate bench, division bench. Coordinate bench. Therefore, list the matter on Tuesday in preliminary hearing. Yes. Final hearing ಅಂತ rule issue ಆಗೋದಿಯಾ? Anyway, list the matter in preliminary hearing.
There are subsequent judgment after
ಆಯ್ತು,
1994.
ಹೇಳ್ತಾರೆ. Will covered ಅಂದ್ರೆ close, ಇಲ್ಲ ಅಂದ್ರೆ we will continue.
It's simple. Sanction preliminary notice in the 28 days ಕೊಟ್ಟಿದ್ದಾರೆ. 30 days mandate ಇದೆಯಲ್ಲ.
25 years ಆದ್ಮೇಲೆ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ದಾರೆ.
25 days ನೊಳಗೆ sanction
ಏನಿದು ಮುಡದ?
25 years ಆದ್ಮೇಲೆ ರಿಟ್ ಹಾಕಿದ್ದಾರೆ ಅವರು.
ಮುಡದ?
ಹೌದು.
ಮೂಡಿದೆ ಈಗ. ಆಯ್ತು.
Your Lordship, we filed an application to vacate the interim order. This is an order passed under Order 39 where both of us have been heard. So they will have to file an MFA. Your Lordship is.
Oh, it's, alla, both are rejected, is it? Miscellaneous appeal hakilwa?
Application.
Sorry, first appellate court hakilwa 43 ಅಲ್ಲಿ.
Illa, hakilla.
No, without exhausting that remedy, how will I entertain, sir?
Absolute unreason.
Maybe, sir. That, maybe, that also can be agitated there.
Section 8 application we had filed. Section 8 application is not, my lord, heard, and then, my lord, an order is passed under Order 39, Rule 1 and 2.
Don't, day after tomorrow in preliminary hearing. Yes, legal time ಇದೆ madam.
Please.
Smart meter ಇಲ್ವಾ ಇವತ್ತು?
Friday.
Oh, Friday. Sorry, all right.
But as I had mentioned, they can bring an army. One man army they brought. That is all they need.
One man army, I agree, no problem. Yes.
Obliged.
That, we'll take it Friday, sir. Yes.
Your Lordship, the name of the council needs to be reflected.
ಏನಾಗ್ಬೇಕು? Rahul S. Reddy be deleted and
VENU, Venu.
Venu, just Venu?
D,
What Venu?
D.
D Venu be printed in as appearing for first respondent.
Obliged.
Who is D
Preliminary
Venu?
hearing. Please, Your Lordship.
Who is D Venu?
D Venu.
D
He's
Venu.
D Venu, yes.
All right, yes.
Obliged.
It's the interim order request fixed.
That will continue. ಇನ್ನೂ ನೀವು ಕೇಳ್ತಿರಲ್ಲ ಅನ್ನರ್ಥನೆ.
The matter was
ಆಯ್ತು, yes.
This is that matter that drunken
Time ಆಗೋದು. There's a meeting at 5 o'clock. It will continue on Friday. ಎಲ್ಲ 2:30 ಮೂಡ್ ಮ್ಯಾಟರ್ ಇದೆ ಮೇಡಮ್. ಅದನ್ನ ತಗೊಂಡ್ಬಿಡ್ತೀನಿ ಒಂದು ನಿಮಿಷ.
180.
ಎಲ್ಲ Friday.
May I make one request?
Now no request. I have only 6 minutes.
1 second. Can it be, this is the clerks association matter.
It will be on Friday, sir.
Can it be immediately after orders? My lord?
It will be on Friday. You make a mention. Yes.
Or can it be at 2:30?
It will be on Friday. Yes.
ಇದರಲ್ಲಿ ಇದರಲ್ಲಿ
138. ಅದು Friday. ಈ ಟೈಮ್ ಆಗಲ್ಲ. ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಬೇಕಾ? ಹ್ಞೂ ಬೇಡವಾ? ಈ Friday. Yes, call the
serial number 124, my lord.
ಎಲ್ಲ. Yes.
Kindly have it on Wednesday, or Monday or Wednesday.
It will come on Friday, make a mention. Yes. Monday and sir, even that on Friday. Yes. Oh, that also I'll take on meeting at 5 o'clock. Tomorrow that Twitter matter is there. It will go on the whole day. Friday. Yes.
My lord, this inconvenience is Friday, my lord, we will take it up on Monday.
I'll do one thing. I'll take it tomorrow. In case that matter is over, you come. Afternoon, after 2:30. Up to 2:30, 100% that will go on. ನಾಳೆ ಇರ್ಲಿ, ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇದ್ರೆ ಹೇಳಿ. ಬೇರೆ ಏನು ಡೇಟ್ ಕೇಳಬೇಡಿ, ಎಲ್ಲ ಫ್ರೈಡೆ. ಎಸ್, ಫ್ರೈಡೆ ಟಾಪ್ ಇಲ್ಲ ಏನಿಲ್ಲ. ಎಸ್, ಅಡ್ವೊಕೇಟ್ ಮ್ಯಾಟ್ರಾ ಯಾವುದು? ಒಂದು ನಿಮಿಷ. ಕರೆಕ್ಟ್. ದಿಸ್ ಯಾಕೆ ಇಲ್ಲಿ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಬಂದಿದೆ ಅದು? ಓ GM ಮೇಡಮ್, ಅದು 2:30ಗೆ ಅಂತ ತೋರಿಸಿ ಫ್ರೈಡೆ. ಯು ರಿಮೈಂಡ್ ಮೈ 2:30 ಆನ್ ಫ್ರೈಡೆ. ದಟ್ ವಿಲ್ ಕಂಟಿನ್ಯೂ. It will come on 30th, madam. Only 30th. Yes. Now call the 2:30 mood matters. Ragna Joyce. Then kodi madam. Boja Gaudra idara? Where is the government advocate? You are the government advocate here? What's the prayer? An interim prayer illa. ಇದಕ್ಕೆ ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರು ಮತ್ತೆ? Learned HCGP is directed to accept notice for respondents 1, 2 and 3. Emergent notice to the 4th respondent returnable by the 6th of August. list on 6th August. Wait, Abraham. Yes. ಅವ್ರು ಹೋದ್ರ ಪರಮೇಶ್ವರ್ ಕಡೆ ವೆಂಟ ಒಂದೇ ನಿಮಿಷ ಇರಿ. ಎಸ್ ಕೊಡಿ ಇದೆಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಿದೆ ನೋಡೋಣ. GMCPC give it. Commercial OS. List the matter on 20th petitioner to serve on the counsel who represents the respondent before the concerned court and file an acknowledgement of such service by the 18th. List the matter on 25th. Further proceedings before the concerned court shall remain stayed till the next date of hearing, 25th in preliminary hearing. Next, office objections be complied with in the meantime. Yes, Deepak Shetty. Guest lecturers, interim order ಯಾವ್ದು ಕೊಡಿಯೋದು? Page 4, madam. Page 486 the tag, same order. Next, Satish.
Matter pertaining to appointment of court commissioner, advocate cannot be appointed as
Settled
for
principle.
division of
ಏನಾಗಿದೆ?
property.
The petitioner is before this court calling in question an order dated 21/2/2023 by which the advocate is appointed as commissioner to divide the property by metes and bounds. The issue in the list stands answered by plethora of judgments. In that light, there shall be an interim order of stay of further proceedings before the concerned court till the next date of hearing. The petition, ಇಷ್ಟೊಂದು ಜನ ಇದ್ದಾರೆ, ಯಾರು contesting?
Only, my lord, your lordship may issue notice to R1 and R2.
The petitioner shall serve on the counsel representing petitioners R1 and R2, sorry, respondents 1 and 2. Memo
is filed, my lord.
memo dispensed with. So list on 30th.
Please.
In preliminary hearing. Next. Aditya.
Matter pertaining to suspension matters.
What suspension?
That's annexure A, page 19 is the communication, which is stayed by this one, by the coordinate bench at page 22 matters.
What is that?
It's a communication, the ITI employees.
All right.
Based on that matters. And annexure C is the impugned order, page 23. Fourth reference matters. The communication which is stayed is relied upon by saying for
The
states.
learned counsel for the petitioner. The petitioner calls in question an order of suspension. The order of suspension is said to have been based upon a communication. The said communication is stayed in writ petition 14765 of 2025. In the light of the communication being stayed, the foundation could not have been used for placing the petitioner under suspension, albeit prima facie. Therefore, there shall be an interim order of stay as prayed for, reserving liberty to the respondents to seek its vacation by filing appropriate application. Emergent, Westcom, Srimati Rakshita DJ is directed to accept notice for respondents 1 and 2. Petitioner to serve set of papers upon the aforesaid counsel. Yes, next. Yes, Dodward.
My lord, suit for bare injunction. My lord, plaintiff is before my lords. My lord, the suit was decreed. My lord, the respondent has taken into the appeal. Suit was remanded the matter, my lord, with a framing of additional issues. My lord, the plaintiff challenged that order in MSA. My lord, the MSA was allowed partly. My lord, the MSA court, my lord, the afford the framing of the additional issue, but my lord fixed the time frame of 3 months, my lord. And thereafter, my lord, MFA court, my lord, said only you lead the evidence regarding additional issue. Now, my lord, after the appearance before the trial court, after remand, the respondent defendant has filed application for amendment of the return statement. That was allowed.
That is challenged?
That is the under challenge before my lords. My lord.
Heard the learned counsel
No, my lord,
appearing for the petitioner. 1 minute.
Please, I'm sorry.
Petitioner to serve on the counsel representing the defendant in the trial proceedings and file an acknowledgement by the 21st. List the matter on 6th August. In the event the petitioner would not file the acknowledgement, the interim order now granted would stand automatically vacated. Subject to the aforesaid, there shall be an interim order of stay of further proceedings before the concerned court. Next.
matter pertaining to transfer methods. That's BBMP comes up with the guidelines methods, Annexure D, page 28. Thereafter methods, office order is issued. Annexure G, page 44 methods. Thus the relevant extract is at page 45. ಕೆಳಗಡೆ 10 ವರ್ಷ ಮೇಲ್ಪಟ್ಟು. The second one methods, ಕಂದಾಯ ಪರಿವೀಕ್ಷಕರು, only 5% have been, have worked for more than 10 years methods. I was not in the zone of consideration methods. A person by name M. Ravi Kumar, Annexure H, gives a complaint methods, saying that I have also worked. I am at serial number 5, page 48. Only I am transferred in this particular list methods. No one is transferred to my place methods.
You not relieved yet?
I am not yet relieved.
The petitioner is before this court calling in question an order of transfer. The learned counsel appearing for the petitioner Aditya would take this court through an order passed by, take this court through the list drawn for persons who are to be transferred. According to the said list, persons the officers who have completed 10 years only are to be transferred. The petitioner has not completed 10 years, but the list is operated only in the case of the petitioner and not others. In that light, not others, the learned counsel would further submit that the petitioner is not relieved and nobody is posted to the place of the petitioner. In that light, there shall be an interim order of stay as spread for. Yaar appear aagtare? Learned counsel Pawan Kumar is directed to accept notice for the respondent BBMP.
All 3 methods.
Obrena?
More jana.
Respondents BBMP. Petitioner to serve set of papers upon the aforesaid counsel. Next.
Grateful.
Plaintiff petition challenging refusal to grant expert interim order, my lord. Lord, the fact that the plaintiff has a permission from the Madnur Gram Panchayat to advertise on the between Budigere Cross and the Bomanhalli, my lord. Now the respondent. Please, my lord, the road between Budigere Cross and Bomanhalli.
Hoardinga.
Please, my lord. On the
ಯಾಕೆ LB ಹಾಕೋದ್ ಬದಲು CPC ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ ಅದೇನಾಗಿದೆ ಅಂತಂದ್ರೆ
ಅಡ್ವರ್ಟೈಸ್ಮೆಂಟ್ ಗೆ ಇಂಜಂಕ್ಷನ್ ಕೊಡಕ್ ಸಾಧ್ಯ? ಅಡ್ವರ್ಟೈಸ್ಮೆಂಟ್ ಇಂಜಂಕ್ಷನ್ ಹೆಂಗ್ ಕೊಡಕ್ ಸಾಧ್ಯ?
I am displaying the advertisements. The respondent being a third party, they are coming and removing those advertisements.
Coming and removing.
Please.
Complaint ಕೊಡಿ.
ಇಲ್ಲ suit ಹಾಕಿದೀವಿ injunction ಗೆ identical matter, similar injunction has been passed against the respondent here.
Writ petition na?
Writ petition.
ಕೊಡಿ. Tag this petition along with so and so. There shall be an interim order of stay. ಅದರಲ್ಲಿ ಏನಿದೆ ಅದು ಕಾಪಿ ಮಾಡ್ಬಿಡಿ. Yes. Next. In terms of memo. 118.
My lord,
Dr. Sudha.
one submission.
ನಿಮ್ದು ಯಾವುದು? ಎಲ್ಲಿದೆ? ಬಂದಿದ್ಯಾ ಮೇಡಮ್? ವಿವೇಕ್ ರೆಡ್ಡಿ ಸರ್ದು.
ಯಾರು? ಶಿವಕುಮಾರ್ ಎಸ್.
ಲಿಸ್ಟ್ ಆಗಿದೆಯಾ ನೋಡಿ?
ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ.
I know you moved the memo. He was also there. Two na. 21191.
Yes.
ನಾಗಮಣಿ ಸ್ಟೇ ಕೊಟ್ಟಾಯ್ತಲ್ಲ?
ಹೌದು.
ನೀವಿಲ್ಲ ಏನಿಲ್ಲ. ನಿಮ್ಗೆ ಗೊತ್ತೇ ಇಲ್ಲ ಲಿಸ್ಟ್ ಆಗಿರೋದು. Granted an interim order also.
It was filed on the basis of an authority letter, not suit.
Maybe I have granted stay.
Yeah, please.
I have posted it on what madam?
Bharat Infra Tech.
Correct, adene.
Yes.
I have listed it on 25. Till then I have granted stay.
Please. Please.
You don't know which case is yours? What is all this? Yes. Move madak matra gottagutte, ಆಮೇಲೆ ಗೊತ್ತಾಗಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ? Yes.
One submission, my lord. My apologies, my lord. Serial number 6, I have not sought for stay of entire proceedings, my lord.
Order matra.
Please, my lord. What happens, my lord?
Therefore, there shall be an interim order of stay of the impugned order. Yes, that is. Abraham. Parmeshwar sir. Here ಮಾಡಿದ್ದೀನಲ್ಲ.
Let's.
ಇನ್ನೇನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಕು?
Nothing. We have completed the argument on the other day.
I'll reserve it and pass orders.
I just draw the attention of this court to few points, not more than 5 minutes. I was not keeping well.
You are not keeping well. Take rest.
Yes.
Yes.
Lordship, as far as the limitation is concerned, I think this court is well aware. limitation in 5
ಇದು
lines, 5 lines.
ಸರ್
This is backed by several orders
Hmm.
of Supreme Court which states that it has to be.
Abraham,
within-
I have a meeting at 5:15. So you have only 3 minutes.
Then give me another. date.
I'll reserve it. I've heard you enough. ಧಾರವಾಡದಲ್ಲೂ ಕೇಳಿದ್ದೀನಿ.
So ಇದು ಕೇಳಿಲ್ಲ ಇವರು.
ಇದನ್ನು ಕೇಳಿದ್ದೀನಿ.
ಇಲ್ಲ.
Question of delay,
ಇದನ್ನಲ್ಲ ಇವ್ರು.
jurisdiction is
ಅದನ್ನ
under
ಕೇಳಿದ್ದು.
question.
ಈಗ
Don't worry, we'll answer everything. Your objections are quite elaborate.
the serious issue which I want this court to make an observation is, why should men be persecuted by women with false complaints? When does it end? See, God's grace, I have the strength to.
As long as human beings exist, it will not.
We'll have to. But, taking law, using law as a weapon.
It is.
It is also.
You have heard from here to eternity. It is from there to eternity. It won't end. Yes.
I don't know. Anyway, I just passed this on here.
Kudi.
Just a short note
Hmm.
on all those 5-6 points.
Hmm.
The pain of anybody, I am willing to, by God's grace, I'm able to withstand it. It's okay.
You have
But
withstood
Lord,
so many. What is this?
I've seen so many people who suffer because of these allegations. And how can the police proceed on a false complaint, you know? They don't have any fear about it.
I have already said in the other petition.
In the other one, yes, it's.
Don't worry about it. Yes.
But idalla, ee matter alla, ಬೇರೆ matter later on.
ಅದಲ್ಲ, ಅದು
Because the allegation
was about something. I have answered that in that. It's all right. Now-
at every corner, every court that I go to, this case is used as an example to target me on the witness box.
Don't worry. Yes.
Anyway,
Heard reserved.
if 2 sentences on that can
ಏನು?
be.
8 ವಾಲ್ಯೂಮ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದೆ. ಅದ್ರಲ್ಲಿ ಏನಿಲ್ಲ, ಇಂಡೆಕ್ಸ್ ಮಾತ್ರ ಎಲ್ಲ ಇದೆ. We'll see. Yes. Anyway,
And the
legal
documents
issues I will answer.
Your Lordship, the documents that I produced with the complaint are not Xerox copies. The originals, checks, the agreement papers, everything.
We'll answer every legal issue. You can be rest assured. Yes.
Thank you.
Heard reserved. Yes, why are all of you waiting? ಯಾವುದು?
Is that batch of matters where my lord 7 matters are there?
Oh, that ಏನೋ ಪೊಲೀಸ್ ಆಫೀಸರ್ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಅದ. Oh, you are here. Friday ತಗೊಂತೀನಿ. There's a meeting at 5:15. So
Any other date, my lords may fix, my lord, like a bulky.
ಯಾಕೆ ಫ್ರೈಡೆ ಆಗಲ್ವಾ?
No, my lords, it may get diluted amongst the other matters is my only concern.
What to do?
Any date.
Let me see.
Please, my lords.
1st August ಹಾಕ್ಲಾ?
Very well.
ಅವಾಗಾದ್ರೆ ಏನಿರಲ್ಲ.
Oblige.
All right.
Please.
ಅಭಿನಯ್ ಮೇಡಮ್, ನಿಮ್ದು ಯಾವ್ದು? ಓ, ಫಕೀರಪ್ಪ ಇವತ್ತು ಇದೆಯಾ?
I would not.
Friday ಇರಲ್ಲ?
Friday, if time is fixed, I would not take your lordship more than 15 minutes.
ಆಯ್ತು. Same time, 5 o'clock.
End of the day.
Friday ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. You start at 5 o'clock, we'll take it.
Please, your lordship.
ಅವ್ರಿಗೂ ಹೇಳ್ಬಿಡಿ.
Yes, sir.
ಯಾರಿಗೆ
I'll
ರೆಸ್ಪಾಂಡೆಂಟ್.
convey. Much obliged.
Sir.